Necessary death. You're exactly right. And I still say that outside of this chamber, there are more people opposed to open carry and even more opposed to constitutional carry. And so, to me, this is my opinion, to pass this bill would not be doing the will of the people. I still say that
accidental gun, and for some reason I want to stay on accidental guns. But if you look at the numbers the past 2 years, Senator, and look at the numbers from March through July of January through January through June of last year, those numbers went up because of the pandemic, related to the pandemic, 77%. So, Senator, is that telling us something about guns? And because we were kind of like locked in at home, guns was readily, I think readily available, but they were there.
I read some of that same information. I think that point could be made, but since you want to stay on accidental death, I would tell you that gun death alone is horrible. But when gun death is the result of an accident, it's much more horrible. And I think that that's what we're going to see. We're going to see more accidental death because, as you said, people will become more lax with how they handle their guns, how they secure their guns, and it's going to be bad. And I think we're going to regret it.
Thank you, Mr. President. Thank you, Senator.
Senator from Richland, Senator Putin, what purpose do you rise?
Mr. President, I'd ask unanimous consent to introduce the doctor of the day.
Without objection, Senator Putin is recognized. Senator from Richland.
Thank you, Mr. President. I'd like to introduce Tricia Weatherspoon, young lady right up here. Is it politically correct to say young lady now? Yes. Okay. Who is the attending physician for residence in family medicine, USC School of Medicine. With her today is Dr. Lynette Ayarbo. Is that right? Who's a first-year resident. I want all of you to welcome Dr. Witherspoon here today. Thank you very much.
Welcome to the Senate, Doctor. Thank you for what you do for us.
Yeah, now they're going to have doctors that are going to go and say, oh no, the children, the children, the children. Even
Senator from Pickens, Senator Rice, what purpose do you rise?
That has no bearing on people who
sponsored amendment number 1A, please.
Concealed carry permit.
Objection?
They just want to
open
carry. But this is what we have to deal with in South Carolina. So, guys,
Mr. President, I ask to be recognized to explain Amendment 1A.
Recognized, sir.
This is what we've been dealing with the last
Please give Senator Massey your attention.
8 or 9 years.
Thank you, Mr. President. Amendment 1A does two things, really. One, it makes a couple of what really are technical changes to the House language, and I'll explain what those are. The House, in its bill, redefines what a concealable weapon is. And it redefines it to include a concealable weapon is one that can be concealed or carried openly. Well, then there are other parts in the bill when they say concealable weapon or openly carried. So it kind of, it's inconsistent. And so what I've done here is that there are places where it says concealable weapon, and we just make that clear what we're talking about. There's also a provision in the House bill that deals with the signs that you see, these signs up on some businesses, some locations where it says, now they say no concealable weapons allowed. The House added in language that would say no concealable or open carried weapons allowed. And I think that it's too much for a sign. And because concealable already includes openly carried, what I've done is taken that back to just be the sign that you see now. It doesn't say no concealed weapons, it says no concealable weapons. It's a difference. So if the signs say no concealable weapons, that tells people that you can't have any concealable weapon, whether you conceal it or you carry it openly. The final thing in the change that I make to the House's language, and this is actually similar to what I explained before, but in the section that deals with churches that are leasing school space for meeting, that they also had the concealable or openly carried language in there, and so I've tried to change that back to make it consistent. But the idea, of course, is that a concealable weapon is one that can be concealed or carried openly. Now, the second part of my amendment is different. The second part of my amendment, this is the last section in the amendment, it is an anti-commandeering provision. It is essentially sanctuary state status for South Carolina related to the ownership or carrying of weapons. And what it does is it uses Supreme Court precedent, U.S. Supreme Court precedent, that says that the United States government cannot compel state governments or local governments to enforce federal law. And so that's the language that I have here. We looked at the U.S. Supreme Court precedent on that. There have been a few cases that have dealt with that specifically. One of the more specific ones, actually, Prince, which got a lot of attention, was one from 1997 where they really set out the language here. It dealt with the Brady handgun bill. And that law, when Congress passed it, required county sheriffs to perform background checks. And the U.S. Supreme Court, in this opinion, said, you can't do that. Congress can't compel counties to enforce federal law. And what we're doing here in this amendment is to use that type of language, and it just says that the state nor its political subdivisions can be compelled by the federal government to take any legislative or executive action to implement or enforce federal law related to an individual's right to keep and bear arms protected by the Second Amendment. And then it says that if they do pass something like that, then the Attorney General could issue an opinion on it, and then we could, the locals would not have to enforce the law based on that.
Senator from Colleton, Senator Matthews, what purpose do you rise?
The senator would yield for a couple of questions.
Sure, I will.
Senator, what cases were you relying upon regarding the constitutionality of enforcement issues? I think you said a 1997 case that referenced the Brady gun laws.
It was Prince versus the United States. There's also one from 1992 where they actually established the doctrine for the first time, was New York versus the U.S.
New York?
New York versus U.S. from 1992. 1997 was the Prince case, and I mentioned that one because it specifically dealt with the federal government requiring the states or the local governments to enforce certain provisions of the federal law related to handguns, and the U.S. Supreme Court said you can't do that. There was a later case more recently. I can't remember the name of that one, but those are the two. The one that I mentioned was Prince.
Okay. Is that New York case the one that South Carolina got involved in regarding the sale of gun laws? That New York, I remember years. You remember? There was one regarding that?
I didn't read that one when I came up here. I looked at Prince to make sure that we were being consistent with the Supreme Court guidance on that.
Now, in your amendment, I haven't had a chance to fully go over the particulars of the amendment, and I wanted to, if I could, ask Mr. President a parliamentary question.
State your inquiry.
Are we on that portion where we're debating the actual bill? I know we had the committee report from the senator Senator Young. Are we in the actual debate?
We're on amendment number 1, Senator Massey's amendment.
Okay. Senator Massey, were you present for any of the subcommittee hearings in reference to this particular bill?
Yes, ma'am.
You were?
Yes, ma'am.
And in those, is it correct that there was no specific testimony from SLED or the director of SLED or anyone that he chose to come to answer questions regarding concealed weapons enforcement and the like?
I don't believe that anyone from SLED testified. I mean,
You were there,
as
though.
a senator from Aiken said yesterday, former Chief Stewart testified, but I There was nobody currently from SLED who testified.
And the issue that you're adding is a clarification. You were a part of the subcommittee,
I was.
and did you try to present? Are you trying to tell me something, Mr. President?
I like the message.
I bet you would. Did you present this clarification regarding concealment versus concealable, and if so, to the committee?
I did not.
And any particular reason why?
Because I knew that we were going to discharge it from the full committee, and that even if the subcommittee acted on an amendment, it would not come out with the bill.
So you wanted to basically get this bill out and then make the changes once you got to the floor.
That's right.
Mr. President, I would move pursuant to Rule 21 to recommit this bill back to the committee.
Mr. President, I've got the floor, so I object.
The rule says that it can be done at any time prior to 10 minutes within the debate, and the senator from Edgefield is within 10 minutes, and it didn't say whether or not he had the floor or not. So I would ask your clarification.
Which rule number, Senator?
21, to recommit.
Let us check.
You giving the
you
desk
want to
a
speak to
test
that?
here.
Excuse me?
Said you're giving the desk a test. You're throwing a rule out at them that's not used every day.
I knew that it would at least make the senator from Spartanburg get that spring in his chair.
You got him
And
over
he'd
there
jump
looking
up.
too.
Senator from Colleton, you must have the floor to be able to make that motion.
And I would ask, pursuant to this rule, where does it see that in there? Because it says it has to be made within 10 minutes. And if he keeps the floor beyond 10 minutes, then how do I satisfy the rule?
We're well beyond
And
10
for
minutes.
Spartanburg, Senator Martin, what purpose do you rise?
I'd like to speak to the point.
You recognize, sir.
Thank you, Mr. President. And just clearly reading Rule 21, anytime before its passage, it may be recommitted by a motion to recommit, which can only be made when the matter is under debate or by unanimous consent when the Senate is in the motion period. And such question shall be decided after not more than 10 minutes of debate. And at any time, the President or his designee may move to recommit a bill that has been on the calendar for a minimum of 9 legislative days. So, Mr. President, this bill has not been on the calendar more than 9 days, and the matter is under the debate, and the senator making the motion does not have the floor.
If I may respond to the point of order that was made, since he's referring to me, Mr. President. I think he specifically referred to me, and I would like to respond to his statements regarding the time period and whether or not the motion is appropriate. May I? That's the first time.
Senator from Edgefield has the floor, ma'am.
Is there a ruling from you, Mr. President?
Point. You making your point?
No, I'm asking you whether or not there's a ruling.
What was your original? Was it a question
No.
or was it a point?
The senator from Spartanburg said that.
That's not what I'm asking you. Your original, was it a question or a point of order?
It was a point of order.
I'll overrule your point.
Then it's a question.
Senator from Edgefield has the floor.
Thank you, Your Honor.
Thank you, Mr. President. So that's what the amendment does. It does those two things. Makes a few technical corrections throughout and then adds in the anti-commandeering language to ensure that the state nor its political subdivisions can be compelled to enforce federal law related to handguns. Move adoption of the amendment.
Question is, adoption of the amendment. All in, Senator from Colleton, what purpose do you rise?
Move to recommit under Rule 21.
Motion is to recommit the bill to the committee. Roll call is requested. Senator from York, what purpose do you rise?
Move to table.
Senator from York moves to table the motion to recommit. Roll call is requested. 5 members second the call. 5 members do. Clerk will ring the bell. Tabling motion. On the motion to recommit. Meeting clerk will call the roll.
Mr. Adams. Mr. Adams not voting. Mr. Alexander. Aye. Mr. Allen. No. Mr. Bennett. Aye. Mr. Campson. Mr. Campson not voting. Mr. Cash. Aye. Mr. Clymer. Aye. Mr. Corbin. Aye. Mr. Cromer. Aye. Mr. Davis. Mr. Davis votes aye. Mr. Fanning. No. Mr. Gambrell. Aye. Mr. Garrett. Aye. Mr. Goldfinch. Aye. Mr. Grooms. Aye. Mrs. Gustafson. Aye. Mr. Harpootlian. Mr. Harpootlian votes no. Mr. Hembry. Not voting Mr. Hutto. Not voting Mr. Jackson. No. Mr. Kevin Johnson. Not voting Mr. Michael Johnson. Aye. Mr. Kimbrell. Aye. Mr. Kempson. Mr. Kempson not voting. Mr. Leatherman. Aye. Mr. Loftus. Aye. Mr. Malloy. Malloy votes no. Mr. Martin. Aye. Mr. Massey. Aye. Mrs. Matthews. No. Mr. McElveen. Not voting Ms. McLeod. No. Mr. Peeler.
Aye.
Aye. Mr. Rankin. Not voting Mr. Rice. Aye. Mr. Sabb. No. Mr. Scott. No. Mrs. Sin. Aye. Mr. Setchler. No. Mrs. Shealy. Aye. Mr. Stevens. Mr. Stevens votes no. Mr. Talley. Aye. Mr. Turner. Aye. Mr. Verdon. Aye. Mr. Williams. No. Mr. Young. Mr. Young votes aye.
Senator Hembry votes aye. Senator Adams votes aye. Senator Kevin Johnson votes no. Senator Kempson votes aye. No, well, you were pointing at your eye, sir. Senator Kempson votes, and that would be you. Senator Kempson votes no. All senators voting. Last call of all senators voting. Polls will close. Clerk will tabulate. By vote of 28 to 14, the motion is tabled. Question is the adoption of the amendment. Senator from Colleton, what purpose do you rise?
Move to table the amendment.
Question is tabling the amendment. Roll call is requested. 5 members do. Second it. Meeting clerk will call the roll.
Mr. Adams? No. Mr. Alexander? No. Mr. Allen? Mr. Allen votes aye. Mr. Bennett? Not voting Mr. Campson? Not voting Mr. Cash? No. Mr. Clymer? No. Mr. Corbin? No. Mr. Cromer? No. Mr. Davis? No. Mr. Fanning? Aye. Mr. Gambrell? No. Mr. Garrett? No. Mr. Goldfinch? No. Mr. Grooms? No. Mrs. Gustafson? Mrs. Gustafson votes no. Mr. Harpootlian? Mr. Harpootlian votes aye. Mr. Hembry? No. Mr. Hutto? Not voting Mr. Jackson. Mr. Jackson not voting Mr. Kevin Johnson. Aye. Mr. Michael Johnson. No. Mr. Kimbrell. No. Mr. Kempson. Mr. Kempson votes aye. Mr. Leatherman? No. Mr. Loftus? No. Mr. Malloy? Not voting. Mr. Martin? No. Mr. Massey? No. Mrs. Matthews? Aye. Mr. McElveen? Not voting. Mr. McLeod? Aye. Mr. Peeler?
No.
No. Mr. Rankin? Not voting. Mr. Rice? No. Mr. Sabb? Aye. Mr. Scott? Mr. Scott not voting. Mrs. Sin? No. Mr. Setzler? Not voting. Mrs. Shealy? No. Mr. Stevens? Aye. Mr. Talley? No. Mr. Turner? No. Mr. Verdon? No. Mr. Williams? Aye. Mr. Young? Mr. Young votes no.
All senators voted. Senator Scott votes aye. Senator Jackson votes aye. Senator Sessler votes aye. Senator Bennett votes no. Senator Malloy votes aye. All senators voted. Polls are closed. Clerk will tabulate. By a vote of 14 to 28, the motion on the table fails. Question is, adoption of the amendment.
Mr. President,
Senator from Colleton.
I move pursuant to Rule 24 as to that portion of the amendment which is not listed, which relates to the enforcement by the state of South Carolina or non-enforcement of federal government legislation or executive action. On the amendment, it is Article 4, Chapter 31. The section is not listed in the amendment.
You raising a point of order, ma'am?
Yes, Rule 24.
Anyone else want to speak to the point? Senator from Edgefield.
Mr. President, the legislation clearly deals with handguns. It deals with concealable weapons. It deals with those that are concealed and those that are non-concealed. The bill deals specifically with openly carried weapons, but it deals with handguns. The portion of the amendment that the senator from Colleton is referencing specifically deals with handguns. It is limited specifically to handguns. And it is a natural and logical extension of the subject matter of the bill. I specifically limited it to handguns so that it would be germane, and I would argue that because of that specific limitation, and that it's not just broad applying to everything, because it applies only to handguns, that it would then be satisfactory under Rule 24.
Mr. President,
Senator from Colleton.
in response, unfortunately, even though he crafted it well, it still isn't germane as it gives the state of South Carolina, it relates to the state's power, whereas the bill itself only relates to concealed weapons permits as it relates to the citizens. This is one as it relates to whether or not we can follow our own Constitution, so therefore it is not germane, no matter how crafty it is drafted. It's trying to circumvent our Constitution as it relates to concealed weapons.
I'll overrule your point.
Surprise. Thank you.
Question is, adoption of the amendment. All in favor say aye. Opposed, no. The ayes have it. The amendment's adopted. Clerk will publish the next amendment.
There's amendment number 2B by Senators Massey, Malloy, and Campson.
Senator from Darlington, Senator Malloy, what purpose do you rise?
You heard on the amendment.
You recognize, sir. Please give the senator from Darlington your attention. Senator Malloy.
Thank you, Mr. President, members of the Senate. I rise today to explain the amendment on 2A by the senator from Edgefield, myself, and the senator from Charleston. I start by saying happy Cinco de Mayo. It's an interesting day when we had a little force at some point in time in our history that took on a big force, which seems the same thing that's going on now. And basically what we have is that we have this festive day that's going on around our country that later the larger force overtook the smaller force. And so it reflects as to what happens in this particular legislation. And I think it's important that we pause for a second and let me take you through a little bit of a time trail as it relates to the legislation. You recall June of 2015, we had the tragic event that we had down at Mother Emanuel, and we lost our brother, Clemente Pinckney. We came back over here, this Senate and this General Assembly started talking about the fact is, what are we going to do with guns? What are we going to do with guns? And so I was thinking about it last night, and I went back and I pulled out my notebook. Here's a notebook that we had, the Gun Issues Committee, that goes all the way back to 2016. And in 2016, I chaired the committee along with the senator from Charleston, Senator Campson, the senator from Lancaster, Senator Gregory, and the senator from Orr Reed, Senator Hembry, and the junior senator from Charleston, Senator Kempson. And so during the time, we had hearings all over the state. Senator from Oconee, Senator from Florence, Senator from Orr Reed. We traveled to the four corners of our state. And we said we need to handle and work on the issues as it relates to gun issues. A couple of things that we heard that obviously were things that we could do. One was dispositions. And so I will go back and talk about this particular legislation. And with the senator from Aiken, I was on the subcommittee. I heard the testimony. I listened intently, and I talked to the local law enforcement, and I had personal conversations with Chief Keel and other folks in his department. Chief Keel was discussed earlier. Did he come and testify before the committee? But his position has been well documented throughout, and it's all over the place of law enforcement's opposition to the bill. And Chief Keel says, I don't necessarily come to the committee, Senator from Aiken, but we knew his position. It was well documented as to what his position was. Also had a brief conversation with Major Frank O'Neill. I'll come back in 1 second. And so what I wanted to end up doing during that time was to make certain that we put together a bill that would reflect something that they had asked for during the process. And I'm gonna be brief in my discussion, and then we can end up raising our points and that kind of thing, so we can see. Okay, quick question.
Senator from Colleton, what purpose do you rise?
To see if the senator would yield for a quick question.
Sure. He will.
Senator, you said that Chief Keel's position on this has been well documented. Where is it documented, and what specifically, given his opinion as to other gateway issues, what is his specific opinion documented as it relates to whether or not he wants people with CWP to open carry?
So in my discussions with Chief Keel, I was not privy to the testimony, but Chief Keel testified in the House. He testified his opposition to this particular legislation. It's well documented in news documents and those kinds of things. And so sometimes it takes us to end up moving beyond and just having that conversation. So, you know, I had a specific conversation with Chief Keel. I had a specific conversation with Major O'Neill, and who I've been a longtime friend with. And obviously, we all know the history, but here we are here in the Senate. And so I think a responsibility that we have is to make a bill as good as we can make it. And so I think that it's an opportunity for us that we see what is going on in the legislation. We have overall legislation that is pending, and the overall legislation, it is pending. And so even whether you agree or disagree with the premise of it, I think that there's opportunity to end up making it. And so we've taken this as an opportunity for, and I referenced the bill that we had for some time. 5 years ago, we came out with an observation that we needed to end up having something change on the dispositions. And so what I'll do is I'll briefly describe what this amendment does. This amendment is very simple. And so if you go back and you think about it, and many of you were here many years ago. Many years ago, the concealed weapon permit process, they have started. I think former Judge Jeff Young, who's now in the Attorney General's office, former Senator Jakey Knotts, who is retired now, they worked on this concealed weapon permit and made it a very strong concealed weapon permit in our country, and obviously it has stood the test of time. It has changed somewhat over a period of time. Many of you remember Bill 308, and we talked about that. Senator from Spartanburg remembers that day when I had gone and I had some amendments on, and I wanted to make certain that some conspicuous language was on the bill as it relates to what happens when a person goes into a restaurant. We had that bill come up. I wanted to have it in the negative as opposed to the affirmative, that if they did not allow it, that we would not have it. And obviously that bill passed pretty much overwhelming. And so what do we do on this? What we do on this is that this amendment, and this is a compromise over time, and I think that what we will know is that over a period of time, this bill has been on the calendar. We've talked about it. We have discussed it. The senator from Charleston, Senator Campson, and I have worked on it for a period of time. It was on Senate Bill 640, the last two-year session. And so we have gone back, and with the help of the senator from Charleston, also the senator from Greenville, Senator Corbin, what this amendment does is that it reduces the time. And so what we're asking for is a faster disposition of the time of the reporting when someone has a problem. Okay, the amendment will reduce the time required for the clerks of court to report dispositions and information to SLED. So it requires the information that they've been needing for a period of time so they can act quicker. It will prevent a person named in the orders from obtaining a firearm. The clerk of court for the general session, family court, magistrate, municipal judges will all be required to report to SLED within this period of time, 5 days. 5 days, which is weekends and holidays not included. The disposition of each criminal case and the issuance, recession, or termination of any. And I think that the senator from Greenville is not in right now, but he had a specific request to the senator from Charleston that he wanted to make certain that if someone was reported that they were not guilty or their cases were dismissed, that would be reported right away too, so they would not have a problem. And so I think that we got that included, Senator Charleston, by a nod of the head. But also, and the issuance of recession or termination of any restraining order, permanent or emergency, any orders of any firearm prohibitions, any criminal indictments, any orders of protection from domestic abuse, and you all know that we have been through this process for a period of time, as those that would not be able to end up having a gun whenever they are under one of these protections, and any other order by a judge that would prevent the legal purchase of a firearm. And so it also adds that the court administration has to create a checkbox on the forms for anything to be sent to SLED. And so this is the force of the amendment. It is detailed, it's bipartisan. I think that it is one that obviously I think it's critical for us to get this piece of legislation, this piece of amendment into this bill as we're going forward, because the time issuance is critical. And so as we continue to end up talking about the issue, and I just almost complete this with my discussion and feelings on this, you know, the issue is not whether we have guns or not have guns and those kind of things. I mean, you've heard me stand up in this Senate body before and say, I still got my Daisy BB pistol, it looks like a 38. We have guns. We have as many guns in South Carolina as there are spiders. Spiders are right next to us. They're all over the place. Most of the people in here are gun owners. But what we're having is that we continue to end up changing, and so I don't want us to lose focus of the debate. We spent a lot of time in this body talking about guns. We talk about the issue of heartbeat and personhood, and those kind of things. And I just say, just as a point, let's not get distracted. I thought that we would be talking about tax issues and those kinds of things in this session so that we could end up finding other ways to move forward. And I would just say, almost in conclusion, as we know what is going on here, we spent a lot of time on a hate crime bill yesterday, and we're understanding what happens. And you all know I had some reservations as it relates to appearances, self-defense, matters of the castle doctrine as it relates to this particular doctrine. And so we'll get into that as we go along the 30-some-odd amendments that we have on the desk. But I would tell you this, folks here, this is the most critical piece that we can end up having that hits the rubber of the road, because when they're starting to do their research and they're starting to end up taking a look, if they get the information and get it quick, then obviously it gives SLED that opportunity to end up making a review. And so if we look at the premise, which we have, and I'm combining a little bit of the story of guns, a little bit overreaching, is that when we talk about what happened with Dylan Roof, he's ultimately denied the gun purchase. They missed it. Came out of the incident report that he had over at one of the local shopping malls. And so had they caught it, or they had something with the indictments, reports, and those kind of things where they had full reporting, they would have possibly caught it. Here's what we know, that purchase started sometime in April. And ultimately, we know the tragic events that happened in June. I report to you again, and you heard me say it from this floor before, he was ultimately denied a gun purchase.
Senator, you ready for
11
questions?
Not yet.
Not yet.
11 days after the murders, denied. We're taking an important step today. And we're saying, so it doesn't go to a lot of the aspects of it, but it's essential for this bill. All the folks have agreed that we would come forward and say, guess what? We, the state of South Carolina, what we're going to require in this process is 5 days. And the 5 days, when you have a disposition, you're going to have to report it, and it helps SLED. And so much of the burden of all of this falls upon our shoulders as elected officials. We have the power to enact, reduce, and do the work that we end up having here. I know that we'll have a conversation about how dangerous it is and our personal responsibility and the crucial part of the changes that we seek. I know we have a conversation about the part that begins at home and the way that we think about each other and the way that we respect and show one another how we feel. But I caution us as we continue to end up going down the road, the most important thing that we can do is, like Dr. King said, change begins not only when we refuse to shoot, but when we refuse to hate. If we can take hate out of it, then less need for guns. And so with that, I will yield to the questions. Folks, I want to be very candid with this. To me, it's the most important part of the legislation that we're going to end up having, that we'll be able to end up reporting. I have put the able eyes of the senator from Charleston, who's been working on this, Senator from Charleston, Senator Campson. You and I have been working on this for 5 years. I think that we've added, Senator from Edgefield, Massey, has put his eyes on it. There's many folks on this side of the aisle have ended up supporting this issue as well. As of today, Senator Hembry and others. Senator Corbin, you put your eyes on it and talk to Senator Campson to end up making certain that we get in the items so that we can end up reporting, so we can have a safer South Carolina. So with that, Mr. President, I'm happy to yield.
Senator Pickens, Senator Rice, what purpose do you rise?
Will the senator from Darlington yield for a question?
Yes, sir.
You will.
The first question I have is, on this amendment, does this change who can legally or not own a gun?
No,
Does it change in any way that?
It does not change. What it does is that, so what it's speaking to, Senator, is that it's speaking to, whenever we have people that will end up petitioning for it. And so what, in other words, if you have a case that is pending that goes on and somebody gets a conviction or something like that, or they get indicted, or they have a matter that we have a restraining order, things that we have already litigated, things that we've already had in this body. I think the old law had us coming in for the current requirement was 30 days for general sessions court, and that there was no reporting requirement that we ended up having for family court, magistrates court, or municipal judges. And so we're cleaning up some of the work that needed to be done. And so there's a lot of things that maybe it took a while, even in your attempting to get a concealed weapon permit, that you had to end up waiting if there is something that is going on there while they're doing the check. But if there's a person that is not qualified for it because they got some indictment or something that is pending, then this is going to catch them. It gives them 5 days.
Okay, does this change, and I'm asking you some questions because I like your amendment.
Sure, I understand.
At least I think I do.
You do.
Thank you. Does this change what we call, it's referred to as a waiting time?
No, it's totally different.
Totally, so it has no impact on somebody purchasing a gun?
Totally different. So
it doesn't change who can buy a gun?
So let me tell you the difference. Let me tell you the difference before we go down that road. What you're talking about is the transfer. Okay? And so we're not talking about the transfer. We're talking about the responsibility of the government, what they end up having to do as it relates to clerks to report this information that they end up getting. You're talking about something that's that's already down if a person just makes a general purchase of a gun, and it's something that we've talked about. I'm sure you may hear about it later, but the thing is that this has nothing to do with what they call loophole or 3 days, 5 days, 7 days, none of that. And that's why we've crafted it to make sure that it's a reporting requirement.
Okay, and this amendment doesn't have anything to do with what they call a red flag law or anything like that?
No, sir.
So ultimately, this amendment is actually going to make somebody that's law-abiding, it's going to make it better for them because the people that aren't supposed to have guns won't get guns, and hopefully it'll make it better for people that are legally own guns or want to legally own guns. That's the whole point of this amendment. Is that correct?
There you go. You got it.
Mr. President, I ask unanimous consent to be added as a co-sponsor to this amendment.
There's an objection? Hearing none, so order. Senator from Charleston, Senator Campson, what purpose do you rise?
Would the senator yield?
Yes, sir.
For a question.
Senator, so what you're trying to do here is you're trying to get, you know the old saying, garbage in, garbage out?
Yes, sir.
You're trying to get better information in to the background check database so you don't have the garbage coming out on the back end. Is that right?
That's absolutely correct.
And so all you're doing is I say all you're doing, this is one of the most important things we can do because what the bill requires is the reporting of disposition of cases that largely, and it's the disposition of a case. When a judge issues an order that may be a disqualifying event for someone purchasing a gun, that's got to make its way into the database in order for a background check to work properly. Isn't that right, Senator?
That's absolutely right. And it goes further from the work that you were doing and you have been working on for a period of time. I mean, you're actually the principal drafter. And obviously, we know the story. The story would be great information for the body as to how it evolved over time, because when we were going through the committee process, this was the one thing that happened when we came out of the committee. When you and I were working on it, we were trying to say, the most important thing that we can do that Chief Kill said is to end up having this disposition. Because I know the position that was taken then. We didn't get to that point. It got changed in the process because we didn't get the committee report because we had things that were coming out, notwithstanding the committee. But here's what we have now. Also restraining orders, permanent and emergency. And as you know, those are critical because we weren't dealing with the family court. We have any other orders of firearm prohibitions. And so it's important that our local government folks know, Chief Kildos know what is out there before that they can end up getting, as your description says, garbage out. And the criminal indictments. And so if we have a criminal indictment that comes in, well, basically, obviously, if we got that pending, they're going to end up reaching the pause factor at that point in time before they end up taking someone through the process. And then, if you all will recall, those that have been here for a period of time, the matters that we had from protection from orders of domestic abuse, the first time that you go into a court in the family court, orders of protection from domestic abuse, because so you won't have some bad event happen, they end up having an issue dealing with guns. And so we did this many times before Senator from Greenville, and so this takes care of that as well. And any other order that a judge would have done that would prevent someone from purchasing a firearm, they have all of that in. And I'll be clear again, I want to make certain, because this is the, as I say, the meat and potatoes that we have to, as it relates to guns in South Carolina. This is overall, this is an important piece. And so, yes, but what you did and we ended up doing together is that this was only for General Sessions Court. But now it goes on to family court, magistrates court, which is the local counties mostly, and the city judges, municipal judges.
And this is important, Senator, isn't it? Because ultimately the NICS database relies upon information flowing from the bottom up to the database, not from the top down. NICS is not aware of anything unless a court order or the resolution or disposition of a case that is a disqualifying event for the purchase of a firearm has to come from the state level up to the NICS database in order for the NICS database to work properly. Isn't that right, Senator?
Absolutely. And it's not going to catch it unless it's there.
And we had a lot. Well, all the states have a lot that's really not there that makes it into the NICS database, and we're trying to do our part to make our disposition of cases more robust, more accurate, more thorough, and more timely on a five-day time frame.
No question. And this has been a compromise, and it's been a work in progress for a period of time, and it just obviously just makes any bill that we would have will make it better, and it'll make the state of South Carolina better to be able to have this.
Senator, I'm going to ask you a question. I know the answer, but under the rules, I have to ask you the question. I know you know the answer, but are you familiar with the federal case before Judge Gergel and the order he issued in the case of Sanders v. U.S.? His order was issued in June of 2018.
So what the senator is referring to is the victims and survivors of Mother Emanuel, including Senator Pinckney, whenever the case was originally filed. So I represent the Pinckney family. Senator from Williamsburg has a portion of the Simmons family, and we had a case that went in front of Judge Gergel. Judge Gergel issued an order that actually was, he went way beyond and did a lot of work and research and did some of his own and put it all in his order. He dismissed the case. The case is not pending in front of him now. The case was appealed to the Fourth Circuit, and in the Fourth Circuit, we got a favorable opinion sending it back to the trial court, and so the trial court has landed now back in the federal district court in Charleston, and so we are in the middle of that now, and we are talking about now 5-6 years later, and so basically, and so to ask you, am I familiar with the order? I have the order. I keep it in my briefcase all the time. So absolutely.
Well, Senator, I think Judge Gergel and the lawyers involved who did the discovery work that worked its way into this order is one of the greatest services that has ever been done in this area of dealing with the database, because I encourage everyone to read this order, because Judge Gergel's order lays out how insufficient the NICS database has been. Right. And it also lays out how in the same building in Arlington, Virginia, is the NDX database. On a different computer, a different database. But the NDX is much more robust. You can go on the NDX and you can look at police reports. You can search things online. You can look at orders issued, drafted by, signed by judges that dispose of disposition of a case. And you have a very robust database right there in the same building, run by the same agency, the FBI, and much more information that is available in the NDX database, and an ability to search if you have questions. A lot of times you have a question when you see something in the NICS database and you don't know. That's what do they do in NICS? They send a fax. I'm surprised it's not a homing pigeon, but they send a fax and just wait for some response. When the NDX, you can actually search, you can look at orders, you can look at police reports, arrest records, and yet it's in the same building, same federal agency has jurisdiction, but when it comes to background checks, the FBI uses the NICS database, not the NDX database.
Right.
And Judge Gergel and the lawyers, including you, who involved in this litigation, helped bring that to light. And that's still the case today, Senator.
That's right.
Senator, isn't that still the case today?
Yes, it is. And I think that what you're really getting to, and we get a little off now because I don't want anyone to get the idea that what this legislation does is it goes to the premise of the transfer. So what we're doing is that we are focused in tight on this amendment to providing the information and the data.
Right.
And so providing the information and the data is to prevent what you were talking about is that having, Jeff is sitting right there on my computer top, of the garbage out. And so it gives us a better opportunity to end up knowing. So if we got 30 days and it gets, we having the General Sessions Court to have 30 days to end up reporting, what this is going to do is going to shorten that period by 25 days. And so if you got something that occurs and somebody is out and they are going to end up trying to do some more harm and they are trying to end up going through a process and getting something into the system before it clears, then they have an opportunity. This lessens that. And so what this legislation does, this amendment does, it says, guess what? Beware, folks. Thank you, clerk. Beware. South Carolina Senate says you don't have 30 days anymore. You have 5 days. And the 5-day period of time is just, and I realize it's a little bit complicated. It takes us a while, it takes me a while to end up wrapping my arms around it. And for us to sit down over a period of time to try to get this together, and there are other people that understand this well because they've been involved in this process before. But I think what it does is that it just says it's a huge change. Folks, I don't know if they realize how monumental a change this is. I think that for all of the clerks to get together to work with you, I think we started out with J.J. Gentry and others, and you continue to end up working with Mr. Maldonado and others to end up getting this into the piece that we have. And then the senator from Edgefield got a chance to review it, and that's how it got to this point. I just think it's very necessary. I appreciate the work that you.
And Senator, we did deal with the question the senator from Greenville, Senator Corbin, raised about making sure that when there is a termination or the expiration of any type of protective order, that also within 5 days is reported. So if someone has lost and then regained any kind of ability to purchase a firearm, that regaining that opportunity would be reported in a timely fashion as well.
Yes, sir.
Thank you, Senator.
Mr. President?
Senator from Kershaw, Senator Gustafson, what purpose do you rise?
Will the senator yield for a question?
Yes, ma'am.
Here we go.
Thank you so much for offering this amendment. I think it's really important to this bill. And I only have one concern, and that has to do with the 5-day requirement. As I understand it, there were tons and tons of subcommittee meetings. A lot of different entities came together and talked about this, but the overwhelming response from our magistrates and our clerks was that they really, it's too much of a burden for the 5 days, and 10 days is really what they were wanting to do, what they think they could do it within a reasonable time period. We don't have huge staffs. 5 days, a requirement for the people I represent might mean additional personnel, and also might mean, it might mean that we might have a whole new reporting system, as the senator was talking about. So did y'all consider making it 10 instead of 5? And just, again, that's
Good question. Good question.
my concern.
Good question. Our senator from Charleston was there. This this evolved over a period of time, okay? And there was a time when they wanted the time period less. And so then they came in and that 10-day time period was discussed. And then whenever it was less, if I recall, I may be inaccurate, but I think somebody said, 24 hours or 48 hours afterwards. Then the conversation was about we needed more time. Of late, in the last few days, some of the magistrates have raised their head again. But the thing is that they said that they would need a little bit more time. What we're talking about is a system, and so we're trying to do a systemic change here. And so our magistrate system is a part of our system, but when we're talking about the clerk of courts for everyone. And so if we go through this list again, what we're talking about is the General Sessions Court. And that's where all the major cases are actually held. And then the family court, where those protective orders are there. And then the magistrates and the judges. And so,
I understand that. Thank you. Yeah.
Yes, ma'am. And it's a legitimate concern, but they came up with this compromise on the days by the masses, and this has been a while back. And so during this is because we had hearings on this in past years. So this was actually a bill of sorts, and so now we place it into amendment because it fits right in what we're trying to do. So 10 days is not out of the question, but 5 days was the most plausible thing that we thought and the most agreeable and the most safe.
Well, do you think the backlog that some areas are experiencing right now in cases, the timing, I'm just really concerned about the timing and the 5-day restriction there. If they're already overloaded and trying to catch up, I just really feel strongly it should be more than 5 days.
Right. I practice in this arena.
And I know you do, and thank you, sir. I'm going to sit down now.
I don't think that that's an issue. I think that we hit this one where it's supposed to be hit. Senator from McCormick. Thank you, Senator.
Senator from McCormick, Senator Garrett, what purpose do you rise?
Will the senator yield?
A question he does.
Thank you for bringing this up. We need to do this. But let me ask you, there's a couple of points that I want to talk about. One, in the probate court, if we have a determination of mental incompetence, does this bill allow for that judge to also report that finding?
So I need to look back. I don't know that we deal with this on the probate courts in this particular legislation, but I think that we have a bill that allows some protection for that we passed a few years ago with the senator from Lancaster as dealt with those that were being adjudicated incompetent.
This is a very important point because if a probate judge has declared someone incompetent, at least at that time, then it seems to me that that person is kind of like our South Carolina red flag laws that are already in place. It's an opportunity for that judge with that finding to
We'll stand at ease for 1 minute. Senator from Darlington retaining the floor. Senator from Darlington.
Thank you, Mr. President. And this would go back, and Senator McCormick, I'll come back to your question. I've just been provided a letter that from the, let's see, the Vice President of the South Carolina Clerks Association that was given to us. Says, in fact, we would even suggest it be further reduced to 5 business days for the sake of timely reporting, and that they would like to see this bill reflected to the compromise that was reached last year in the Senate, which was the bill that I was talking about beforehand. And so it shows that the Clerks Association and all those folks came in and agreed to a 5-day time period. And obviously, we have not been operating the courts, and so I don't think that they would have a backlog for the things that were filed. I think that the filings would actually be down in light of the fact that we've been in the pandemic and they've been operating but not open. Senator.
Most of our magistrates' court usually file, in Greenwood, for instance, we file on Thursdays.
Right.
I mean, it's a constant that they try to get everything, so that may change that for them, and that's fine. 5 days is fine to get it over to the clerk of court. The other question is this: what happens if somebody has filed a notice of intent to appeal? I'm concerned about that 10-day in the sense that in a criminal case, you've got 10 days to file a notice of intent to appeal. So is there some way that we can have them file with the limitation that they haven't filed a notice of intent to appeal yet? I'm concerned that we're violating their due process rights, taking their gun away from them if they have the right to appeal and they have filed for an appeal. And then the question is during that time, if the jury has come back and found him guilty, or the judge, then the burden is going to be on him to show that his appeal was successful, and then he or she had the right to get their...
In the CWP process, so it also deals with indictments, and so you haven't gone through due process with that yet either. And I think that what happens is that the fact if you've been adjudicated, even though you file your notice of intent to appeal, what happens is, addressing the senator from Greenville's point, is that as soon as that is resolved, they're able to end up coming back. And so, unfortunately, we have to have an all-encompassing process. And so I think that your point is well taken. I think that has been considered.
I just want to make sure that those people who have filed their right to appeal, if they lose their rights during the appeal, they've also lost other rights, of course.
Right.
But I just want to make sure that right is identified, that it is under appeal, if it is by that time, and so that is noted. And then if that ever gets overturned, then there's some method in the procedure to allow them to be able to get their rights restored.
It is. Yes, sir.
Senator from Beaufort, Senator Davis, what purpose do you rise?
Unanimous consent request.
State your request, sir.
To be included as a co-sponsor in this amendment.
Is there objection? Hearing none, so ordered. Senator from Charleston, Senator Kempson, what purpose do you rise?
Darlington yield.
Sure.
What question?
Senator, you mentioned, I believe, that I was on that gun committee.
Yes, sir. Absolutely.
With you.
5 years ago.
5 years ago now. As I recall, and I want to see if you agree, this part of the bill was filed by me and the senator from York, Senator Gregory. Do you recall that back in 2014?
So I do recall. I can't tell you specifically, but I do know that after the committee was over, when we were contemplating the review and the report, that there was some discussion going on during that time, also with the senator from Charleston, that you and the senator from the other members of the committee got together and filed part of it. It's not exactly the same as this, first of all, but it's similar because there's been several disposition bills, several waiting period bills that were filed, and basically at one point in time they were all together. So it's just two different issues. So if I had my rathers during that time, I would have had a chance to end up doing a full report coming out of that bill, which is the normal way that it would end up happening. But for whatever reason, it didn't happen that way. And so obviously, when that bill was filed, that bill did not make it for whatever reason, it did not. It's bifurcated. It went back. There's a long story as to what happened all through Charleston and dividing it and so forth and so on. And at the end of the day, there has become several different bills that have come out of that committee process. This being the one that I think is the one that the Senate had sort of craved. The other one that I support in large part was waiting periods. And at the time, so in my view, you know, you and I have had this discussion. I think y'all jumped the gun a little bit because you wanted to get something done because the people are crying out. I thought it was an opportunity to get a longer period coming out of that period. But as it got more comfortable here and we had opinions and stuff that were coming out, then the period started to shrink. And so in the beginning, there was some discussions amongst the members that end up getting 10 days waiting period. And then it came down to 7 days. I'm not certain what the bill that was eventually filed. I mean, I filed one that went up to 24 days. You had one that filed from a certain period of time. I was on the phone with the FBI at one point in time, and I think it was, some memory goes back, but I remember Mr. J.J. Gentry was with us then, and it's probably too much information to end up going here. But after the murders, FBI got on the telephone with the families and said, we're wrong. We messed up. And so the question becomes then is that what fixes it? What fixes it? How much time does it take? And we went all the way up to some 20 some odd days. And so as opposed to getting bogged down, which is where we were, but I think that what happened, there's appetite for waiting periods and that kind of thing.
Yeah, and Senator, did you know I'm not so concerned about the fact that this first part that's in this amendment was my and Senator Gregory's bill. Because I guess my point is I wasn't looking for the recognition, although I rise to recognize myself.
I understand, but let me pause for that for a second.
But I applaud the efforts.
Senator, please let me answer while I have the well. So there's one thing here in this Senate body that, you know, we had this conversation a little bit before. And I would tell everybody here in this Senate, and I got people who's been here longer than me, nobody owns an issue here.
True.
Nobody owns an issue. We have a process generally that we like to follow. We like to end up having precedent. Anyone can file a bill. Anyone can do all of those things. The process is generally that we take it through the committee process. And we have a strong chairman process here in this Senate where the chairman gets a chance to set the priorities. If you and I were setting the priorities, I don't know that we'd be here in this position now. So, but I think that one, listen, you get credit for each and every part. You've been an advocate. And so I've been an advocate with also a cause. And so that cause has taken a lot of time out. I think that cause collides. I think that it collides and the advocacy collides on the same course, headed in the direction of trying to keep us safe. And I like my quote that I came up with, that I'm sure you would agree with, is what Dr. King says: change only begins not only when we refuse to shoot, but when we refuse to hate.
And Senator, I'm going to vote for the amendment. It's a good body of work, and it was collectively done under this committee, so I applaud the amendment moving forward. The only question I would have is the bill was filed originally with an extension of the background check period from 3 to 5 days, but that is no longer the case under the current amendment, correct?
Right, and I would go further, and I'm not trying to end up moving this to any direction, but what it was, if we'd have waited and got the committee report, I personally think, and we were all younger then, and y'all heard me say many times how long we've been here, because I've just seen a lot of things happen. I think we'd have had a more comprehensive package that would came out as it relates to guns during that time, but it didn't happen. And so the fact that it didn't happen, here we are today, and our responsibility is not to end up going back in time. You know what we can do? We can connect dots going backward. We can't connect dots going forward. we can connect dots going back on things that happen and see why did we have something that happened in our lives, even in that committee, that would make us go forward and do a certain thing, which is what happened in this particular thing. Because as you recall, by and large, the committee talked about issues as it relates to waiting periods. That's what they talk about. But we take that information, we fast forward, we get here. What's the most plausible thing that we can get here today? And I'm anxious to see what happens. I think that we get, a lot of support for this amendment because it's just necessary. And so we get stuck a lot of times on this floor to things that divide us. And sometimes we don't know the answers. We don't know the background. We don't know how we got there. But we do know it's something that is needed. And a short story, and I'll conclude, because it's happened here recently. Some of you are old enough to remember the milkman. Used to come to people's houses out in the country. Milkman comes to a house one day and stops, and he sees a woman chasing a child around the yard with a fly swat. And she was chasing the child with the fly swat, hitting the child in the back with the fly swat. And he stopped and says, I got to stop this. He runs in, child runs in the house, woman runs in, she's exhausted, she falls down, and he grabs her and says, ma'am, how dare you hit that child and beat that child with that fly swat? And the woman says, sir, you may want to get that wasp out of her shirt. Sometimes things are not as you see them whenever you show up. You don't know what they are beforehand whenever the actions are taking place. Don't be the milkman. Make sure you understand what's happening. In this particular situation, we go back, we look at what happened during this process in a gun committee and what the Senator from Charleston is demonstrating and talking about. We're 5 years later doing something that should have, could have been done. But here we are now. But you know what? Here's what I tell you about this. We're better now. We're better because Senator from Charleston got a chance to put his eyes on it in advance. Senator from Greenville got a chance to put his eyes on it. And members here got a chance to put your eyes on it over the years. And the senator from Pickens, who's one of my farm guys, who's a gun guy, as we end up discussing, puts his eyes on it and says, you know what? I think I want to join and help. And so with that, we went too long to be able to end up saying, I think that this is an amendment that is absolutely necessary on any and every gun bill that we end up doing, and hopefully it will be a part of any matter that becomes the law in the state of South Carolina. Thank you, Mr. President.
Question is, adoption of the amendment. Senator from Richland, Senator Hart-Pootley, on what purpose do you rise?
I'd like to address the amendment.
You recognize, sir. Please give the senator from Richland your attention.
Mr. President. So I'm not going to lob any bombast. This is a very technical amendment. And in principle, I support it, but I got to tell you, I'm not quite sure it hits the mark, Senator from Darlington. I, last week, asked SWED what their procedures were when dealing with somebody who's been charged with a crime if they're a CWP holder. And their position was that they, when they become aware, and that's an automated process, when they become aware of somebody being charged, they revoke their CWP. That doesn't mean they can't own a gun. That doesn't mean they can't possess a gun in the same manner as anybody else without a CWP, but they can't carry it concealed. And the authority for that is Section 2331, 215 J4. It says a permit is valid statewide unless revoked because the person has been charged with an offense that upon conviction would prohibit the person from possessing a firearm. However, if the person is subsequently found not guilty of the offense, then his permit must be reinstated at no charge. So, Senator from McCormick, I think that answers your question. The statute, and by the way, it makes sense. Let me give you all a little trip down this data that SLED gave me. So in 2021, revocations in Greenville, attempted murder, possession of a weapon during a violent crime; Union, murder, possession of a weapon during a violent crime; Richland, attempted murder. This is an interesting guy named Christopher Gaskins in Florence. Got to be Ken. Attempted murder, possession of a weapon during a crime, felony; discharge firearm in vehicle while occupied, felony; arson, third felony; second arson, second-degree felony. And it goes the list. I could stand up here and read it for another hour. I'll be happy to make it available to anybody. But just on murders, in 2013 there was a revocation for murder; 2014, 2 revocations for murder; 2015, 1 revocation for murder; 2016, 3 revocations for murder; 1 was reinstated. In 2017, 2 revocations for murder; 2018, 2 revocations for murder; 225 revocations for murder, and 2 so far this year. There's a couple important points to be made about this. One is the data that is to be collected and given to SLED may be superfluous. I don't mind so if it's upon conviction. But secondly, and also to answer a question from the senator from McCormick, in 2015, an Ethel M. Smith was adjudicated mentally defective in Darlington, and they took her CWP. I think there's 2 points to be made here. The data collection is important, but SLED is already collecting this data at arrest. Number 2, it makes me a little bit concerned that this many people that have been investigated, vetted, fingerprinted, scrubbed to see if they met our legal requirements for being able to carry a concealed weapon, are charged with murder. And these are just the serious crimes. Just the serious crimes. So when y'all let somebody like, up in Greenville, Michael Carl Hamilton, you give him the ability to strap one on and walk around town. Remember, not as soon as you gave him his permit to carry it concealed, he got attempted murder, possession of a weapon during a violent crime, attempted murder, illegal use of dangerous weapons, and instrumentalities. For those of you from Horry County, murder. Heather Sims. In Union County, Robert Chibolek, murder, possession of a weapon during a violent crime. In Dorchester County, murder, Salin Shakur Biggs. He had a concealed weapons permit. How about over in Florence, Joseph Edward Foss, murder, burglary first degree. He broke into somebody's house and killed him. He had a concealed weapons permit. We trained him, we fingerprinted him, we made sure that he was of good character. How about Jasper County? Dorothy Marie Smith, murder, possession of a weapon during a violent crime. Here in Richland, Darrell Jamal Simmons, attempted murder, 2 counts, felony, possession of a weapon during a violent crime. Discharging a firearm into a dwelling, licensed to carry, and soon will be licensed to strap one on and walk down Main Street. These are the folks. Now, if Senator from Spartanburg, Martin, has his way, we won't have to, they'll just be able to carry it. They won't have to be licensed. We won't have to do the minimum vetting of them. My point is this: the data collection's great. Just like during the pandemic, we kept up with how many people got infected every week and how many people died. We didn't do anything about it. We just kept track of it. So I think the senator from Darlington's amendment will allow us to keep track of how.
Ms. Colleton,
see if the senator would yield for a question.
Certainly.
You will.
Senator, your points are well taken as it relates to that issue, that it's the bad guys that are going to get the guns anyway. And did you know I agree with you on that? I hope that's what you're leading to. But as to the amendment that is before us, that Senator from Darlington is presenting, it seems to be a series of how any violations of the law should be reported. Were you here back a couple of, maybe 3 years ago when we had a spirit?
No, I was not here, thank God.
Okay. Were you aware of a spirited debate that we had in judiciary as it relates to the magistrates' courts wanting to get an increase in salary? Do you remember anything about that?
No, I can't say I wasn't here, though, because 3 years ago is a long time ago.
There was the debate, basically, if I can just tell you a little bit about it, was basically they felt that they were being overworked, their salaries hadn't been reviewed, there were computation issues that I can't quite remember. Did you know that our Judiciary Committee basically, it did not pass, allowing them, and the reason why I bring that up is because in reading this, this amendment as it relates to magistrates court, what happens in a small town, say in Allendale, where you've got the Cooter Festival on Friday, that's a holiday technically for them.
I have been to the Cooter Festival in Allendale. Wonderful event.
There's a reporting here.
If you admire Cooters. Yes.
Right. And it's Memorial Day weekend. You've got that on Friday. And this, and I've tried to read it and make it make sense because you don't want to get any of these counties awry with this proposed amendments. Say, that is on Friday. That's one day. An offense was committed on Thursday. So the one day is Friday, Saturday, Sunday, Monday. But Monday is a holiday as such as Memorial Day or Labor Day as such. And then, so what the problem I have with this amendment is it says 5 days no matter what as to reporting, but then we're not equipping these smaller courts in these smaller towns to be able to do the reporting properly.
Well,
and did you know that this amendment does not say anything as to what happens if they don't report the way they should?
Well, Senator, I think you make a good point. First of all, I find it somewhat disingenuous for us to be adding 6 new circuit court judges, a couple new family court judges, when the folks that really need the help are the magistrates. I mean, that is the court that everybody and that more people in the state come into contact with than the circuit court. And while I'm sure the circuit court is working their fingers to the bone, the magistrates courts can't keep up with what they have. And this would be a further report. And by the way, what are we going to do for the clerks of court? Because they're the ones who have to report this. Do we give them additional people to do it? Do we in some way assist them? And how are you going to report this? We all know that those of us who go to criminal court, there's a form filled out that a judge has to sign with all kinds of codes on it. That has to be manually entered into a computer by someone in the clerk of courts. This will be a further report. And by the way, there's no time limit on those reports now. This would put a time limit on that report. I guess
Senator,
what I'm saying.
one other question.
Yes, go ahead.
If you would, in looking at this amendment that is being proposed by a number of senators, does it have anything in the report that specifically relates to tort claims liability for those entities, either the clerk of court, the municipal court, magistrates court? Does it have anything in there which would say that their failure to timely report? In other words, what is the remedy if they don't follow the statute for someone who gets killed?
I think Senator Campson talked about the Mother Emanuel case. Judge Gergel ruled There was no liability on the part of the FBI. He was reversed by the Fourth Circuit. It's back to the district court for a determination of basically how much, rather than if. So there could be a enterprising lawyer could make the argument the clerk didn't report it in 3 days, the person kept their CWP, they concealed that weapon, walked into some place and killed somebody, that the state would be liable for up to $300,000 under the current caps unless there were 2 people killed, then it'd be $600,000. Or they wounded them and then they died, then it'd be $600,000. There's a whole bunch of, but yes, this could conceivably give tort lawyers, the most villainous group on the face of the earth, the ability to sue when this is not done properly. So I guess what I'm saying is this is what I'm hearing here is inconsistent with what SLED told me, and there are a number of questions about who's going to do the work. And while I agree with it in general principle, I think we need to talk to SLED, talk to the clerks, talk to court administration, talk to the folks who are going to have to implement this, rather than just have a feel-good amendment. And by the way, they revoke at arrest when everyone's arrested. The date is put in, and it pops up at SLED. They know already. So I'm not even sure of the need for this.
Halfway through.
So, Mr. President, I would move to carry over.
Motion is to carry over since from,
like how the
from Darlington. What
tried
purpose
to
do you
do
ask?
a Freudian slip and talk about the
This is the
Congress
South
today.
Carolina Senate. And
Mr. President,
the Republicans have
table the
majority.
carryover motion.
Since from Darlington moved to table
Yeah,
the
whoever
motion to
that
carry
lady
over.
was, I was listening
All
to
in
her
favor
talk
of
about
tabling the
rate of
motion to
pay
carry
and how
over,
overworked Congress
say aye.
is. And it's just like,
All
are you
opposed, say
kidding me?
no. The ayes have it.
Ooh, they tabled it.
Question now is adoption of the amendment. All in favor say aye. Aye. Opposed, no. The ayes have it. The amendment's adopted. Clerk will publish the next amendment.
See, right now, if we can get this bill through
Spartanburg,
the
St.
Senate,
Martin, what purpose do you
then
ask?
it goes straight to the governor.
Clerk will
Or
publish the next
I guess it
amendment.
goes back to the
Next
House,
amendment
and then it
is
goes
amendment
to the governor.
number 3B by Senators Martin, Verdon, Cash, and others.
Senator from Spartanburg,
Bill
St. Martin
Price, I'll
is
have to
recognized on his amendment. Please give the staunch
But
from
it's-
Spartanburg
it's
your
literally
attention.
almost there.
Senator Martin.
Thank you, Mr. President. Members of the Senate, I'd like to talk for a few minutes
States right now pushing for
without
open carry,
interruption.
which is awesome.
and I'll be glad to take questions from anybody and everybody that wants to ask.
Let me get some attention. Just suspend just for a minute till we can get some attention. Take your conversations outside, please, Sergeant. Keep order. Senator from Spartanburg.
Thank you, Mr. President. And just for confirmation of the desk, this is Amendment 3B, correct?
Turn the air on.
Thank you.
really in
I'd like to
California?
thank staff for keeping up with all these amendments as we go. We're currently on House Bill 3094 of Representative Bobby Cox. And Representative Bobby Cox, who I see standing over there, is with us today. He also is the author of House Bill 3096, which is constitutional carry. And that's why we're here today. And I neglected earlier when my daughter was out here. I think she's on the phone right now. But when she was here and people were talking about the committee process that was gone through, I just wanted to remind everybody
Committee, every gun bill
that
goes to die.
I was touring around the state on constitutional carry, listening to hearing after hearing. We weren't in Columbia for 3 hours. We were traveling the state. And people overwhelmingly came out to support constitutional carry. And we did this over a period of, we had several meetings. We had one in Myrtle Beach. We had one in North Charleston. We had one in Columbia. One in the Greenville-Spartanburg area. And I believe Senator from York, we were up in York. We were up in York and had a meeting up there. So we did travel around the state, listed the citizens.
Yeah. You can carry a long gun openly in South Carolina.
I think it's tough to get folks.
But the problem is you can't carry a handgun on your hip.
To come to Columbia, especially as we're coming through this
what all the Democrats are
COVID
afraid
pandemic. It's hard to get them to come to Columbia.
Yeah, and that's my preferred method of carry.
I know the good folks watching at home, the folks that I represent. I think if they hadn't have been at work, they would have been able to come down here and probably overwhelmingly testify for constitutional carry. So what my amendment number 3B does, I'm going to go through what it does and then talk about a few more things. It completely eliminates the open carry with training
Yes,
provisions
what?
from this bill.
I need you to go down and get
It
me the
replaces
JCPenney package.
open
Okay,
carry
bye.
I'm hoping
with
your
training
pants are in it.
with constitutional carry. Constitutional carry language from House Bill 3096
Oh, it might
is
die now.
identical to what the House passed. The amendment, the one thing this amendment does,
I can't see
Senator
the,
from Anderson,
the live
They would have
is it
passed
leaves
with,
alone the
with
church
permit.
language allowing
But,
constitutional carry or
constitutional
concealed carry
no,
with a permit on
Republicans are
church
on board
property,
with South
which is
Carolina,
already
even though we have
passed the
majority in the
Senate.
House and Senate.
The language is just slightly different than what is passed. The other version was
Well,
from
it's over,
for
guys.
open carry with training, so
Terrible.
some of the
People don't want
terminology
permitted
needed
carry,
to
they
be
want
adjusted to
constitutional
accommodate
carry because it's their
constitutional
right. They were
carry.
born
Yeah,
But
I know
still,
you can hear us. There is a
in
panel.
effect,
I did post the
allows
link
the
midnight.
churches that rent out facility or schools that rent out facilities for
Who, me?
churches, and it allows them
join.
to go through
Yes,
as we
everybody can
pass
hear
the
you.
Senate. It also contains language, and I want to make this very clear to the body.
Is there
It
more people
contains
than just me and you?
language that makes it clear
No, they can hear my
that
phone
this
conversation.
bill
so
with this
yes.
amendment, constitutional carry, does not, and I want to repeat, constitutional carry does not eliminate
Artisan,
our
Tony,
concealed
what's
weapon
up?
permit.
Tony,
here
you're
in
in
South
charge while
Carolina.
I'm gone.
I just
We've
want
heard
you
from
to
this
make sure you
podium
get your
people bragging on
pants.
the concealed weapon permit we have. I
Don't
believe it's a
forget
good
your
permit
pants.
program,
Family
and it's
ordered some
not gonna
clothes for
eliminate
me
it.
off the internet,
But where
so
I
they
come
wanted me to go
from-
down and get them. So
In my philosophy and what I've campaigned on, I've campaigned on this ever
Are
since
y'all-
I
are
was
y'all-
elected.
why not
Are y'all
just keep it in
was
there?
to
I'll go
try
get.
my
Tony,
best
you're
to
in
get
charge
constitutional
while I go
carry
get them.
passed.
All right.
I'm not in
And
charge.
wish
I
I'd
just
have
came
worn
on to
my-
make a joke
my
about your
pen today.
pants.
I've got my
Okay,
Senate
Mr.
pen that
FNH is
the
in charge.
former senator from Spartanburg gave me when I very first got elected. But I also have one from the senator from
What's your
Berkeley.
favorite gun there?
It says
That's
Liberty.
The topic.
And I wish
Oh,
I'd
that's
have
the
worn that
topic?
today because Liberty
My
is one
favorite
of my
gun
favorite
is
words.
probably a Ruger
And the
1022.
reason I love Liberty is
Hell
because
yeah.
it has
I've
two
got a
parts:
1022 takedown model.
freedom.
Oh,
and
I need one of
responsibility.
those.
So what constitutional
Yeah, I got a
carry
Davidson's
allows us to do is have our liberty
I put a suppressor
We
on
have the
one of my
freedom
suppressors on there.
to exercise
Got the
our
Franklin
God-given
Armory
rights
binary trigger.
backed by our Constitution.
VX25 mag.
To
Got
carry.
like a whole stack of those.
But we also have the responsibility
Well, I put a
to know
real
how to
cheap
carry,
optic on it. I
to
need
know how to
change it
use a
to like
firearm,
3 to 9
and
540.
be held responsible if we don't know what we're doing when we strap a
trying to
gun on our side.
bring
If
back
that's
up
what
the YouTube
somebody
side.
chooses to do.
Tony,
My
did you
point is,
send him
I
some?
want everyone to be able to
underpants.
exercise his or her constitutional rights.
That's not nice.
But I don't want
I'm not supposed to
government
talk about
to
me
have to
and
tell us how to do that.
what
And the reason
I
this
share
bill
with
and
not
amendment, I wanted
Stripe.
to make sure it didn't interfere with the CWP. I don't begrudge anybody who
What's
wants
your
to go and get a
favorite
CWP
pistol to open carry?
and go through that training and do whatever they take.
I don't.
And have
I don't
reciprocity
really
with other
go
states
for.
and-
I
and
mean, I
pay for
don't
that.
really.
That's fine with me. But I want
I'm not a fan of
every
open carry.
law-abiding citizen who
So
can
I
carry
like
a
to
gun
carry my Glock.
to be able to
I like to carry my
exercise his or her
Glock 42 in my
constitutional
pocket.
rights and carry with that.
That's
I would
okay.
encourage folks.
Different strokes for
If you don't
different
know what
folks.
you're
I
doing
love
with a
all types
weapon,
of carry,
you probably
but
don't
I
need to strap it
prefer
on.
open carry because I can get
But
away with
most
carrying my
people
FNX-45
who have been
tactical,
around
which
weapons
that's
and
like
firearms
my
all their
favorite handgun.
lives, they know what they're
When I was
doing.
younger and I did
And they
a
need to
bunch of
exercise
hunting,
those rights.
you know, I
A couple
carried
of the things I
open,
wanted
you know,
to say,
carried
and this is
sidearms
the
when I would
reason I
go
wanted to
hunting.
thank staff, and I want to thank the
but
staff up
I
behind us again. They just came
I
through
don't
a
find
budget
much of
cycle,
a use
and now
for
they're
it
working
for
on us with these
self-defense.
amendments. But I think what we did
So-
today is we passed a couple of good amendments. The first one, Senator from Edgefield's amendment, I think that was a good amendment. A lot of times we have to clean up some House language. I think that's been a custom in my time here in the Senate. We from time to time have to clean up House language. So that's a good thing. I appreciate him
You know what I mean? I've got
adding
more
the
choices
anti-commandeering
than I
language
think is what I
to the
enjoy
to the
about it.
bill. I have some
Yeah.
amendments up next
I
that
don't,
deal
you
with
know,
that,
like I
and
said,
I'll
I don't
get
have
to those
anything
now
against
because,
people
like I
who
told him,
open
if he
carry. I
already
just
got
don't
it
think
done,
it's
I wanted to make sure
the
that
best
any amendment I
idea
had coming
as
after
far as,
does not move that.
you know, I
So
think
my amendment is now
having
drafted. The
your
reason it's
weapon
3B
concealed is
is
good
it does not
tactically, you
impact
know.
Amendment 1 that was just passed.
So,
The
but
previous amendment by the
that's
senator
where
from
that's
Edgefield
the
and Darlington
ultimate
and others that's gone through a lot
argument,
of work.
right, in the gun
I think
community.
that I think if that had been a
No,
standalone
it's
bill, it
definitely
could have
not an
probably gotten
argument. I
unanimous
respect
consent.
I
to
don't,
pass
I
the
don't mean
Senate.
argument. I
it's
mean
something that-
discussion,
It's something that
debate.
currently
Yeah,
should
oh,
be
yeah.
done,
No,
but
I
I
love
think
to
the
open
struggle
carry,
is how
and
it's
I
been
think I look
getting
at it, from the
accomplished.
perspective of
So Amendment 3B is drafted so that it doesn't strike out the amendment that was just passed. So that's what my amendment does. I wanted to point out, I know there's been a lot of things that have gone on, but I did just find out that this week the Kansas legislature overrode Governor Kelly's veto of House Bill 2058. And
I do tend to forget it's there sometimes, though. Like I almost walked into a bank one time, and I thought, "Oh crap!" I had to walk back to my truck.
You can go to Kansas and carry there.
Put it under my seat.
And the other thing is, it's kind of funny that my daughter's here with us today. It allows individuals who are 18 to 20 years of age to apply for a concealed weapon permit. So I wanted to point that out. A couple of other notes,
you just don't really feel
talking points.
That much. You get kind of used to it after a while, right? It's like anything in your pocket you carry all the time.
31 states allow the open carrying of a handgun without a permit or license. That's 31 states that allow
what sites do you have on that
the carrying openly of a handgun without a permit
just
or license.
the factory sites.
Now, 15 states require a permit to carry a handgun, and 5 states prohibit from openly carrying handguns in public. And it's a shame that South Carolina is one of those 5 states that prevents people from openly carrying firearms in public. Now, the one thing that we can do that we're not going to mess with, you can get a fishing rod or a cane pole, leave your house, strap your gun on your side, and
messing
you're going
around too
fishing.
much with sights on
As long
pistols.
as you're going fishing,
currently
under
I had
state
changed
law
out my
right
Glock
now,
19
I could walk from my
sights
house all
to
the way to
the XS
Orangeburg,
big
see the
dots.
senator from Orangeburg,
I actually
and go
didn't
fishing
like
with my
them.
gun on
I
the
know a
side.
lot of people are big
If I
fans,
wanted to.
I don't like it when the
or if I was
dot
hunting.
covers your target at 25
the
yards.
trick that you get into is you got to be careful where you're actually going. You can't stop off at the movies. You can't stop off at the convenience store. But now you can pull in there and get fuel or something like that if you're driving. But those are the things.
They're kind
so
of
I
a
think
distraction,
it's
to be honest
time
with you.
that
I mean, I think
South
after you
Carolina
shoot as much,
comes and makes
after you
this
shoot a
statistic
lot,
where only 4
it
states
becomes more
prohibit
instinctive, and you don't
the
really
open
need to
carry of
focus that
handguns.
much.
Now,
And I know
the
people are going to
debate
freak
here,
out
the
over
fight,
this, but
the fight
at a
is going to
certain
be
time, at a certain time in
the
your
fight
life,
is
you
not
find
going to be
yourself
so
not
much
focusing on the
on
sights
whether
as
we
much
allow
as you used to.
some form of open carry.
When you're shooting,
I think the fight
it
is
becomes
probably
more
going to be
instinctive.
over this amendment to whether we allow
the
constitutional carry and CWP to coexist, or if we're only going to allow open carry to exist with a permit. And I think that's where the fight is going to be in here today. Hopefully it's not going to be too much of a fight. I do know
those Trigicon high
that
night sights on it. Suppressor height sights.
I travel to North Carolina a good bit on business. I travel around the country in states that have open carry.
I didn't have a use for the 22.
I've never been offended or worried with someone who is openly carrying a firearm. But I do agree. I think the senator from Clarendon was talking about this. I do agree, and I think the senator from Aiken stated this.
What was Midnight
testimony,
Range talking
that
about?
maybe only 5%, if I'm correct, only 5% of people that could carry concealed would even carry openly if they were allowed. And I think that's something that you pointed out to Senator from Clarendon. I think most people, if given the option, they will carry concealed because they don't want people to really know they're carrying.
Not can hear, but does he listen?
But our laws only allow you to carry concealed if you have a permit.
Yeah, I don't.
Those men and women,
of course, I'm
that don't want to go through the permit process. And we had a lady testify, Senator from Spartanburg,
since I was a kid. It's, so guns to me are just
Spartanburg
not,
behind me and over here. We had a delegation.
I got a hammer in my toolbox. I got a gun.
Lady,
I got a
and the way
square,
she
a
was
tape
signed up to
measure,
testify,
a
I
nail
was
gun.
worried that she was
I
going to
got
be
all
against
these
constitutional
tools,
carry.
and
When I read
that's all they are. They're not.
Read the layout of why she wanted
I
to
don't
speak.
take my, hammer to a barbecue.
But as chairman of Spartanburg delegation, if somebody
So
requests
that's why I
to
don't
speak,
fit into the gun community
I
very
allow them
well
to speak.
because I don't get off on all the
even if I don't
gun
necessarily
porn,
agree with their position.
I don't alter
So
every
she
gun
got
I
up and
buy.
she gave us some
If
statistics.
we were all the same, think of how
She was
boring
talking
the world
about
would really
how
be.
women
that's what I know.
who might be in an abusive
Oh, I know,
situation
yeah.
or under control by
No, that's
abusive
why
spouse or boyfriend that was really worried about her safety, maybe her children's safety.
For anyone that's concerned, I have
If she had to go through
That's
and
good.
get a permit
I just
to
got it in
carry
the
to
mail.
protect herself, that she has to jump
We
through
were about
all
to
kind
solve
of
the
hoops.
oldest debate in the world.
Maybe she's trying to
but
get
you
out of an
interrupted
abusive
it, so-
situation under constitutional carry.
Yeah.
And all the things that you hear about people that may be mentally disabled or something like this or have some sort of
Here's
condition.
a perfect example. Like
Anybody
I've
that
always had
cannot
a
legally
particular
purchase a
case
gun
on
is not going to
my
be able
AR
to
rifle.
purchase a gun.
And I
So
finally moved to the
that's the
point in
reason
my
I
life
talk
where
about
I'm
when
like,
we're
you know
carrying
what?
constitutional
I have a suppressor.
carry-wise,
If I have a new AR,
you already have to be
it's gonna
able
get the
to
same
legally
three-prong
possess that
flashlight
firearm.
silencer code, so it's a
But
QD
when they're
mount.
trying to get out of one of those
Suppressor that I paid
abusive
like $1,000
situations,
for back in the day,
do
with
we really want
tax
them
and all that crap.
going to sign up for a class and paying for
Certain
training,
things, but then there's other mods that are totally
spending all the money on ammunition?
say useless,
Ammunition
but
is
much
expensive
less
now.
utilized,
There was some
like
talk,
a front sight,
a couple of
night
side
sight
conversations
for
I
the
was having the
AR.
other day
Like, I'm
about,
guilty of that.
I
I'll
think
do
some
that.
of the trainers, may have been Senator from Honeypack.
I remember when I got
some of
involved
the
with YouTube Gun
trainers were
Community back
complaining
in,
that
what,
they couldn't
2006,
find enough ammunition to get the
whatever it
class.
was.
So
I got all
wouldn't
excited
want
about
somebody
modifying
to
my
have to go
guns and
through
all this
that.
stuff. And I
if they
took a
don't-
couple
if they don't
ARs
want
and put
They
wood
shouldn't have
furniture
to
on
go
them.
through the added expense and the hassle
When I found out
to carry
that
a firearm
probably
they
wasn't
can
the
legally
best idea,
own
you know,
and obtain,
I got kind of over the
and then
whole
have to go get permission
modifying
and training and
you know,
spend
my
money that they don't
ARs and
have
stuff, you know.
to be
Now
able
I
to
just have
protect
factory
themselves.
stuff.
So
which I
that's
think
why.
I think
another
it
reason
takes a
that I
while to
believe
figure out that the reason something is
that
factory is
constitutional
because
carry
it works.
helps
You know,
people
most of the time.
more than it hurts people. I really do.
No lie.
It's kind of like mil spec, you know, that works.
Once you you definitely hit on something there. Once you
Another
customize
point that I
something,
wanted
you
to
need vet
make.
it again and make sure that it's still worthy of defense.
Now, if this guy's amendment passes, then the bill's dead. If it doesn't pass, then there's still a chance that open carry.
I think that's
permit in
the
South
only points that I wanted to make.
Oh, that's why I
And I
joined. I was going
appreciate-
to
I wanna
ask you. I
thank
don't
the
understand
Senate
what the
for
amendment
allowing me to
is.
make my
What
points
is
and
the actual
comments.
amendment?
And I
This
will
guy's
now
trying to get
open it up for questions from anybody and everybody who may have one.
Change from
Senator Anderson,
from
Senator
open
Cash,
carry to
Representative
permit to
Ryan.
constitutional carry. That's
If the
his
senator would yield for
What do
a
you?
few
I thought you
questions.
had.
I will
Don't you
gladly
have
yield.
concealed carry now? Then?
Senator, do you
yeah, we
consider the right
have
to
concealed carry. And it was
self-defense
open
to
carry with a
be
concealed carry permit.
innate or intrinsic?
Yes, sir.
Every human
Okay.
being?
So
Yes,
what
sir.
are you worried about?
So,
worried about the bill won't
by
pass
extension
if
of,
they,
of that,
if
you
they
probably
allow the amendment
don't
for it
feel
to be
like
an open
someone
carry bill.
needs a permit to carry a pocket knife around if they wanted to.
That's what's
would you?
confusing me. If
No,
you
sir,
already
and
have
and
concealed
it's a funny
carry,
story. I
why,
used to
why
carry
would,
a pocket
why would
knife
you
all the
worry?
time. And I'm
They're
glad
not gonna-
before the
they're not
schools
gonna
got all these
rescind the
zero
current law,
tolerances.
right?
Because I'm of the belief
When I was
that
going to school in middle school, I
incrementally
had a pocket knife one
adding
time.
laws to
And
get
this
rights
young
back
man who was
works
playing
better
with
than
this
trying to
big
get it
thing
all
of
at once.
yarn, I guess yarn like you would tie up something for Christmas or
Well,
tie
that's
a present
true.
with.
I agree.
He made something and tied that around his neck for a joke.
All up to you. But
And the
that's how
teacher
I
was
believe. And
screaming.
I figured
He was
if
trying
we
to
got
breathe.
open carry
And I
with
realized
our concealed carry permit,
that this
then
young man
it
who
would
looked
only
like
take a
me,
year or two for us to get
his
con-
face was
constitutional
turning
carry,
blue.
Okay, that's how I
I
looked
felt
at it.
like it was the
That's
time
kind of
that
how it's kind of
he was
happened
probably
in
no longer going to
Tennessee
be with us.
incrementally.
That's how it's looking like
I
in
took
Texas
out my
right
pocket
now, too.
knife.
Yeah,
Now,
yeah.
but the
I
issue
stuck
is
my
he
two
wants to
fingers
just change it to
in
a
behind that
constitutional carry
yarn.
bill, and you know
Cut the
we're
yarn.
having a
The
hard
teacher
enough
couldn't
time
get it
trying to
off.
get it passed.
All of a sudden,
with,
he
as
went back
a
to normal.
Open
Teacher
carry
patted
with
me on the back.
CCW.
I think I got like an ice cream after that or something. Nobody said a word out of that.
What was
But
what was
it's probably a bad example to use here, but if I hadn't had that in my pocket at the time, I believe that young man wouldn't have made
You
it.
can just open carry a rifle or shotgun on
But I didn't need a permit to have it, and it wasn't against the rules
no
at the
questions
time.
asked. But but they banned
Senator, do you believe
open
that-
carry
that,
in a holster on your hip
some people
in the 60s and after the
sometimes
civil rights
may
movement? And you
feel
can
more
guess why.
comfortable for their personal safety
And that's
if
all
they
I'm
do
gonna say.
have a handgun with them. If they're going out late at night or
They were
they're
scared.
traveling on the road or
They were scared.
something
They're
of
still
that
scared.
nature, that even though they may not want to put one on
Because
every
they've
day,
been living 30, 40 years
that at
with,
times they may
you
feel
know,
like
not
that's
having to see
a
it.
wise decision.
Senator,
I wish that that
I
guy,
believe you're right.
the guy who
I believe
was
you're right. I
touting,
think people
you know,
like to do
calling
that.
people's
That was
names
one
out
of the,
who were
when
murderers
I got,
and had
it was
permits.
my first year here.
I wish he had
And I
said,
thanked
okay, so
everybody
there's this
then,
many people that have a
for helping me
permit
get
to
this
kill
bill
somebody.
passed.
You want to hear
All
the
the
real
senators,
How
the
many-
ones that are still here with us that
How
helped me
many
get that
people
bill
have killed
passed.
somebody without a
It
permit?
was
Yesterday he called
illegal
himself out because
for
he also
someone
carries a permit.
to have a weapon in their
carries a
vehicle
gun.
to drop
That
their
same-
children off
that
from
same
school, to
liberal.
and from school.
He called
It
himself
was
out?
also illegal
Yeah,
for a teacher
he said he
to
had
have
a concealed weapons permit yesterday,
weapon in
and
his
he
or her
carried a
vehicle
gun.
while they were at school. So I went around and I got
Well, we know
testimony
they're
and I
the biggest
solicited the help
hypocrites in the
of the senator
world.
from Orangeburg,
So-
worked
Most of
on
the
my
Democrats
opposition
in the
of
Senate
people that I think might
have a
be
CWP,
opposed to it,
you know,
and
concealed
laid
weapons
out the
permit, and
facts.
carry a gun.
The facts were more of the
I'd say
people that were
75% of them.
concerned about their safety were our teachers who were getting up before dark and driving to school and not being able
They
to protect
probably ought to.
themselves just due to the place that they were employed. And
Good idea.
it wasn't that they were needing that, but when they leave by themselves, maybe had a
This
young
guy
child
kind of
with
freaked
them,
me out when
dropping
he first
the child
started
off at daycare,
talking because he was
they
jerking
wanted
his head
to
in
feel
kind of strange
safe.
ways, like he
And
had.
that's why they
trying
did
to
that.
speak to everybody in the room.
Did you
because
know,
remember, it's a
Senator,
circular
I've been
style
contacted before by a
No, it's
constituent
not that.
who
You don't.
has
when
to
you-
leave
Go
early
back
in the
and watch
morning
when
to
he
go to
first
work.
started. He was
And they
kind of
actually
jerking
have
his
the
head
same
kind of
problem,
in
and I'm
weird
not
ways, like he was on
sure
crack
that
or
this
something.
bill will even solve that problem, which is
I wouldn't doubt most of them being on
they
crack,
can't take their
honestly.
gun with them because where they go and work and park in the employee parking lot, they're not allowed to have a gun in the car.
What's
So
ETV?
I don't know that we're going to solve every problem
Entertainment?
because
South Carolina.
would you agree,
education
Senator, that although
That's why
your
you got the
amendment
South
here would
Carolina
make it
PBS.
outline. Yes,
so
the
where someone
PBS.
could carry a weapon if they wanted to, it also specifically says places where it's still going to be unlawful
Well,
to
at
carry a
least
weapon.
they
For instance,
bring
you
us
cannot walk into a
debates from
courtroom
the Senate. That's
with a
about the only
weapon. You
thing
cannot walk
they
into
probably
a school.
bring that's worth
That's correct.
anything.
I don't want to put
Honestly,
words in
this is
Representative
gonna become
Cox's
a
mouth,
video
but
on
I
YouTube,
think he
so
was
if anybody wants
trying
to watch the straight up
to
video, I'll
realize
post the
that
link in the
the
description
concealed
below.
weapon permit and some of the areas
So
where
if
they
you wanna get
didn't
the whole thing.
feel like that it was agreed upon to carry, wanted to keep
Nice
that
nice
intact
Can I get your
because
thoughts
most
and
people
feelings
realize that we probably don't
how
need to
you
carry
feel about
weapons into the
carry?
courthouse per se. So that's why that's left
I
in
want
there.
open carry with a permit first, and then
So there's
we
probably
push for
10 or
constitutional
11
carry.
places
That's
here,
what I
just
want.
right off the bat.
But the
that
issue is,
even if your amendment is adopted,
if he gets the open constitutional carry, I
there's
believe the
still
bill's
going to be
gonna
places
fail
like a polling
entirely.
place on election
He's
day.
asking what about
I'll
what
be
you
glad to
personally
know
think about it.
You shouldn't have a weapon there.
That's true.
I told him.
I
true.
don't see
Now-
why it has to be banned.
Yes,
One,
that is true.
I want open carry. I'd
And
like
the other
to
thing
open
is,
carry.
you know, I've been the constitutional
like I
carry
don't do
guy
that
for
on my own
years,
property
and I
already.
respected what my teacher said, the senator from Darlington
So I
said
don't see a problem with
earlier
it.
about
I think open
ownership
carrying on
of
your own
issues in
property
here.
is cool, but I wouldn't open carry in
It doesn't
public.
matter if you're
I
for the
only-
cause,
I would only
whether
open
your
carry
name's
if
on the
I,
amendment
you
or
know,
name's
I
on the
wanted
bill.
to. And honestly,
We want
that's
to
the
try
point.
to get
Not that
what's
I'm
to the
going
finish
open
line
carry everywhere,
first.
but I'd like to have
That's
that
why I keep
option.
thanking Representative Cox.
Okay,
He got his bill
It's-
to the finish
it's
line
about
first.
having the option.
So it's
and
still
not having the
advocating the
option.
cause.
Right now, we
That's
don't
why we're
have
here
that
today
option,
trying to move it forward.
Whereas we're one of 5 states
Senator, I
that
think
don't.
you and I both
you know,
understand
we're in the company
some of the
Illinois,
concerns that have been
Florida,
raised and are
New York,
probably
and
going to
California.
continue
And
to be
that's not a good
raised
company
about
to be in.
how people are concerned that this will
No,
make
and it's probably not a
some
good
people
time to be
uncomfortable
debating it
if they see someone
during
carrying,
this
or
particular.
else they're
We weren't
concerned this is
debating
going to
whether we
cause
should
more
have it or
gun
not.
violence.
We obviously should
Senator,
have the right
I
to
would
open
guess,
carry.
is it not so
We
that
were talking about whether it's a
you
good
would agree
idea
with the
tactically or
idea
not.
that if someone is
And that's up
intent
to
on doing
the
harm, or
individual.
if someone
And
is
Right.
intent
your
on
area
using a
and whatnot,
gun
there's a couple variables there. Okay?
for an
I'll
illegal
agree on that.
purpose,
Matt had asked,
they're
your name
already
is
going to
Matt,
have a
right?
gun. If someone's a drug dealer, they're already armed.
Mr. FNH.
Would you not agree with
Yeah,
that?
I'm FNH.
Senator, I
Oh,
would have to
no.
assume if someone's
Yeah,
dealing
he
illegal
had
drugs,
asked
they're
me,
probably
and
armed.
that's why
And
we
whether
had-
or not we pass
started
constitutional
that
carry, whether or not we
conversation.
pass anything, whether or
That's how
not
that got.
we
Yeah.
mandate CWPs for
Yeah,
everybody,
we had just
they're going to
kinda
have a
talked about
gun
how
no
we-
matter what.
what we each kinda
But I
thought
do.
of
I want to
open
go back to
carry,
the first thing you asked
like
me.
it or
I
not.
do
That's what I was
respect
asking, yeah.
what the
Thanks,
senator
thanks,
from
Bill.
Clarendon said. I think there is an awareness issue that could probably be brought to light. I think it could be appearing to be shocking to some folks initially, but I've been to other states and it doesn't cause a problem. Here's what I think
Remember, I'm
that
originally
hasn't
from
been
Arizona,
mentioned,
and when I went back there for
that I think is
Illinois
going to be
Policy
the
Conference,
actual
I
opposite
opened carry
of
in
what
the
people
neighborhood
think.
my family lived in.
I think if you're
Nobody gave
walking
a damn.
and you're at a ball game and somebody wants to start a fight with you, you may be more apt to mouth off or want to do something because you pretty much,
from my other aunt and uncle.
you're kind of in that
So
element.
I just walked over from
But I
one
think
house
the
to the other.
minute somebody
I was open to carry,
straps
nobody
on a
cared.
weapon, whether they're
Nobody
carrying with a
gave a
concealed weapon permit or whether they're carrying constitutional carry, I think once they strap that weapon on, I have a feeling that most people are going to realize
they
they're at
allowed
a
open
heightened
carry on
sense of
premises.
duty
And you know what? Everybody was
not to
carrying.
need to use that weapon.
I had
So
never felt
I
safer
really
going to
think
that conference
that it's going to
than
have
any other place I've
the
ever been.
opposite effect of what some people
Because
think that
everybody
it's
had
going to
a gun.
cause the Wild Wild West. I think
Mr.
the
FNH,
people
you
who are
just,
able
you said something about your
to purchase
microphone.
firearms and are going to use
you-
that for self-protection,
the
think
audio from this
you're gonna
is being played
they're going to be
over
less
the
likely
YouTube
to even
side?
want to be in any kind of confrontational
Oh,
situation.
if I had known that, I wouldn't be talking
Senator,
so much if I had
you
known
know,
that. Sorry.
If we just think back to
That's fine.
the founding of this country, when there would not have been permits to carry guns, I think perhaps we can begin to work through this perception, because I don't in any way disagree that, you know, if this law is passed and some people are seen out carrying guns, that it's going to be what you might say novel, because they haven't seen it in the past other than a police officer having a weapon. But just like if you go back to the founding of this country, if someone had a firearm on them, it wouldn't have been an unusual thing.
Sorry, I was muted.
That over a period of time, to see someone carrying a weapon
Mr. FNH, watch out for the cops.
will not seem as strange as it would seem initially. Would you agree with that?
And Senator, you bring up an excellent point, and I'm going to go on another example.
Both for
Cell phones. When I was in college,
oh no, yeah, I told you about it. No tickets.
the coolest thing somebody could have was a bag phone that they plugged into their car.
Yeah,
I remember
That was cool. And it cost a lot of money a month, and nobody had them. When I was at Clemson walking around,
He's talking about bag phones.
tick after Senator Peeler and Senator Harpootlian were there, but walked around on that campus.
My dad had a bag phone.
The only way you got in touch with somebody was we had phones in our room.
On call all the time, so
And you would call, and we had those answering machines, and you had several roommates, and you all left a message and said who lives there, and you checked your messages, and you called somebody
I had
back.
one of those answering machines.
I had one of those bag
I
phones.
went back over years after graduation.
It was not a bag phone though. It had a
You know
big,
what I
it
saw
had a
on that
battery
campus?
under it that looked like a.
Grenade.
No, it looked like
Walking
an
around
ammo
like this.
can.
Oh, yeah.
Walking around with a
And
little
the
phone
phone was a regular receiver. It sat on top of it. Had the
That was weird to
keyboard and
me.
everything built in.
Is you started
That's how big the
seeing
battery was. for
children
those.
carrying phones on their side. But now, what's obvious to you? It started
That was
out with
like-
something that never happened, and now,
1989, I think.
have fun picking on my daughter today,
You guys remember flip phones?
never seems to put the phone down.
Yeah.
I know I'm embarrassing her right now, but I can.
I see the twitch on
She
him.
came with me today because she wanted to hear this
I
debate
think
on
he might
guns
have
and
disorder.
So it's something, I think we're saying that
That's what I was wondering about. Yeah.
as you see it occasionally, and it might just be occasionally, that that initial concern perhaps
See.
is not as great, you know, once you've sort of gotten used to it.
It's
Senator,
like he's
are you
either
aware
trying to be
that
cool or yes.
what we are calling here constitutional carry or permitless carry, that some people call it Vermont carry? Are you aware of that, and do you know why?
not exactly why. I wish you would tell me though.
Well, because in Vermont, you've always been able to carry. Right. And so this is not a new idea. If you go back to the beginning of our country, you know, there was not a permit required to carry a firearm. It was not an unusual thing.
I had a bag phone. Mine looked like a satchel.
And it's something that in the past decade, a lot of people have begun to rethink that issue. And did you know, Senator, that a lot of people who have the open or the concealed weapons permit, as was stated yesterday, probably only about a fourth of them ever even use it. They have it just as a sense of if they want to be able to carry, then it's there. And that if this was to pass, I don't think tomorrow you would see 1,000 people out with guns on their sides. Did you know, Senator?
Senator, I agree with you. I do think that you would see, I think you would see some that have been waiting to do this. I think you would see them out on the street tomorrow. But I think most of the people with the permits, like the senator from Clarendon and the senator from Aiken
this
said,
thing?
I think that only a small percentage of those
the thing weighed
would
like
quit
30 pounds.
carrying concealed, even if they wanted to carry, and carry openly. But I do think that there would be some people that would be more comfortable, especially in the summertime, even with a permit, even if they had a permit and wanted to have that and pay government and do it that way. if they're in the
Mine wasn't
summertime,
that
it gets
pretty,
hot,
though.
it's harder to conceal that
my
weapon.
my
I
dad's
think that's
was
when you
much
might
worse.
see some more people open carrying
when we got the
or
Motorola
not
brick
being
phones,
so
he was much happier.
concerned that their T-shirt didn't ride up and part of their weapon was exposed, and all of a sudden they're now breaking the law. I think that's what you would see a lot of as well.
Sure, and just to, I think,
Can't actually
repeat the
find the one,
statistic
the
that the
exact
senator
one I
from
had.
Aiken mentioned,
They can't
about
see this.
only about a
I
25%
figured- I
of the
didn't
people
figure
who
that,
have
yeah.
a CWP actually use it. And I believe the statistic he mentioned was probably only
That was
about
like
10% of
1989. I should have put
those,
the date in. I can't find it. Wait.
would actually carry openly,
Oh,
which would get you down to about 2.5%. So did you know, Senator, that I think this other concern you've just raised is also valid, that people who want to actually carry concealed do sometimes feel concerned that, if the gun is showing through or their jacket comes open or something, they could be somehow liable for that as well, and this would kind of solve that problem, did you know?
I do know that, and I really believe, back on the concealed weapon permits holders, I think that they're very conscious not to want to break any of those laws.
Oh yeah.
So, I mean,
I love my CWP. I don't
you're
want to
right.
jeopardize it whatsoever.
Thank you, Senator.
Senator Spartanburg, Senator Kimball, what purpose do you rise?
Mr. President, see if the senator would yield for a few questions.
He will.
Yes, sir, I will yield.
Senator Martin, I appreciate your offering this amendment. I've already informed the desk I intend to co-sponsor this with you. I have a few questions in light of our conversation and delegation just the other day in the Spartanburg County delegation meeting. Do you believe that
I got a question.
do you agree with me that the right to keep and bear arms really isn't about, as many folks will say,
how
deer
long does the
hunting
carry
or going on
permit
hunting
last
trips,
for
or
you
even in the
guys?
case of
5
handguns,
years.
about self-defense
Yeah, ours is
against
5
other
years.
individuals
But
at the gas
just after
station? Would
I
you
got
agree that
mine,
it's
they
really more about
instituted
pushing
online
back
renewals,
against a
so
potentially
I just have to
tyrannical
go online and
government?
renew it.
That's right. The deer weren't coming, the British were coming.
British were coming,
Yeah,
not
we
the
won't
deer.
have
That's
to
right.
renew ours anymore.
Do you think, though, in light of what's happened, and if you look at the number of emails that you have received, that I've received, would you say that
Did you
we've
also
probably
hear
gotten
you
more
guys,
emails from Spartanburg
you
County
guys, are becoming
citizens
a
about
second
this
amendment
particular
sanctuary?
issue than anything in recent memory?
Well, I'm going to be honest with you, Senator, I do agree, and I feel bad.
No. Where did
Yesterday,
you-
my phone was ringing
Where
so
did you read
bad.
that?
And,
Here, I'll
and
send
they
you
know
like
where
I
I stand.
saw it on the.
And my
on the
phone is
Reddit
still
Good
ringing
News.
bad. It was so
Oh,
bad I
boy,
had to forward it to
Reddit.
my office
I
because
know.
I couldn't concentrate on the
Everybody's
calendar
favorite.
in this debate.
But they do.
Well,
it to
I've
I've been
actual
trying. I had
so
like
there you
50
go.
texts. I couldn't even respond to all of them. So the people out there, here's what they want. They want government out of the way
Has to go
of their
through the Senate
God-given
next,
rights
but
that are protected by our
it's halfway
Constitution.
there.
That's what they want.
Well, and that leads into the next question. Do you think, and I believe this is certainly true, Senator, with the constituents I represent, and you and I are neighboring districts there, so I think there's a lot of crossover. Do you think that the government's response to even the COVID pandemic and what we've seen with, at every level, government rolling back rights and imposing new regulations, sometimes by just executive orders, that's led people to a heightened sense of fear about the possibility of
recent,
losing
May
their rights?
5th.
Senator, I think you bring up an excellent
That's
point.
today.
And in thinking
That's
about
today.
that, I think back to March of 2020.
Hey, well,
when
you're
no
on
one
the
knew
ball,
what was going
man.
on. When you go out to your mailbox and you're
man,
thinking
I'm
about
just-
washing your hands when you get the
just
mail
watching
because
everything.
you
I'm
really
making-
don't know.
keeping
There's
tabs.
such an unknown. You know, you got that first executive order,
I have
and
to
you
admit,
think, man,
I don't read the
he doesn't know what's
Washington
going
Gazette.
on. We don't know what's going on. You know, you didn't know how to take it. But then as it went on and we wrote letters and tried to
You know
get
what you
these
should do? You
rolling
should start a
executive
hangout
orders stopped.
separate from
Again, I'm
when you do these
begrudging
things.
what he was trying to do and what he was dealing
Well, you
with.
can't- oh, you
but
can't
what the
start. Well, you
citizens
can
and the
start two
constituents
hangouts. You
that
can
you and I
start-
and everyone
you
else
can
is
live
trying to
stream that.
represent,
But we're getting,
they saw
we're,
that
we're already live.
his government is
I'm
now
using
taking
OBS.
over and
I'm
controlling
not
their lives, their
streaming
jobs,
directly
their
from GunTube.
livelihood, and how to feed and support their families.
'Cause I want
And they're
people to
tired.
hear this.
They're
But I also
scared,
will post the
and they
link to
don't
just the
want
video so they
anything
can go
else to
back and
happen
watch it,
again.
'cause the
And that's
Senate-
why I
the
think
Senate
you
just
see more
archives
people
everything.
paying attention, more people texting
Archives,
us,
excuse me.
more people emailing us, demanding this.
So wouldn't you say that in that same vein of people being concerned about governmental overreach at every level, particularly with regard to the most recent pandemic, that's why they're worried about having to have a permission slip from us in the form of a permit
Thought
to
we
exercise
already
their Second
were,
Amendment rights?
Senator, I
state
believe
that
they are
welcomes
worried about that
all
because I think what they'd be worried about is if you
peoples
have to
with
have
their
that permit
guns.
to carry it, the government who issued that permit is the same government that could take that permit away. And that scares me, Senator.
Well, Senator, that's my view exactly. That's the view of the majority of the people I represent, is that the same government that's taken away other rights is the one granting permission to exercise this right whenever we would view that as an inalienable right given to you by God. My last question would be for those that say that if we pass this constitutional carry amendment, which I support, that the purpose of there's no remaining purpose in having a concealed weapons permit. But as you've already pointed out, there are a lot of privileges that would still come with having a CWP, including carrying in other states, that are not going to be nullified or taken, be careful with the word nullified, that are not going to be revoked by virtue of this amendment being added to this bill. Is that correct?
That is correct. And Senator, and that's why I opened up with, look, if someone wants to go to the government, get a CWP, pay for training, pay to go through all that, have reciprocity with other states, I don't begrudge them. I still think some of the people that call us demanded constitutional carry, they may go get a permit just for those reasons we're talking about. But I think at the end of the day, they feel better, I feel better, everyone sleeps better at night knowing that they can freely and legally do everything the Constitution grants them, or excuse me, the rights that they have that's backed up by our Constitution to carry no matter what government says or does on a whim.
It's ridiculous.
Senator, I appreciate that. Thank you, Mr. President.
Thank you.
You almost need one of those fake
Senator from Richland, what purpose do you ask?
Will the senator yield for just a couple of quick questions?
No, I'm gladly going to yield, but I was hoping you were rising to be a co-sponsor.
Senator yields.
They're not fake, man.
No question.
They're real.
I do have a question. Without a permit, how will law enforcement know if somebody is prohibited or has a dangerous
They
history?
can stop them.
Okay.
Well, if they've got a history and they can't own the firearm, they shouldn't have a firearm
I'm not
anyway.
listening
But
to you. I'm
I think
listening
what you're saying is if they see someone openly carrying, I think that they've just got to trust that person has the right to carry. If that person's not committing a crime, we certainly don't want them to be searched and asked whether they've got a permit or not.
Okay, so we're going with the honor code system.
Well, I mean, I think that's everybody's civil rights to be able to walk down the street and not have a cop stop them and ask them what they're doing.
Yeah, I agree, but that's not how it works for some of us in real life.
Because you're a Democrat.
Do you know if our neighbors in Alabama or North Carolina or Georgia or Florida require a permit for concealed carry?
I think Georgia does and North Carolina doesn't, but I've got this right here. North Carolina is allowed without a permit. Georgia is allowed,
She doesn't
but you
agree.
have to have a permit or a license.
No,
What
she's
other
gonna
state
vote
did you
no
ask about?
regardless.
North
Yeah.
Carolina, Georgia, Florida.
Alabama, my notes say it is somewhat restricted but not prohibited. Florida does not.
We're pretty
You
far
said
away from
Alabama was what?
Florida
I
says
hate to,
restrictions
love you
but
and
not
leave you, but I gotta
prohibited.
hop out of the chat for a little while, fellas.
But the states that
later,
prohibit
Mr.
it
Definition.
are California,
Hey, thanks for
Florida,
having me, guys. Good
Illinois.
chat. Hopefully I'll catch you up another time soon. Thank you.
Yep.
South Carolina. Where's the fifth one? I said there was 5. Oh, New York. So we're in the company of New York, Illinois, and California. I mean, I don't like being in that category.
Neither do I.
Okay, thank you. Thank you for yielding, Senator.
Senator from Greenville, Senator Corbin, what
Thank you,
purpose
Senator
do you
from
ask?
Oh, this guy.
Senator yield for a question.
Senator yield for a question. He does.
I'll gladly yield.
Senator, is this the same constitutional carry bill that you and I sponsored together year before last? Pretty much.
Well, Senator, and I just spoke about, thank you. And I just spoke about the authorship. You and I, I've sponsored constitutional carry for years. Thank the Judiciary Committee staff for helping me with that and making it clear we weren't interfering with the permit process. I did get a side-by-side. There are a couple of differences in Representative Cox's Bill 3096, thank you, that we're basing my amendment off of. Just a couple of minor differences, but for the grand scheme of things, it's the same. There's like a couple different things with signage and maybe a couple little words here and there that's different, but the overall premise
is the same. And that's why the reason I didn't go and say, well, you know, and they talk about subcommittees. Constitutional carry has passed subcommittee, I think, twice. I know the senator from Darlington helped me get it out of subcommittee one time before, but that was years ago. But the reason I used House Bill 3096 from Representative Bobby Cox is because the language had already passed the House of Representatives. So the House of Representatives has passed the language. I didn't want to say, well, I'm the great author of constitutional carry. We've got to use my language.
All right, see you later, Tony.
I felt like his language was so close to mine that it didn't matter. There's no pride in authorship here. But what I did want to do is be able to stand at this podium and say that this was the language already passed by the House of Representatives and promised to be signed by our governor. On the campaign trail, I want to thank our former Lieutenant Governor, former Senator Kevin Bryant, and all the candidates for governor the last time. They all supported constitutional carry. And the only thing I'm taking a step further is I get on to people when they say they're going to sign something. We might need more help than them just signing it, Senator from Greenville. We might need help rallying the troops at some point. I don't know. We may be overwhelming, or we may be a little bit behind here. I don't know.
Senator, did you know I completely agree with that? And I just wanted you to know, did you know, that I also have co-sponsored this amendment with you.
Well, I'm glad you did. I was hoping somebody was going to, maybe the senator from Charleston might want to add the role of Senate to my amendment, but I think that'll be objected to if I tried to bring that up. But,
Senator, did you know you introduced your daughter earlier who's in the chamber with you? Did you know my son just walked in the chamber up from Georgia Law School, so we're glad to have him today.
How are you doing? Do you want to take time to introduce him, or
that introduction's enough, Senator?
Okay,
We're on a very
thank you for being with us. Hope law school is going well, and I hope you straighten them out over there at the court you were attending today. So.
Well, Senator, I appreciate it. I won't take up any more of the time. Appreciate what you're doing. I'm in full support of it. Thank you very much.
Senator from Florence, what purpose do you rise?
The yield for a question.
Yes, sir.
Senator
I'll
yields.
yield to my chairman.
Did you know that I listened very carefully to your exchange with Senator from Anderson? Very insightful. And I think you asked him, or he told you, where you could carry under this amendment. Is that correct?
Yes, sir.
My question to you is, where can you not carry under this amendment?
Well, and I think that's what he was really alluding to. Let me find it, make sure I'm on the 3B now.
Oh, boy. We'll see where this goes. But
it is unlawful whether or
this
not,
is what I have to deal with
over
in
here on
South
page
Carolina.
3, you cannot carry in a law enforcement,
This is the
correctional, or
second day of
detention
this
facility,
They
courthouse,
might do
or
it another day, who
courtroom,
knows?
a polling place on election day, business meeting or office of the governing body of a county, public
something
school
goes through,
district,
though.
municipality, or special purpose district, school or college athletic event not related to firearms, daycare facility or preschool facility, place where carrying of firearms is prohibited by federal law, church or other established religious sanctuary, medical clinic, doctor's office, residence or dwelling of another person. And I can get to cover up on that some before, like if the church, if the board of deacons or the pastor, depending on whether they could authorize, even the superintendent of a school district can authorize his or herself or a designee to carry now. Or if a resident of another dwelling, if you said, Senator from Spartanburg, when you come see me, bring your guns with you, then that would be permission to come into your house. Otherwise, I couldn't just come into your house carrying a weapon. Place clearly marked with a sign prohibiting carrying concealed weapons. And they don't apply to, and I don't want to read all, but basically regular salaried law enforcement officers, and I can go through all those. You probably don't need that, but or employees of a law enforcement facility, members of the Armed Forces of the United States, National Guard, or the state militia. And I'm not sure if that's our regular state militia or Senator from Greenville's militia. And not sure if that's my battalion or not, Senator from Richmond. But that's the places.
Senator, thank you for that.
Yes, sir. Thank you for asking.
You did a good job of telling me where you could not carry. Now, help me understand where you can carry.
Everywhere else.
Oh, everywhere.
Well, just like you can now.
So, person want to go into a bar and have a couple of drinks and carry it in there?
Well, Senator, right now, unfortunately, the senator from, I think most people know, we don't have bars in South Carolina. We have restaurants that serve alcohol. I think that's been a big debate around here. But I think what we did is, even now, under our laws that we passed, I want to say, right as the senator from Dorchester got here, we passed so that you could carry a weapon into those establishments. I think it's prudent. I don't think you can be intoxicated. I'm not sure if you're supposed to even have a drink. I wouldn't. If I was carrying a weapon, I wouldn't even get near it, and I hope nobody else would. But I don't think you're supposed to drink while you're doing that. But if you take you and your wife to go eat, you can carry it with you.
Are we talking about your amendment, or are we talking about your thought about you're supposed to?
Well, I was just talking about my amendment because you can do it now. You can carry there now if you have a permit.
So we do have bars in the state.
Well, we have restaurants that serve alcohol.
Well, I think we got bars that you go in and get a drink, and that's all.
Well, but I wish the senator from Richmond was in here, because he's been trying to figure all this out with I'm pretty sure with our alcohol laws in this state that you have to serve food in order to serve alcohol. So technically, we can't have bars in South Carolina, it's my understanding.
I know that technically you cannot without serving food, but
But under our current law, you can carry your concealed weapon inside an establishment that serves alcohol. You can do that now.
So I decided to go in a restaurant that serves alcohol. Don't do that often. I may occasionally. And get in there and some guy picks a fight with me. That may happen, right?
Well, I would hope not, but I guess it's possible.
No, we ain't talking about hopes.
Right.
We talk about may happen,
That's right.
right? Okay. So if I pick a fight with someone, which I don't generally do, they got a 45 on their hip, they said, I'm going to show you something. Bam.
Right. Well, I mean, all that could happen now, and there's legal consequences for shooting somebody without justification.
But isn't it happening now with the CWP?
Sir?
Wouldn't that be true with a concealed weapon permit?
It would be.
So if we don't have that CWP and just constitutional carry, go in there and the guy don't like the color of my hair, the color of my eyes. He said, I don't like brown-eyed people. Bam.
Well, I mean, you can't stop someone from breaking the law. I mean, that's not what's in this amendment. You know, I mean, if somebody was to do that, you couldn't stop them now. It's already illegal.
But your answer, I think, was you knew it anywhere.
Yeah, right now, anywhere that's not prohibited, you can carry your weapon. And currently, you can carry your weapon inside an establishment that serves alcohol. Well, with that, Mr. President, no more questions.
Just for
I'll move it up.
clarification, you can carry
Question is
into a
adoption of
bar
the amendment.
concealed, but you can't imbibe alcohol.
I asked him a question, but since no, you go ahead.
No,
Senator,
I'll yield to you. I'll yield, Senator. If it's
I just love the fact that your daughter is here and that we all know each other and that she knows that you and I are the force.
She does.
That was a name that we had from a long time ago with the senator from Anderson, and we have a few things that you know and the body needs to know, and this is one of them, that we have these issues that we just really, before we get together this weekend, you know, we talking about how does it work in this Senate, and so I'm gonna ask you this: is that did you know that truth is better than what?
Harmony.
Truth is much better than harmony. And I think that what we're talking about on issues just like this, and it's sort of a complete sentence on issues that we think are true in South Carolina, some things that there's some fundamentally difference. And I think that the other part of that is that no one needs to absolutely tell me yes but everybody needs to tell me
The truth.
the truth. And I think that as we get forward going down this road on this bill, I think that what I see is that the Senate is really close on this issue. I think that it's perplexing. It's with great trepidation that we end up going down this road because of we don't know exactly what's going to happen. We see what happens in other states, and I just want to applaud you as a dear friend, one that has graced this podium and handled it with grace for an issue that is very, very true for you, and you've been waiting on this day for how many years? I'm not certain.
Several. Even with your breakfast crowd in Hartsville rallying me on years ago.
Well, anyway, I think there's some other folks that want to be heard, and I just wanted to end up taking a chance to thank you for your knowledge and your information on this. And I tell you, I think that the way that you laid it out makes some sense. I think in some respects, but I think that it's a tough issue for the Senate. So I want to wait to see where it goes. I think you got another question now. I think you.
Thank you. Yes, sir. And I appreciate your kind words. And thank you.
Senator from Old Senator Rankin, what purpose do you rise?
See if the gentleman, your father, will yield for a few friendly questions.
I'll gladly yield.
And I appreciate your family being here live to witness this, to watch your dad in action, or to watch you, young lady, your dad in action. So in the vein of our parents and in the vein of us as parents, we are told and taught to respect our elders, correct?
Yes, sir.
Not that we respect them if they're wrong, but we're to respect authority, God's authority, right?
Yes, sir.
Man's authority, rule of law, correct?
Yes.
Is that a yes?
Yeah, I'm with you.
Give me an amen occasionally. That might make it a little bit better here.
Well, I'm a little bit nervous today because I was on the elevator and I won't say who, but it was a new staff member, and said, "Oh, hi, Senator Rankin, how are you?"
Young lady, you've got a damn good-looking dad, let me tell you. And not in total levity here, but in the realm, again, of what we are to do. Again, render unto Caesar what is Caesar's, right?
Yes,
we learned that in the Bible. We've learned to respect, again, authority. And I know you have no qualms with some of us, perhaps me personally, in respecting my local authorities, and that being to a person, elected, appointed to a person, respecting the authority of our law enforcement officers who have repeatedly, to me, expressed concern with what you are supporting today. You don't disrespect or
Senator,
have any issue with, again, my local law enforcement officers who do not support this, do you?
Senator, personally, you know, you and I are friends. I respect you. I don't begrudge any member of this body who has an issue with anything I'm at this podium talking about. I'm here today to advocate for me, and I know my sheriff, if he was here from Spartanburg, he'd be standing right here behind me saying, "Hurry up, move adoption." But I understand that there's many others around the state that may not feel that way. And I don't begrudge anyone for that. I really don't. And I'm not up here to do that. What I'm up here to do is to lay out my case calmly, try to give the facts like I did, and hopefully get enough votes to pass this issue. Because, Senator, I think you know from me watching me over the years, it's near and dear. I've been trying to get this to the finish line. But this Senate, I mean, we go through a lot of things together here, and I don't personally begrudge anybody. It's just that I hope that me being here at the podium, that maybe I can sway some people that maybe weren't on my side or think in my direction. And if I can do that, then it's a win for me. But if not, I've got to do better next time and try a different strategy. But I don't know any other strategy on this than to lay out what I believe in my heart and try to use the the language that has already passed the House and the governor has committed to sign, I felt like that was the best avenue for me to take rather than try to add any more things that Shane Martin would like personally into it.
So we've heard discussions, and I appreciate the debate we've had on this with you on this particular amendment. Again, there was a subcommittee hearing that I think the Judiciary Committee chairman appointed to. I don't know who that person, that chairman is. Oh, that's me. This bill, and
I heard that. I thought it was me in the elevator,
yeah.
but
again,
it is you.
Great looking guy.
That would be you.
You are a younger man. By what? How old are you? Are you in your 30s, Senator Rankin? You look great.
Yeah, I tell you.
Anyway,
we're getting closer to moving adoption now.
So 3 hours of testimony on this bill, and again, the House has taken up a separate bill 2 weeks or 3 weeks after passage of open carry with training. So do you believe that that subcommittee process was fair and exhaustive and that folks were heard?
Senator, and I mentioned that. I don't know if you were here when I first started my remarks, but I talked about the fact that I know they tried to get through and take 3 or 4 hours of testimony. I alluded back to several years ago when we went around the state when I was still on the Judiciary Committee, and we went and listened to hours upon hours of testimony around the state in favor of constitutional carry. So
that was Senator Martin. That was 5 years ago?
Yeah.
He was the chair of the committee
then?
then?
I think Senator Martin was, because that was a time when Senator from Cherokee got on me when I first got elected that I'd given him 2 Shanes and 2 Martins, so it confused everything. So, but anyway, we went around the state and heard a lot of testimony. My point was this issue has been around for years. I even mentioned that it passed the Judiciary Subcommittee, I think, twice. I do know that you have assigned a subcommittee on constitutional carry, and I do know that you assigned, it's my understanding that you assigned the subcommittee on this bill that we're currently under before you ever received the other bill, the constitutional carry from the House this time. So,
and that may be right. But,
right.
And again, you bring up the history of this a couple of years ago, and forgive me, is your daughter in college or in high school?
She's in college.
Okay. So you recall this bill and your efforts 3 years ago. My daughter is a sophomore at Emerson College, just came home last week.
Give her my best.
I will. She might not be listening now, but...
I would hope she's not.
I hope
but
not.
I do remember you and I they're very similar in age, and we've both brought our daughters to this podium, and
they've met in, I don't know if you remember this, Hollings, y'all met in Hilton Head.
Yes.
But nonetheless, I recall this subcommittee assignment that we had before, and that was to take place the next day. In fact, Senators Goldfinch, Senator Sin, and one other, Senator Malloy, I think, were on the subcommittee. And they had called experts in. They had folks that were coming the next day to testify and appear in that subcommittee. And I think that was on your bill, was it not?
It was. And Senator,
3 years ago, let me finish.
It was May 8th of 2019, I do believe.
So that's 2 years ago, which might make sense, but that I don't believe was the actual date. But nonetheless, we were near the end of the session, but the bill had been sent to subcommittee. You remember that?
You had. And it had been delayed. You had sent it to subcommittee earlier. It had been delayed for an issue we had with a House member who was threatened.
What was that issue? Because I broached it yesterday in our group.
Right. I believe it was on the same issue in the House.
Someone was threatened. A House member was threatened.
The House member, I believe it might have been the chairman of the committee that wasn't moving the bill or something. Or I don't know what the reasoning was, but a House member was threatened, and the subcommittee chairman from Georgetown that you appointed, I think he probably made the right call at the time to not have that hearing at that time, and it was rescheduled, and it was.
All right,
and I was just trying, as you know.
Well, let me get to that.
I was trying
to
move us there a little faster.
Well, and in fact, to be fair and truthful, you didn't want any subcommittee testimony, and you bypassed that subcommittee by the day before moving to recall it from the full committee. So effectively 2 years ago, or 3, by your action, you prevented this Senate, you prevented the Judiciary Committee, you prevented these subcommittee members from having any testimony on your bill. You agree with that, don't you?
Well, in part, I did ask the senator from York the other week when he was trying to get a bill out of committee, and I was making that point that it was no longer under the jurisdiction of the committee, but that a committee could still hold any hearings on any issue or topic they wanted. So my actions did not prevent that subcommittee from having that testimony. Even though the bill was already over here, it didn't permit that at the time.
You didn't invite that same group that had come at the request and invitation of the subcommittee chair to ever reschedule a hearing 3 years ago, did you?
Actually, it was 2 years ago, and it was May of 2019. You can look it up in the journal. We were running out of time, and for the people watching on TV, you can't just plan. A lot of people think one senator can jump up and just make any motions. You have to get recognized in the motion period. I caught the chairman of rules. He wasn't paying attention, and I got recognized by the president. And once I got recognized, I knew it was close to session. It wasn't to begrudge you. It was I realized I had my chance to get a vote on constitutional carry and try to get it to this floor of this Senate, because in my mind, it had already passed a Judiciary Subcommittee before. We had been around the
5 years ago. Well, 5 years ago.
But it would have been 3 years prior to what I was doing. So at that point, I felt like everybody knew where everybody was going to be, and I wanted to get this moving forward. And I even asked the senator from Georgetown if he could still hold his hearing, but the Judiciary Committee staff told him that it was no longer part of the committee and they couldn't do it. I did ask him, and he can verify it. I asked him, would he still go ahead and have his hearing? I was just glad to have it on the floor of the Senate for a vote, and he'll verify when he was here.
I wish you'd have told me. I mean, I was just the chair of the committee then. I would have certainly, to the people who came to testify, I would have been a bit more courteous to them to let their voices be heard. And 2 years hence, they have been. Effectively, 3 hours have been spent in subcommittee, again, that I appointed to advance this debate. But to a personal note, and you know this, I've shared this with you, that was not your first attempt to discharge that bill. It was a second attempt. Before the subcommittee ever met, you again tried to bypass a public debate, public input at the committee process. You failed on that instance, correct?
I did. I failed the first time, but Senator, when I'm advancing what I feel is our fundamental Second Amendment, God-given constitutional backed rights, with all due respect, I think a lot of you and we're friends, but at that point, I care more about advancing the cause of the Second Amendment than I did the committee process.
And again, no disrespect to you for doing whatever you wanted to, but again, on a personal note, and with your daughter here, you recall on your second successful attempt that you knew that I was hitting the road to Greenville to have supper with my daughter who was at the governor's school, and that was an opportunity for one less vote, and perhaps not to alter this debate happening today. Perhaps it would have happened 2 years ago, but as a dad, you know when you need to do something with your family, right?
That's right.
And we've shared this just to make it public. You knew that I had something that I needed to do that I thought was important, and not stick around to the end of the session to protect my flank and the committee's flank from what you, on the second attempt, did. You know that, correct?
Well, Senator, when I was able to get recognized over the senator from Edgefield, I did what I had to do, and in the moment, I was not thinking about you or anybody else.
And
other than
nor should you. Nor should you. But again, it's strikingly, it's a neat thing that your daughter's here, that we're having this exchange, and that, again, I'm invoking my family. This bill on its own doesn't decide your child's success in life or mine. But what I think is important, now back to the underlying bill itself, again, you honor and you acknowledge your sheriff, your police officers. Again, they may have a different opinion. You're doing what they think. And again, you said if he was behind you right now, he'd tell you to quit talking and move adoption. But again, in my area, you respect the fact that my law enforcement officials don't agree with yours in Spartanburg.
And I do respect that, and I said that from the start, but since that time, my dad is now texting me, telling me to move adoption and get our gun rights back.
Well, that's curious. I wonder if your dad is operating under the same odd bit of groundswell and what do they call it, a organically grown initiative here. All these folks that are calling us, we're getting these wonderful from home. They don't have anything better to do than to get a call and a text and an organized effort to stop your filibuster. They think you're filibustering right now. Do you know that? And so we've gotten texts, I've gotten calls from Nevada, New Jersey, all these folks operating under this organized effort to well up support for what they don't even understand what we're voting on. Your dad knows what you're pursuing here, correct?
That's right. He knows.
He doesn't need to text you to tell you to do anything other than to say, Rankin, let's go outside and let's talk about our families, perhaps, right? Thank you very much.
Thank you, Senator from Waree. No other questions?
Question is,
I'll move adoption.
Senator from Edgefield, Senator Massey, what purpose do you rise?
Mr. President, I ask to be heard.
Oh, okay.
Senator Massey is recognized on the amendment. Please give the Senator from Edgefield your attention.
Thank you, Mr. President. First of all, I appreciate the senator from Spartanburg's comments. I thought he articulately explained his position very well. He articulately laid out what I've heard from many people, a good explanation for his position. I'm also glad that Ashland's here. I think there's a lot more of Amy there than there is Shane. But I'm glad you're here. He's so much calmer when you're here. It's so much more coherent. But no, Senator, in all seriousness, I appreciate your position. I appreciate the explanation. I thought it was a very good argument for your position. I come up here to speak today because I think training and background checks are important. And saying that has resulted in a few people calling and texting and emailing over the last several days, but I've said that publicly and I'll say it again publicly. I think training and background checks are important. It's interesting, though, that when I've heard from a lot of people over the last several days, and for some of them who I would call back or I would talk to or who I would trade text messages with, it's interesting how many people who have contacted me to encourage me to support constitutional carry don't understand what constitutional carry is. Because when I respond that, look, I appreciate your input, but training and background checks are important. Many times, y'all, the response I've gotten back is, well, I didn't know constitutional carry prevented that. And in fact, that is what it does. Right now, constitutional carry, first of all, whoever came up with the term, the marketing term, was a genius. Right, Senator Spartanburg, it's a great term, right? Because how do you oppose constitutional carry? Right? How do you oppose the Constitution? It's a great terminology. So I congratulate whoever did that. I do think, however, there are a number of people who don't understand that it would eliminate the requirement for training. It would eliminate the requirement for background checks. It would eliminate a number of those things. Those things, I think, are important. But I had many people who didn't understand that. I had a couple people who, when this one gentleman, at least I think it was a gentleman, kind of hard to tell through a text message sometimes, but this one gentleman who sent me a text and was encouraging me to support constitutional carry, and I responded, well, I think background checks and training are important. And his response to me was, well, I don't disagree with that, but I applied for a CWP, and it was rejected because I have a domestic violence conviction. Yeah. And while I understood, I mean, I've read the amendment, I've read the language before, and I understand the senator's position, and it does say lawfully carrying, but I do think it covers a lot of criminals. It gives them cover because there's now, if there's no permit requirement, there's no ability for law enforcement to check the permit when they see you with the weapon. So it gives cover to a lot of people. In essence, you've got to commit a second offense. Even after you've been disqualified, you'd have to commit the second offense before they can see. And so I've got trouble with that because I think background checks are important. But a lot of what I've heard has been dealing with the Second Amendment itself. And I want to spend some time talking about that. But first of all, I want to say this. Look, I think, and I know there's some disagreement with this, I think we ought to interpret the Second Amendment, the entire Constitution for that matter, the way it was intended. I think we should look at what the people who wrote it thought that it meant. I think we should look at the people who ratified it. How did they understand it when they ratified it? Any responsible interpretation, I think, of the Second Amendment or any other amendment or the Constitution itself requires that we have to look at what they meant and what they understood at the time. And I think we should do that here too. Now, one of the most significant, perhaps the most significant U.S. Supreme Court opinion dealing with interpretation of the Second Amendment came in 2008. In fact, surprisingly, most of the significant Second Amendment rulings have been fairly recently. 2008, which I'll talk about in just a minute in a case called D.C. versus Heller. There was another one that came about 2 years later, McDonald versus the city of Chicago. In that case, in 2010, 2011, for the first time, in 2011, the Supreme Court said the Second Amendment applies to the states. Before that, before 2011, there was no application of the Second Amendment to the states. But it does apply now. I'm not a big fan of the incorporation doctrine all around. But it's there, and if you're going to have it, the Second Amendment should apply as well. But 2008, in D.C. versus Heller, the Supreme Court said, for the first time, the U.S. Supreme Court said that the Second Amendment guarantees an individual right to possess, to own, and to bear arms. It said it's an individual right. Now, there had been a lot of disagreement up until that point about whether it was an individual right or whether it applied collectively because of the term militia that's included in the amendment. We'll talk about that some in a minute too. But the majority of the court held that it provides for an individual right. But the interesting thing is they talked about why. Now, Antonin Scalia wrote this opinion, and Justice Scalia, that great bastion of progressivism, but Antonin Scalia wrote this opinion, and as Justice Scalia was wont to do, he probably spent about 40 more pages than he needed to spend in explaining his rationale. But what Justice Scalia did in this opinion was he went through the history. Because if you're familiar with Antonin Scalia, you know he's a big historian. He's a big textualist. He wants to know what they meant when they wrote it. What did they mean when they were having the ratification debates? What did they understand that this meant? So he spent a lot of time in that opinion examining the historical record, looking at the quotes from the statements made by people, the contemporaries at the time when the Congress was debating the Bill of Rights. He talked some about Madison, senator from Charleston, who I'm pretty well convinced would be considered to be opposed to the Second Amendment today. It's kind of baffling to me. The guy who had a large hand in writing it probably wouldn't even be considered a supporter of it. But Justice Scalia spent a lot of time talking about those folks, and he looked at how the states interpreted it. He looked at the state constitutional provisions. Every state has a constitutional provision that's somewhat similar to the Second Amendment. Ours in South Carolina, verbiage-wise, is the same. Many others are a little bit different, but they all have similar contexts. He talked about that in his opinion. He talked about a lot of the commentary and the judicial opinions, both state and federal, that happened after the amendment was adopted, up through the Civil War, even beyond the war, and how it was understood, how they interpreted those things. And I think that's important because I believe that you need to look at that historical precedent when you're looking at those things. But he talked about why they felt the need to adopt this amendment in the first place. And he talked about that, the way the amendment is written, it can be kind of confusing, but it says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And he says, really what that says in modern day English is, because a well-regulated militia is necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. So to the senator from Spartanburg's point earlier, some people would argue that the Second Amendment is there to protect hunters. That's not what it is. Not at all about that. Now, it protects hunting, right? It protects your right to use firearms for hunting purposes. That wasn't the reason they adopted that amendment. Some will argue that it was there in order to provide for self-defense. Well, certainly it covers that, right? It protects your right for self-defense. But it wasn't just for that. It was also to defend tyranny, defend against tyranny. It was there for national defense in many respects because they were very concerned that a tyrannical government may come in. Look, they're creating something new, right? They're creating something that many of them didn't like in this federal government, but they recognized they had to have something new, a central government intact. They're creating this, and they were concerned about the potential tyrannical effect of that government. They just fought a war over this issue. And so what they were trying to do was to protect the individual's rights to keep and bear arms because those individuals might have to be called on to defend their communities, the nation as a whole. So when they say, because a well-regulated militia is necessary for the security of a free state, it's because they thought that the well-regulated militia might very well be necessary for the security of a free state. And in order to ensure that militia would be able to engage and to fight, each individual would have the right, in fact, they would probably told you the obligation, to keep and bear arms. Right, so that's a little bit of the historical context, but that's important. It's important because much of the comments that I've had over the last several days have focused on the language in the amendment itself, and specifically the last 4 words of the amendment. The last 4 words of the amendment being, shall not be infringed. Right? That's what I've heard about a lot. And I understand that. But I want to talk about that because typically what I hear from people who are supportive of the senator from Spartanburg's amendment is it says, shall not be infringed. It means what it says. You can't infringe it. And so when I tell people that I think training is important, the response is, the amendment says, shall not be infringed. There's nothing there that says, only if you have training. Now, as I've said, people focus a lot on the last 4 words of the amendment, They don't focus so much on the first 4 words of the amendment. The first 4 words being a well-regulated militia. And again, Senator from Greenville, who's the militia? Everybody's the militia, right? All able-bodied adults, back then all able-bodied men, but all able-bodied adults are members of the militia. They were expected to own weapons, unless maybe you had, I don't know, maybe you had some vegetarian Quakers or something who didn't own guns, but they probably even owned them to fend off the wild beasts. But it was an obligation. It was something that everybody understood. But the first 4 words are important. Justice Scalia, in that opinion, says, and I'm going to read from page 23 of his opinion just for a second, because I think this is important. Justice Scalia, and he's talking, so what he does, he breaks this down. He talks about every little segment of the amendment. And in this particular section, he's talking about well-regulated militia. And Justice Scalia writes, the adjective well-regulated implies nothing more than the imposition of proper discipline and training. It means what you think it means. Later on in the opinion, he went through a number of historical references, as I mentioned before. On page 45, he starts talking about some of those historical references. He's into the post-Civil War period and how the commentators looked at it, how the courts interpreted the amendment even up until that point. And he writes, quoting one of those 19th century sources, that the purpose of the Second Amendment is to secure a well-armed militia. But a militia would be useless unless the citizens were enabled to exercise themselves in the use of those warlike weapons. Later, he said on the next page, he quoted someone else, and he says, some general knowledge of firearms is important to the public welfare because it would be impossible in case of war to organize promptly an efficient force of volunteers unless the people had some familiarity with weapons of war. Again, y'all, I believe we ought to look at what the authors meant when they wrote it. We ought to look at what the people who ratified it thought it meant, how they understood it when they ratified it. We've got to look at how the contemporaries understood it to be during that time period. And if we look at the historical record, and Justice Scalia does a pretty good job of that in this opinion, it's clear that requiring training is perfectly consistent with what they thought it meant. So when we require training, and what we require really is pretty basic, right? It's pretty rudimentary. That is, you get some exposure to the laws in South Carolina. I think it's important to be exposed to the laws. It's important to be exposed to the Castle Doctrine. It's important to know what stand your ground means. It's important to know when you can shoot, and probably more importantly, when you can't. Those are the things that you are exposed to in that training class. It's important to be able to demonstrate at least a minimal proficiency in handling the weapon. There are a number, I know all of us in here probably know people who teach these firearms classes. They do a good job. They've been slammed over the last several years. They've been slammed in offering these classes. And that's because, look, there is a lot of concern out there that maybe even the police can't get to them in time. There's a lot of concern about what's going on with Washington and what's going on here. I get that. There's a lot of interest in people being able to protect themselves and their families. And so these classes have been overloaded because of that. People trying to get the concealed weapons permit, they're taking the classes. If you talk with a lot of these folks, though, and I will concede that many of them they've got a self-interest in preserving the permit program. I concede that. But it's amazing the stories you hear from these people about folks who come into these classes who have never handled a weapon. They've never shot the gun. They come in, Senator, they don't know how to load it. They don't know how to hold it. They don't know. In fact, one senator here has told me the story about when he took the class, there was somebody in the class who didn't even know where the bullet came out of. Requiring the training is perfectly consistent with how they thought the Second Amendment, what they thought the Second Amendment meant. It's perfectly consistent with that, and it provides a good basis for people who are going out to protect themselves, knowing what the law is a protection for yourself, but also protecting those who are around you. So I believe, based on my review of the historical record, based on the Supreme Court opinion, that requiring training is perfectly consistent with the Constitution. I hear people say, well, shall not be infringed doesn't say anything about background checks. There's nothing in that amendment that says you can have background checks. And I would ask the question, first of all, whether those folks believe, is it permissible? Does the Constitution permit the state to restrict a violent criminal's ability to carry weapons? Does the Second Amendment permit the state to restrict the mentally ill from carrying a weapon? Now, my guess is that everybody in here will say yes to that. I don't think there's anybody who would say no, even though the specific language doesn't say that in the Constitution. Now, it doesn't say that because it was understood. A lot of things were self-evident, right? These guys who wrote this amendment, the ones who were in the states ratifying the Bill of Rights in 1791, they understood. I mean, they didn't let violent criminals, I mean, there were restrictions there. They probably didn't have nearly as much mental illness as what we have now. But there were people that they would restrict. They understood that there are people that you can't have carrying weapons around everywhere. They understood that. And then I'll say, if I can finish this last point, then I'll take a question, my last point on this point. I'll say also that if we go back to this D.C. versus Heller case, and I think this is important because this is the basis for a lot of what we talk about when we talk about Second Amendment rights. Justice Scalia said in here, nothing in our opinions should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill. Or, he went on to say, or laws forbidding the carrying of firearms in sensitive places, such as school and government buildings. Background checks is the way that we do that. Background checks are the way that we monitor those things. So I think background checks, restricting as best we can, it's not perfect, right? We don't get everybody, but as best we can, we restrict violent criminals and the mentally ill from carrying. Background checks allow us to achieve that objective. So I believe, based on what I've read, what I've seen, it's perfectly consistent with the history of the Second Amendment, what they thought it meant, what they understood it to be. I'm happy, Mr. President, to take a question.
Senator Mandelson, Senator Cash, what purpose do you rise?
See if the senator would yield for a few questions.
Yes, sir, I will.
Thank you, Senator. I appreciate your study, your comments. I want to ask you just a few questions about the background checks, see if we understand it the same way. I mean, currently, some people are not allowed to legally possess a firearm, correct? They're a felon.
That's right. Well, you can't, now we're not going and confiscating anything, but yes, there are federal laws that say that, yes.
All right, so the same people who would fail a background check, are they not the same people who cannot legally possess a firearm anyway?
That's probably right.
All right, so in terms of background checks, the groups are the same group. People who would currently fail a background check aren't allowed to have a firearm, which means they shouldn't be carrying a firearm. Even if we pass constitutional carry, that doesn't give them all of a sudden the right to carry a firearm if they're excluded from having a firearm.
But what you do, I'll agree with that, but what you do is you take away the enforcement mechanism. Because right now, Senator, Right now, you're required as a permit holder to have a background check every 5 years. You're required that if law enforcement approaches you and identifies himself as a law enforcement officer and asks you for identification, if you're carrying, you've got to display your permit, right? If you eliminate the requirement, then there is no requirement to show the permit anymore.
Could not a law enforcement officer, well, first of all,
well, now you've got to have.
If you're carrying right now, you're carrying concealed, right? So
I'm sorry, I missed you.
If you're carrying right now, you're carrying concealed. A law enforcement officer has got no reason to come up to you and say, I need to see your permit because I can see that you're carrying, even though I can't supposed to be able to see that you're carrying. I mean, currently there's just not a lot of these, what I would call random incidents where a law enforcement officer is going to be asking to see a permit. Would you agree?
Because you have concealed carry, but there are, part of the reason I think for this bill, and look, and I support this bill. I think this bill is a good idea. But one of the reasons, and the Senator from Aiken talked about this yesterday, one of the reasons that we've heard of those in support of it are sometimes the weapon can become exposed. So, that could factor into that situation. But I think you're right, but I will say that if we allow for open carry, that rule doesn't change. Right? So even though the law enforcement officer may not be seeing it now as a concealed carry, he would be seeing it later on. And I don't want a situation where law enforcement's stopping everybody on the side of the street because they see a weapon.
I understand what you're saying, Senator, but in my opinion, and you can tell me whether you agree or not, a law enforcement officer, if we pass open carry with a permit, I don't perceive that they're just going to go around randomly stopping people and saying, let me see your permit. What I would guess they would be doing, though, if there's some kind of an altercation, if someone points that weapon at someone and there's a problem, they're going to want to see the permit. Would you not agree?
Well, I think if they point the weapon at someone, the person's going to be arrested because that's a crime in and of itself. Look, I don't think that they're just going to be randomly going up and asking to see the permits because law enforcement's not allowed to do that. I wouldn't want. I think you get into some other constitutional issues about probable cause, reasonable suspicion, potentially racial profiling. I think the senator from Colleton brought that up earlier. So I would have concerns about law enforcement being authorized just to do that.
Right. So now we're talking about probable cause. So if there's probable cause for the law enforcement officer to want to know if you should have a weapon, certainly it would be easier for them just to be asked to see your permit, but they could also ask just to see your identification and run a background check on you, could they not?
I don't know how long that takes, but right now, if you're a permit holder, if you have a meeting with a law enforcement officer and he identifies himself and ask you for identification, if you're carrying, you've got to show him your permit.
I understand, but again, we're getting in. I'm just trying to have the conversation about if there's probable cause, a law enforcement officer can still ask for identification. We've got one sitting right here who's telling me that, in a minute or so, they're going to run a background check and ascertain more or less the same thing that the permit did, which is whether or not you're legally able to be in possession of the firearm. So I understand the convenience aspect of it, but it still is, would you not agree the law enforcement officer is still going to try to ascertain if there's a problem with the gun, if that person possesses it legally? Are they not going to try to do that?
I think if the officer sees a gun and there's probable cause to question the person, then hopefully they're going to, I suspect they probably are going to do that.
Yeah. So they're going to be able to do it with or without the permit because they're going to run a background check if we're not in a permit situation.
But most of the time, there's not going to be the encounter with the law enforcement officer.
Right. So we're just talking about situations where the law enforcement officer needs to know should this person be in possession of a gun.
Yeah, I think that's what your line of questioning is, right?
Thank you, Senator.
Yeah.
Senator from Lawrence, Senator Verdon, what purpose do you rise?
See if Senator will yield for a question.
I will.
Senator?
I will. Oh, yeah.
Thank you. Did you know I really appreciate the historical context? I even appreciate the invoking of Justice Scalia as someone we both admire. I'm going to ask, because I believe there's been a degree of conflation with the arguments that were posited by the justice and your definition. Is there not a difference between a well-regulated militia and a well-regulated firearms owner?
Well, the adjective describes different things. However, the militia, and Justice Scalia talked about this, it is as Senator Corbin would tell you, the militia is the individual firearm owner, but it's everybody, right? And so the idea was that you had to have the weapons, you had to be trained in it, you had to be prepared to use it when you were called upon to be part of the militia.
The militia is not an individual under any definition or description.
It's made up of individuals.
The militia is the composite.
It's made up of individuals.
It's made up of individuals.
Yeah.
So the notion that, and it wasn't even a practical argument, and that we could apply to today, I believe that, I think you would have to agree, would you not, that the Founding Fathers would be aghast at one of your observations, and that is that we are most incompetent with arms. Could our Founding Fathers have imagined how unfamiliar that we would be in the 21st century as a free people trying to maintain even a free state? Yeah. Now, we've enjoyed a lot of tranquility relative to what they experienced there in the 18th century, have we not? But can you not agree that they would be aghast in peacetime or war with our unfamiliarity based on what you know that they put in the Second Amendment of our constitutional compact?
I think it's fair to say that they would be aghast on a whole number of issues.
Yes, sir. Certainly they would. But a well-regulated militia, I can't think that our Founding Fathers, when they considered the composition of the militia, that they even fathomed that there would be someone who didn't know the proper end of the gun from which, or
yeah.
So that really wasn't there. So the well-regulated militia, in order to maintain the free state, relates to the actions of that composite group, not the skill set of an individual musketeer.
Well, I think I disagree with that because, it wasn't like the Guard that went out to train one weekend a month, right? They never got together to do that stuff. In fact, and I think I read one of these contemporaries was talking about that you were expected to be proficient with using the weapon when you were called up. Like if they got to call up the militia, they don't have time to train, right? They got to put you out on the line. So you've got to have some proficiency, some understanding in how to use it at the time. Now, you're absolutely right.
And that proficiency usually came from where? What was the natural progression of proficiency with the handling of an arm?
The natural progression of proficiency is what you did with yours and what your father did with you and what my father did with me. But as you know, and this gets to your aghast comment, but there are too many who are not. Right, there are too many who, like the situation that we have now that I described, that you and I were just talking about, where people go into these training classes having had no experience whatsoever with the weapon. That would have been completely foreign.
Have we not had 50 years of cultural demonization of firearms?
If not more.
So the psyche of the general population is one of skittishness, scaredness.
I think that's true.
But for someone who has the culture of the traditional handing down of the experience and the obligations and duties that come with it through their families.
Yeah.
Through their families.
That's right.
Which was the vision of the Founding Fathers, you have to believe.
It was just a self-evident expectation, right?
It certainly wasn't a multi-tiered, layered permitting, seeking of permission from a local, state, or federal government to maintain that cultural progression. Was it not?
Well, no, they wouldn't have expected that, but I don't think they would not have expected that because, as you said, I mean, they were trained just by living, right? I mean, that's the way they were brought up. So there would not have been any expectation of that. However, it's not prohibited by the language.
So the fact that it's not expressly prohibited in the language, you are suggesting that we can develop a whole 200 years of progressive law that contradicts the leading principle of the amendment itself?
I don't think it contradicts the principle of the amendment itself. The idea of the amendment...
Go back to the four important words. You pivoted your entire argument for the background checks and the permitting process on the over-attention given to the last four words of the amendment, not the first four words, a well-regulated militia. That's the reason, Senator, that I went to your definition of what constitutes the government's responsibility in a well-regulated militia. Sure, the militia should have officers. The militia should have training. The militia should have discipline. The militia should have all of the martial spirit and experience necessary to defend the free state. Shall not be infringed. The capable citizenry to make up that militia. That's the whole crux of the senator from Spartanburg's amendment here. As stark as it is in the 21st century, Senator, relative to what we experienced at the founding of the country, it is still the red letter. And even though let's go back to the Scalia interpretation.
I mean,
just because it took that long to get to a Supreme Court definition, the states where most of this rests still, has it not been more safely guarded and promoted than we have, based on what we've heard today, in 46 other states, 45 other states, than what we've accomplished for our citizens here?
I'm all for open carry, but I'll say this too. I mean, I'm happy to give you the podium in a minute if you.
I can't get my questions either on the front end or the back end, Senator. I apologize. Somebody calls me out of order. I'll apologize in advance.
You know I love you, I mean, look, I understand your position. I understand that argument. I've heard that from many people. I will tell you.
Well, I'm about finished. Senator, I don't have any more questions. I just had to make sure that we have more agreement on the first four words argument versus the last four words of the amendment. And you answered for me to my satisfaction.
Okay.
Thank you.
I did use the first four words. One of the points I wanted to make in response to, I don't know if it's a question or a comment, but one of the responses I wanted to make was, I did use the first four words, the well-regulated militia, on the training aspect of it. I don't think that's really important for the background checks component of it.
Senator from Berkeley, Senator Adams, what purpose do you rise?
The senator would yield for a question or two.
I will.
He will.
So I'm going to kind of piggyback a little bit on Senator from Lawrence questions a little bit. So would you agree that when the amendment was written, most of those who handled weapons were probably self-taught or taught by other family members?
Yes.
As I do with my daughter when we went and shot armament light rifles, I taught her the same safety aspects, when to use it, when not to use it, how to aim it and such, just like your father did with you.
Yes.
So I do think that training is there. And then you talked a little bit more about training, about people going to training.
It's there for you, your daughters. Correct. It was there for me.
Correct. And that's why I'm about to go into your other statement. You're talking about training when people went and they didn't know what end a bullet came out of. What we did in training, when I was retired law enforcement, we expected those questions to be at training. If we're going to hear that question, that's where we want to hear that question. Would you not agree?
Sure, absolutely.
So I do believe people going out buying guns now, I think there's more people buying guns now more than what we probably had in the past. And I also think, as you were talking earlier up there, saying that more people are also going through training. Our instructors are busy throughout the country. So I am encouraged by self-motivated training people, and I'm sure you are as well.
Yes.
One of the other things I want to talk to you about is you're talking about, sorry, one of the things I would ask you about, you brought up about a concealed weapons permit, about an officer with the, during a traffic stop. Do you realize, or before the concealed weapons permit, we were allowed to carry a gun in our car whenever we want, still to this day without a concealed weapons permit? Did you realize that, right?
Yeah.
So if a person is carrying a weapon legally in their car without a concealed weapons permit, they're not required to say anything. It's probably nice if they tell the officer if they're stopped, but they're not required to tell the officer they have a gun in their center console or lockbox. Do you realize that?
Sure, and I know lots of times, because maybe I shouldn't admit this, but sometimes I've had some experience with law enforcement when I've been in my car. But many times the officers will ask you, right? They'll ask you the direct question: "You got any weapons? Anything in here that could hurt me? Anything like that?"
That's correct.
Yeah,
that's correct. That's very common. It's become part of their verbiage as they're walking up on the car. And one last. So did you know that officers have the ability to talk to a dispatcher, and while they're running their license or they're writing a ticket, if they're so, whether it's a warning or actual citation, they do run a background check and get anything if they're prohibited or anything like that at the same time while they're doing all that?
Okay, good. I wasn't familiar with the law enforcement process, but yeah.
Thank you.
Yep, thank you.
Senator from Greenville, what purpose do you rise?
Senator Yield for a couple of questions.
I will.
You will.
Senator, thank you for giving us a history lesson. I did a little studying on the history of the Second Amendment myself, and you are correct. And you know that actually back in the Founding Fathers' time, you were not only expected to know about firearms and to have in your possession and carry a firearm, but you were in a lot of hamlets and villages, and you were required to.
Yep.
And if you couldn't afford it, there was mechanisms in place to purchase you a weapon.
Which also would be very important for the militia argument, right? Because we're going to make sure that you have the weapons you need in order to come to fight if we need you to help defend everybody.
Right. Yeah. Well, that's true, Senator. Yeah. Let me ask you this now. We've established earlier when I brought up the fact that it is perfectly legal for any South Carolinian to walk down the street with a rifle, shotgun, long gun, correct?
I think that's right.
Okay. And they can do so without any training required, correct?
Yeah, I think you're supposed to have training with hunting, but yes.
Okay, they can do so without any permit, correct?
As far as I know.
They can do so without any background check, correct?
Yeah.
And they can do so without any proof that they're not a felon, correct?
Carry them, that's right.
Senator, do you know that I think that these facts just negate your entire argument?
Is that the mic drop? Is that what that was? The mic drop? Yeah. There are a few other points that I wanted to make. I don't have a whole lot more to make, but I do. There were a few other points I wanted to make, and that is, I've heard a lot that we should do this because the criminals are going to be carrying anyway, and I think it's true that the criminals are going to be carrying it anyway. I mean, as much as we try to come up with reasons or ways to restrict criminals, unfortunately, they're criminals for a reason, right? I wish we had a foolproof way of excluding criminals. We don't. But I don't think that the fact that some people are going to commit crimes and some people are going to carry unlawfully is a reason to abolish the laws that are out there. The fact that some people are going to commit crimes and carry weapons even when they're not legally permitted to is no reason to get rid of all these restrictions. I mean, I can't imagine that we would take the position that because some people commit voter fraud, that we shouldn't have any anti-voter fraud legislation in place. the fact that people are going to violate the law is not a reason to get rid of the law. Maybe we need to be harder on the criminals, and there are more, I support that. There are more amendments coming to do that. But I don't think that's a reason to just abolish the law. I've heard, in fact, some of the questions were, we shouldn't have to ask permission. Well, I don't like asking permission either. I understand that. I do think it's important. We shouldn't have to get a permission slip. I do think it's important that we point out that South Carolina is a shall issue state, right? As opposed to many other states where our neighbor to the north, for instance, you've got to get a permit to buy a gun in North Carolina. And there's an opportunity for the local sheriff to evaluate your moral character. And they can say no. In many states, in fact, one that's going to the Supreme Court right now, they allow for a moral character component or some subjective component that allows a local official to reject issuing your permit. South Carolina doesn't have that. Right? As long as you successfully complete the class, and you pass the background check, and you complete the application, they've got to issue it to you, even if they don't like you. They don't like the way you look. If they don't like your political opinions, they're not going to deny it. They can't under law. They can't refuse to issue the permit. I mean, some of the conversation earlier, they can't under the law refuse to issue the permit just because they don't like you. South Carolina is a shall issue state, and I think that's important. I've also had in some of the communications I've received that, this is a right, which it is, but we don't require other rights to have permits before you can exercise them, which I thought was somewhat interesting because the bill itself actually references another right that requires a permit to use it. The First Amendment, we require permits for First Amendment expression all the time, for protests, for demonstrations, if you want to have a peaceful assembly on the State House grounds. Right, there are permit requirements. The First Amendment says, Congress shall make no law abridging the freedom of speech. There's no material difference between abridge and infringe. They're synonymous words. We require permits there. There's no difference effectively here. And I'll say also, I think it's important to understand that even though the First Amendment says Congress shall make no law abridging the freedom of speech, all of us would acknowledge, I suspect, that you can't defame somebody, that there are exceptions for libel and slander, or as Justice Oliver Wendell Holmes once said, the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing panic. There are limitations in that respect. And finally, I think this is important. The senator from Lawrence and I were talking a good bit about Heller, and we talked about how he admires Justice Scalia. Now, I admire Justice Scalia. And he was a very, very much pro-individual rights person, whether it be on the Second Amendment or anything else. Sometimes that would not sit well with conservatives, but he was very pro-individual right on things. It's important that in that D.C. versus Heller case, the case in which the Supreme Court decided for the first time that there is an individual right to keep and bear arms, that the remedy in that case, what the court ordered was for the District of Columbia to issue a license to carry a permit to Mr. Heller. The remedy was not that the permit was unconstitutional. The remedy was that they had to issue one. I think that is telling as well. But look, I'll tell you guys, look, frankly, I don't care about the permit all that much. It doesn't matter to me whether we have one or not. It does matter that we have training and background checks. I've heard a number of people say they don't like that they got to pay for one. I hear that a good bit, Senator Spartanburg. Don't like that you got to pay for it. It's a right. Why should I have to pay for it? And I got to tell you, I agree with that. We don't charge people to register to vote. We shouldn't charge them to exercise this right. In fact, I've got an amendment coming up later that's going to make it no cost. That there would be no cost for the sled fee and there would be a reimbursement for any training class. I think that would be important. I would like to see that done. But, Mr. President, I came to speak for two reasons. One, because I wanted to express that I think it's important that we have training and background checks. My other one is to point out that training and background checks are completely consistent with the Second Amendment, consistent with how they thought it, what they thought it meant when they wrote it, and how they understood it when they ratified it. Justice Scalia told us that. And the historical evidence backs him up in that. So I'm opposed to getting rid of the training and background checks.
Senator from Pickens, Senator Rice, what purpose do you rise?
Will the senator yield for a couple of questions?
Of course I will.
You kind of piqued my interest there because you said you don't care about the permit.
I don't care.
But you do care about a background check and you do care about training. How would you deal with a background check without a permit?
Well, effectively, I understand that permit is kind of a root of permission, and so people see it as a permission slip. But effectively, because it's a shall issue, it's really not a permission slip. But beyond that, the permit really is just the vehicle to allow for the background check. That's the way you ensure that it happens.
So you would want a permit then?
I'm sorry?
You do want a permit?
Look, if there's another way to ensure that people have training and use of that they're exposed to the laws, that they have some training in using the weapon, if there's another way to ensure that people have background checks every 5 years, I'm okay with getting rid of the permit.
Okay, and I hear you on that. I don't know that I agree with you on that because I think if you're law-abiding, then you're law-abiding. If you're not supposed to have the gun, you're going to have it anyway. But on the training, what would be acceptable to you on the training? If the individual had an affidavit in their pocket that said, I've had an hour's worth of training at ABC shooting range, would that be acceptable to you?
I think I think the training should be what we have now. Right? You have the course, you're exposed to the laws, you're told about these types of things. It's important to be exposed to those things, I think. I think that's important. And it's important to be able to demonstrate a minimal proficiency. When you're shooting 50 rounds, you're not going to become a marksman. It's a minimal proficiency. I like the training that we have. Now, personally, I'm okay with getting rid of the permit as long as you have with you some type of a certification that you completed one of those classes and you have proof that you've successfully completed a background check within 5 years.
But I'm on the training right now. I'm just trying to think how you would make that work because without submitting that to somebody, and I think about it, I've got a commercial driver's license. I have to get an annual physical every year because of that. I don't have to carry that card anymore. I may be wrong about that. I do carry it, but I don't have to because I now have to submit that to DOT or DMV, and they actually log it in on my license, and they send me an email when it runs out. But I'm just concerned if I have training, and many of us have had training over the years, had a lot of training. Anybody's got a CWP does. But you have to submit that training certificate when you get your CWP to SLED.
Yep.
My concern on the whole thing, and that's the whole emphasis on this amendment, is that you do it on your own. You don't have the government watching over you. So you could do it. You could have a training course. If you go out back and...
But it eliminates the requirement.
It eliminates the requirement.
That you have the training.
Well, it does. It doesn't require you to have training to have the weapon. That is correct. But you have to, under the permit process that we have now in place, you have to submit that training to SLED.
That's right. As part of the application.
Somebody that's handled guns for years may not need that training. Well, somebody that doesn't know which end of the bullet comes out does need that training. So
all right. I think everybody would tell you they're fine. But there are exceptions, of course, for people whether you've had military training, you had law enforcement training, you don't have to go through the proficiency part of it. But even if you've had the training, Senator, you may very well not have any idea what stand your ground means. And I think it's important that you know that.
I understand where you're coming from on that, but I'm worried about the process more so and who you have to submit that to. You're saying if you had an affidavit in your pocket that said you have been trained, you'd be acceptable to that.
So you have, right now, in order to complete the application that you send in to SLED, you submit a certificate that you receive from the training class, right? Like, I don't care about the permit. I care about the training and the background checks. So if there was some way that you could have something, if you had a certificate or something that you keep on you that you can show to verify that you've had the training, that's sufficient for me.
I think the training side of this is easy. It's the background check that's hard. I mean, how are you going to deal with the background checks? How are you going to do that?
Well, the whole purpose, I mean, as I understand it, and I've thought about this a lot, trying to figure out how to get there, and I'm willing to listen on that to ideas, but it seems to me that the whole purpose of the permit for the renewal process, the reason it's renewed every 5 years is just the vehicle to get a background check. That's all. I mean, that's the whole purpose of the renewal part of it.
But without a permit, how are you going to do the background check? Explain that to me.
Well, I mean, I'm asking you. I mean,
well, yeah, I get to ask you questions. You don't get to ask me. I've been wanting to say that a long time.
Yeah, I understand. Well, no, I mean, that's why, I mean, I've had a hard time coming up with a way, how do we ensure the background checks without having the permit? If there's a way to do that, I'm game.
I mean, right now, you don't have to have a background check to have a gun in your house.
That's
now,
right.
Granted, to buy one, you do.
From
and
some
to carry
places.
one, do what?
From some places, yeah.
But you don't have a background check on everybody in the state of South Carolina that has a gun.
No.
So, I mean, I think to do a background check and expect to do that without a permit process is going to be difficult.
I think that's probably right. My guess is that's why they created that permit process back in the 90s when it came about, was especially the renewal part of it, was to ensure that they could have a frequent repetitive background check that's run. Because I don't think anybody would argue that we want to allow domestic abusers to be carrying weapons around. That was the way they came up with in order to try to restrict that as best they could. It's not perfect, but it was the best way that they knew how to come up with.
It's my understanding, though, that what I heard, the debate earlier that I heard today, that if somebody violates a crime, that they report that to SLED. You just said that you do it every 5 years to check on the background check. I mean, that kind of contradicts itself. If they're clearing, or if they're checking people with CWPs on a regular basis and getting them out of the system, purging them out of the system, or taking their permits away, then they really don't need the renewal process every 5 years.
Yeah, but and if that's the way that it works, then I would be okay with that. I don't know that is the way that it works all the time. I mean, what we're asking for in that previous amendment was that the courts have to report this, but I don't know that it's always, every time something is reported, I don't know that it's checked against the CWP database. If that is happening, then you may not need the renewal process. Yeah, I don't disagree with that.
Senator from Lawrence, Senator Verdon, what purpose do you rise? Senator from McCormick, Senator Gadd, what purpose do you rise?
One more question, Mr. President, with Senator Yield.
Of course.
Yield.
Are there any other constitutional rights that you've come across in your study to see whether or not there's been any type of training requirements?
I'm having trouble. I don't think there is.
Like hunting, for instance.
Well, that's under the same one, right? I mean,
we have a constitutional right to hunt in South Carolina. Is that right?
Yeah. I think you got a constitutional right nationally too. But
sir,
I think you got a national and a statewide constitutional right. Yeah.
Right. It's interesting. I was made to take a certificate of training. I was exempted in South Carolina, but when I wanted to go bird hunting in Colorado, they made me show my proof of my South Carolina certificate showing that I had been trained. I didn't have one, so I had to go back and get one because they wouldn't accept the fact that I was grandfathered in. They made me take the course.
Yep.
So all I'm saying is certificates of training are required in the area of hunting, which is also a constitutional right.
Yep.
There is that in our precedent.
Oh, yeah, no, absolutely. I mean, I'm sorry, I misunderstood your initial question. I thought you were talking about outside of the Second Amendment issue.
No, I'm talking about strictly South Carolina. Look,
Sure.
this thing about the federal Constitution right now, we're talking about South Carolina Constitution.
And I'm with you on that too, right? Because I said earlier, I'm not an incorporation fan. Right. I don't like that doctrine.
I mean, I think our right is independent of the federal government.
Right.
South
Absolutely.
Carolina, we as an individual have an inalienable right to own and possess a firearm. And we're also, by the grace of God, we're Southern and South Carolina, and we're also in an unregulated militia. Is that right?
That's right.
And also our Constitution says, and it's also been adopted by the legislature, that in times of war or in times of insurrection, you know, I'm thinking about the people who need to be trained to be able to handle an insurrection. For instance, when we saw what happened in one of those northern states where somebody took over a whole block, I just don't think that could happen in South Carolina. I don't think our well-regulated militia, if our own National Guard didn't step up and help because they were out somewhere else, or our federal didn't come in and help, who else is there but the unregulated militia to protect our citizens and our neighbors?
I think in a situation like that, you'd probably end up with a posse forming, because I don't think that would go over very well here either.
It wouldn't go over well in Edgefield and Greenwood, can it?
No, it would not.
I can assure you that.
It would not.
So, you know, again, if you go back to the unregulated militia, those weapons, and Senator from Greenville's argument was that we ought to be able to keep the weapons that we've got, you know, in order to make sure that we have those weapons as a matter of state constitutional right to be able to protect ourselves in the event our own militia isn't there. Is that correct?
Yeah, that's right.
Isn't it also a check and balance? In other words, there is a reason that the unregulated militia is also there. Our forefathers had the insight. What happens if you get a rogue military?
Sure.
What happens if you get a rogue regulated militia? The people in ourselves have an absolute right to protect ourselves.
That's why in the federal Constitution, and when the state constitutions mirrored this in many respects, but that is the very reason that they guaranteed an individual right to keep and bear arms, was for that purpose right there.
And I've got a right now to keep one in my house, and I got one to keep one in my car, and I can take it to my office where I work. But when I want to go out in the public, you know, I'm being prohibited from doing that now. And so, you know.
To carry it openly, yes.
Right, carry it openly. I can take my rifle or my shotgun and don't have to do anything.
Yeah, that's right.
And we did that when we were kids going to school. We carried our rifles and shotguns because right after school we'd go hunting.
Yeah, no, I mean, look, I think, and, you know, I was up here. I made this argument. You weren't here yet when we had the debate. I think it was 2013 about allowing for restaurant carry. Senator from Florence was having that conversation with Senator from Spartanburg earlier, but it was a pretty contentious fight that we had at the time, and you would have thought that that the apocalypse was coming, right? If we allow people to carry their weapon into Applebee's, but I made the argument at the time, these are the good guys. We know they're the good guys. These are the guys that have done the training class. We've got to done the background checks. There's no reason not to trust these people. They are not getting in trouble. I mean, the senator from Richland earlier was talking about some people who've had their permits revoked. I mean, he identifies about 6 or 7 people out of hundreds of thousands who have permits right now. Over 400,000. I mean, yeah, you're going to have that sometime, and then you got to have a provision to revoke in that situation. But those people, those are the good guys, right? And I think, like, I would expand lots of different things for those people because they have proven themselves law-abiding and trustworthy. Like, I don't think we should have nearly as many restrictions as what we have for those guys because they've they've shown that they are responsible.
So what if it's just a certificate of training, and they could have got it from a host of things? They could have got it from a hunting class. They could sign an affidavit that their daddies taught them how to hold a gun, or they had a prior CWP, or a host of ways to get at it as long as that training is there. It's an individual right, and as most of us, thank God we were born here and trained by our fathers, we know how to hold and possess and carry a weapon, and also to be able to sustain ourselves in the event, God forbid, we ever get into a position where we have to kill our own food to, sustain ourselves. Hopefully that'll never happen. But again, our constitutional forefathers had the insight that we needed to be able to do this. And so I don't think there should be any restrictions on it other than what you're talking about is the limited acknowledgement of training, or to make sure that that person knows how to use that weapon. Other than that, there should be no limitations on it.
Yeah, no, I'm with you. I mean, what they were trying to do was to ensure that the crown wasn't going to take the weapons away.
That's right.
Or that a tyrannical government wasn't going to take their weapons away. It wasn't an effort to say that you should. It wasn't an effort to say that there should be no training, and that anybody and everybody, no matter your criminal history or mental stability, should be able to have them. What that amendment says is that you've got the right to keep and bear. They didn't want the government to be able to take them away, because if they took them away, their fear was that's the way you're going to prevent the militia, right? That's the way you're going to do it. They're not going to prevent the militia by outlawing the militia. What they would do, their fear was you prevent the militia from organizing by telling people that they can't have weapons to begin with. Right. And so what we've been seeing from the Supreme Court in recent years is you can't do that. Now, as Justice Scalia said, there are a number of limitations, restrictions that you can have in place to ensure proper use, but you can't tell people they can't have.
Do you agree it's both an individual right, every individual has that individual right, as well it is a collective right?
Yes.
As the senator from Lawrence has indicated.
Yes.
So it's both. I mean, we don't restrict it, it's both.
Yes.
And parts of it, and together we can throw off a tyrannical government, whereas one or two of us may not be able to do that.
Right.
Thank you.
Senator from Lawrence, purpose to rise.
I'd like to be heard on the amendment.
Recognized, sir. Please give the senator from Lawrence your attention. Senator Verdon.
Thank you, Mr. President, members of the Senate. This debate boils down to defining and determining preconditions. Preconditions for exercising what I've heard as inalienable rights, God-given rights, rights that are precursors at the state level to federal rights, rights that trump restriction at local, state, federal level. But it still boils down to preconditions. I view this in my mind, this whole question of the Second Amendment of the Constitution, in my mind, as a whole. Now, it's not a hole we just stumbled along and came upon and fell in it. It's a hole that has been dug over 250 years of history. I'm like probably everyone in here, I love history. Matter of fact, I've told several of you about the books I'm reading and how I've got to pass them along to you. In the sense of martial conflict, this is a bloody country. Painful, horrible. The context that this Constitution, this compact was, I love when the senator from Charleston starts detailing the Federalist Papers and the history of what it took to get this compact ratified in the first place. The fierceness at which those patriots, sons of patriots, there's not a lot of time between 1782 and 1787 when they convened again to try to perfect the Articles of Confederation. A couple of years in the ratification process. That's not far removed from some of the most unthinkable conflict that's ever transpired on this continent. Carry it forward just a few short decades. The one we talk about without telling you what war it was, we just talk about the war. I've got a book right now I've got to share with the senator from Beaufort because it's all about his part of the world. Senator from Charleston, you too. It's the history of the Charleston and Savannah Railroad. It's called Vital Rails, written by a pediatrician senator from Florence, who, as an undergraduate at Furman, was consumed with his families and everything that they had done, sweat, blood, toil, tears, to see the country from the colonial era to its founding and then on through antebellum period. Anyway, the professor said, well, son, you're telling me a lot about the Ravenels and the Manigos and the UGs and these people. What about that family? That is a common name. He said, well, they weren't aristocrats. They were just hard-working railroad people. After 10 years, he ended up writing the definitive work on the Charleston and Savannah Railroad, and it's all about Pocatello to Telefinny to Salkehatchie to Adams Run to all those places that those senators love. The hole was dug incrementally, senators. It was dug by our forefathers. It started out as a little crevice, then a ditch, and a little deeper. As each successive generation enjoyed the benefits and privileges of standing on the shoulders of their forebears, they got a little less committed and enjoyed less fealty than the previous generation to the actual covenant that binds us together. To the point that we've seen the need to start trying to fill in the hole. So just as the hole was incrementally dug, we've been trying to incrementally fill the hole back in to bring respect, deference, and honor to the constitutional principle. So the way I see this debate, senators, is that we have got up about chest level. We've had spirited debates through the years where we've understood where we stand as it relates to trying to find this balance. We've had significant court decisions that helped us along the way as we try to refine our statutes. But we found ourselves in uncertain times. As a state, we've been subjected to rhetoric from Washington that's unnerving. I really appreciate the contributions of the senator from Richland, Senator Harpootlian, but he built a straw man argument yesterday talking about, when have you heard our president talk about actually confiscating the guns? It's everything that transpires around the confiscation issue and precedes the confiscation that's taking place all across this globe in countries that enjoy less freedom and less commitment to the individual responsibilities of freedom that scare me, that have come from the lips of the president and many in his administration. No, I haven't heard the president say he's sending out somebody tomorrow to get the guns. Nonetheless, I shudder at all the utterances otherwise that come relating to the Second Amendment. That's the reason we're at a point where we're trying to determine if we're going to hop out of the hole now or keep just filling it in so that one day maybe we step out of the hole. And I think there's concerns here that we may not ever get the opportunity to just take an easy step out. Because society has not evolved that way to give us those comforts. Therefore, we're contemplating what really is a Herculean leap. A flat-footed stance to get up on top of the ground. That's what the senator's amendment from Spartanburg accomplishes. It puts us right back where the people who suffered more, endured more, were more prescient than we are, established us. I tell you, Senator from McCormick and Senator from Edgefield, I appreciate the dialogue y'all were having as it was relating to the difference between a permit or a certificate. But let me just say, the question is still the point of a precondition. That's not the way a free society treats its citizens, with the presumption that you're not qualified first. A law-abiding citizens of this country or this state that is acting in good faith and good communion with me and my community, and I'll make that community as large as this state, and they've not transgressed what we've all agreed upon in any way whatsoever, I put my confidence in that person based on the covenant that we keep with each other until they break the covenant. I don't want them, and I don't want somebody in Washington judging me and my ability to keep a covenant if I've given no indication that I am a covenant breaker. Now, if you're a covenant breaker, you don't qualify. And the statutes cover that class of individuals in society. So yeah, it's a tough thing to do with narrow runway to make this final approach and step out of this hole. I'm already here on more points than, well, I keep looking over here to where my really good friend sits. And I've told constituents that, and that'd be the senator from Edgefield, and I've told my constituents, don't think that your representative voice in that body does not enjoy the ability to reason, postulate, argue, debate, and have the ability to bear influence. Because I think each and every one of you has done that, and I can go to every single one of you, even those that I've just known for less than a year, and I can give some example of where you've done that for me. So that's the reason I keep looking over here to the senator from Edgefield's seat. He's been our leader. I think he's led us well. But we are at severe loggerheads on this matter if we try to finesse this matter and find some kind of sweet spot where we can maintain the preconditional permission. I think he's moved a lot. I appreciate him saying he didn't have to have the permit. I want to hear him say, I want to hear us all say, even if some of us have to say it begrudgingly, I want to see this body take that step. Now, if we fall way short on that vote count, I'll consider that the arguments were made and the time was well spent, because we don't know if we'll get back on this issue or anything tangential, quite honestly. There's a lot before us. But let me just quickly hit 2 or 3 other things that the senator from Edgefield had to say. As it relates to North Carolina and the stringency of their precondition, I can't take any solace and consolation that ours is bad. I can say thank God that we're not starting at that point where North Carolina is. But that in and of itself is of little consolation. Comparisons to the First Amendment, free speech, same principle. If your exercise of your tongue creates a demonstrable and identifiable harm to your neighbor, there are consequences. And on to back to Justice Antonin Scalia and Heller. The example was D.C. and an order for D.C. to exercise what happened in D.C. The context is D.C. and their permitting process. If the context had been South Carolina, if the context had been a mountain or western state, and there had been the infringement, the high court's order would have been to comply with the prevailing state statutes. So I've already made my points that I don't believe conflating well-regulated militia with well-regulated firearm holder holds up. I believe that we have an opportunity within the context of our existing statutes to step up out of this hole, embrace the Constitution, embrace the goodwill of the law-abiding citizenry that you live with, and in any other facet of daily intercourse. Enjoy the peace and tranquility that is more and more unique to this state, because I think predicated on the fact that we still embrace and honor our covenants. Thank you.
Senator from Charleston, Senator Campson, what purpose do you rise?
I'd like to be heard.
You're recognized, sir. Please give the senator from Charleston your attention. Senator Campson.
Thank you, Mr. President, and Senator from Lawrence, Senator from Edgefield. I appreciate your reference back to history in our founding era. This is exactly the kind of debate that we should have in determining issues such as this that are grounded in constitutional provisions and rights. And Senator from Lawrence, did you know that that Charleston-Savannah Railroad is I have a very keen interest in it. And there's a great book written about that railroad and the defense of it. The defense of it was an essential element in the Confederate defense of the coast of South Carolina, because they concluded, Robert E. Lee concluded, he came down here, did a recon mission. You can't defend the Barrier Islands, but you got to defend the railroad, because we need to be able to move troops north and south wherever there are gunboat incursions, federal gunboat incursions. And that's why when you look at the history of South Carolina in the Civil War, you see a series of gunboat incursions. Now, we had a real extensive assault on Fort Sumter, but everywhere else along the coast, it was gunboat incursions. We had it in the Stono River. We had the Combahee River Raid on the Combahee River, where Harriet Tubman helped organize a raid that freed over 700 slaves. And they took them to Tabernacle Baptist Church in Beaufort, and from there they dispersed to other places around the coast east of the railroad that federal troops largely controlled. And I have a friend whose great-great-grandmother, he has a photograph of her, that she was freed in that raid and was moved. She ended up going to Edisto Island, which the senator from Newberry has some property there, and lived the rest of her life as a freed woman after that Combahee River raid. But there was a raid on the Ashepoo River too, Chapman's Fort. There were 4 Medal of Honors awarded in that one battle, where a federal gunboat came up to take out the railroad, the Charleston-Savannah Railroad, on the Ashepoo River. And they were engaged, a Confederate battery engaged the boat. It ran aground, the gunboat, it ran aground, and federal troops, including African-American troops, were involved in saving, going back and across the river multiple times under great cannon and rifle fire, musket fire, and saved, and 4 Medal of Honors were awarded, more than any in the history of this nation, in that one battle right there on the Ashepoo River, down Bennett's Point Road. So I really enjoy that history, and there's a lot of, so I want to talk about a little bit of history when it comes to the Second Amendment. And I'm going to start with one of the Federalist Papers, Federalist 46. And in Federalist 46, it's really interesting. You hear me, we talk about federalism a lot, and the separation of powers and federalism, diffusing political power, not concentrating it. That is very important. That was the framers' vision. But it's really, this debate is the first time I really focused on Federalist 46, and what Madison says there, he says that really what he says is not just federalism and the separation of powers, but it's armed citizens, really, is what he says. He says armed citizens and federalism combined are the barrier against the enterprises of ambition, is what he says, basically. And it's the first time I'd really focused on that concept, stated that explicitly, but I'll read the words to you in Federalist 46. Besides the advantage of being armed, which the Americans possess over peoples of almost every other nation, the existence of subordinate governments to which the people are attached, that's the concept of federalism. We're attached to our local government. The states are focused on the state government. They're protective of state powers, and therefore that keeps federal power in check. More insurmountable than any which a simple government of any form can admit. And so really what he's saying is it's federalism and it's the armed citizens that are the great barrier against the enterprises of ambition. Now, what is the enterprises of ambition? What is he talking about? Well, if you go to Federalist 51, he talks about the separation of powers and federalism keeping political ambition in check. And is the senator from Richland, Senator Harpootlian, he's not in the chamber. I was going to humor him. I humored him in a Judiciary Committee meeting the other day. But in Federalist 51, Madison is saying that by creating federal government, state government, by creating 3 branches of government at each level, political ambition keeps political ambition in check. The ambition of the federal government is thwarted by the powers, ambition of the state government. The powers of the legislative branch thwarted by the powers of the executive or the judicial branch. And so it's this constant dynamic of 3 branches of government and 2 levels of government constantly jockeying and jousting for power. And so really they harnessed political ambition to keep political ambition in check is what they did. It's brilliant. You harness the desire of power to keep others from accumulating too much power. And Senator Harpootlian and I was wondering where you were, because you were humored when I mentioned the analogy of what's a good description of the separation of powers doctrine, and that's the three crabs in a bucket analogy. And you laughed at me. I think it was because you were intrigued. Maybe you thought it was with me. Okay, that's good to know, laughing with me. And it's a great analogy because that's really what the framers intended. The question is, what happens when you put three crabs in a bucket and one starts to crawl out? The other two grab them and hold them down and keep them from crawling out. And so, crab cakes? Okay. So that's the political ambition being kept in check because of the structure of government that Madison's talking about in Federalist 46. But he adds to that armed citizenry, because no other nations had armed citizens. So we're talking about a very important right, is the point I want to make. It is a very important right that distinguishes us from other nations, almost every other nation on earth, even to this day. So it's a very important right, and I understand the passion in which people approach it and deal with it, because it is a very, very important right. And I'll say this, personally, I am an avid hunter. I've been one since my birth almost. I dare say, except for the senator from Berkeley who was in law enforcement and he carried a gun every day. I probably have carried guns and handled guns more than anyone in the chamber, just for years of hunting. And Senator from Georgetown is similar, but I'm older than you, so I probably logged more hours. But so I'm a the First Amendment is very important. The right to bear arms is extremely important to me. It's a lifestyle to me. And it's not just hunting, it's managing property. You know, when you're out there managing property, you need to deal with wild boars and hogs on the property you need to deal with because they tear it up so bad. So I'm someone who exercises my Second Amendment rights frequently and very competently. But yet, I do believe that there should be a background check and training before you carry a weapon, not in the woods, but in urban areas. I mean, I carry handguns all the time on my hip when I'm riding on the tractor. I can't carry a long gun. I carry a handgun in case I run into a pig or a snake or... I believe that because one reason I have used weapons all my life, and I'm around people that use weapons, and everyone I'm around, my friends, they are very competent in handling firearms. And so when I see people, when I took my concealed weapons course, people have alluded to someone who took the course, and there was a student in the course who didn't know which end the bullet came out of. That was me who told you that. I actually saw that in a concealed weapon when I took my concealed weapons course many years ago. Literally did not know that. And thank God she was operating a revolver, because a semi-automatic handgun is much more difficult for someone to safely operate when they're that much of a novice. And so that really stuck in my mind. Wait a second, there really are, and I'd really never encountered someone like that, because everyone I've hung around, everyone I grew up with, they were very competent handling firearms. And it really, and then you go on the range and you shoot during the concealed weapons permit, and it's a piece of cake. I mean, the targets they're 20 feet or 25 feet, I forget, 20 or 25 feet. And these people are shooting at that distance with a handgun, and they're missing the target by 10 feet, 25 feet away. The same people who don't know which end the gun the bullet comes out, they're missing it by 10 feet. And I'd never experienced something like that, because that's not the culture I came from, but that was about 25% to 30% of the people in that class. And I've never been scared of being around people handling firearms in my life. And I wasn't really scared, but I was cautious. I kept my eye on I kept my eye on them. I said, this is a crowd that I'm not familiar with. Because everyone I knew, we grew up in the woods and the waters and hunting and fishing, and it was we just grew up that way. We knew what we were doing. And then my service, I really haven't dealt with firearms law in my law practice in any way, but I have in my service in the legislature. I've dealt with it quite a bit. And one of the biggest and most important aspects of going through the training for CWP is exposure to our firearms statutes. And I can tell you, we have some good lawyers in this chamber who have dealt with these firearm statutes, and they are not easy to really understand. I know lawyers argue about how many molecules on the head of a needle. So we can focus on details, but really, this is not just about focusing on details. Like the Castle Doctrine, where you have the right to use lethal force to defend you if someone is breaking into your house. And there are several Supreme Court cases who have dealt with that. That law can change. The status of that law can change over time. Even lawyers have a difficulty keeping up with it. The Stand Your Ground doctrine, that one's really a bit obtuse of when you can really stand your ground and use lethal force and when you can't. I would dare say that most people who have never been through training and aren't lawyers, they don't even know what stand your ground is. They don't even know what the Castle Doctrine is that lets you use lethal force if someone is breaking into your home. The idea being a man or a woman's home is their castle. That's why it's called the Castle Doctrine. The Castle Doctrine, we passed a law that, since I took the concealed weapons course, we passed a law permitting the Castle Doctrine to be used in defending your automobile. Now, I know that because I'm served in the legislature, but if I weren't serving in the legislature, even since I got my concealed weapons permit, I may not know that. Even as a lawyer, I may not, because I don't practice in that area. Then you get to a very difficult field, and that's citizen's arrest. Citizen's arrest law. I was talking to the senator from Richland, Senator Harpootlian, about he dealt with this code section in a case. But we've got a law on the books. I've got an amendment to deal with this law, actually, in part to repeal it, because we have other we have two citizens arrest statutes, but one of them permits you to use lethal force at night, not during the daytime, at night, if a citizen thinks someone has just committed a felony. That's it. You remember the Audman Aubrey incident in Georgia? In February of 2020, he was jogging in the neighborhood in Georgia, and he's an African American, and a father and a son, they shoot him because I'm not sure if he committed a felony or not. I mean, I don't think he did, but it was that statute that they used as a defense. And so if you're going to carry I mean, if you're going to carry and never use, maybe it doesn't matter, but if you're going to carry with really an intent to use it when you need to use it, you need to know the law in this area. And really, that's one of the most important aspects of the training is the law. And of course, we don't want someone who's ineligible. We don't want someone who's ineligible because they're a convicted felon or they're subject to a protective order issued by a court. They're not supposed to be carrying guns, and so you have to have a background check for that. Now, it seems to, in the last bit of give and take between the senator from Edgefield and others, it seems like maybe there's just concern about having a, quote, permit. I mean, you could just require, you got to have a background check within no older than 5 years, and you've got to have your card that says I completed a concealed weapons permit course. But we take the permit out of it if it makes it easier for you to accept. But those are reasons why, although I am a big exerciser of Second Amendment rights, very few people in this state probably exercise it more than me, and thinks it's more important than me. I think it's really important because of my love for history and my love for the framers. And I look at Madison and Federalist 46, and he's saying it's not just the separation of powers, it's not just federalism, it's also your right to bear arms that keeps political ambition in check, that keeps government becoming oppressive. That's true. And so it's really important to me, but I just think that if you're going to do this, and to those who say you shouldn't permit open carry, I mean, I understand that the concerns that people express, but I also understand this. There are 45 states that permit it, including our neighboring states. I've traveled this country a good bit, and I don't think people ought to be brandishing guns on their hip. I mean, I wouldn't want to do it. I think it's kind of in your face in a way. But the other thing, I mean, if you want to carry, like if it's summertime and you want to carry, you may not carry a weapon of the same, I wouldn't carry the same weapon concealed. I have a concealed weapons permit. I can carry concealed weapons. I rarely do, but sometimes I do. But if it's the summertime, frankly, I can't carry the weapon I want to carry. I got to carry a smaller gun, a gun less lethal. And that's what, if you got to use one, you want one that's more lethal. So I travel the country. I have never seen anyone carrying a gun on their hip, a handgun. Never seen it, except in the woods. I mean, I see it in the woods, hunting all the time, but I've never seen it in any urban setting. And yet it's permitted in 45 states. It's permitted in our neighboring states. And so I'm not sure that all the parade of horribles that we hear about are really going to happen, because they really haven't happened in those other 45 states. And experience, human experience, is the greatest tutor of what has happened is likely what's going to happen in the future. So as a very strong Second Amendment supporter and proponent, someone who even believes it's, like our framers believed, it's even an important aspect of keeping government in check. That's James Madison speaking, not me. I still think it's important to have the training, to have the background check. And I think when law enforcement enters a situation and realizes, like I've been stopped in my truck, and if I have a pistol in my console, I'll tell law enforcement, I have a weapon and I'm a concealed carry permit, and it's just their demeanor changes completely. They know you're one of the good guys. They know you're someone you can trust. I think many of you have had that happen too, that they respect that. And so if you're going to carry open or concealed, that's an important aspect. And it's a close call, but on balance, that's where I come down. And just wanted to make that comment. Thank you.
Senator from Darlington, Senator from Lloyd, what purpose do you rise?
Just to be heard briefly. Mr. President, I want to thank the senator from Spartanburg, Senator Martin, the senator from Edgefield, Senator Massey, the senator from Lawrence, Senator Verdon, and the senator from Charleston, Senator DeCamps, for some very thoughtful comments and consideration. I was just talking to the senator from Berkeley and the senator from Spartanburg, and was telling about how this happened in the Senate. And so what they were saying about talking about the discussion, and this is how the Senate operates. And I think that what happens now is that we heard from two sides opposing on different sides of the issue. And so at this point in time, with all due respect for us, to move to respectfully table the amendment. Ask for a roll call.
Roll call has been requested. 5 members second the call. 5 members do. It's too late. Ring the bell. Meeting clerk will call the roll.
Mr. Adams? No. Mr. Alexander? No. Mr. Allen? Aye. Mr. Bennett? Aye. Mr. Campson? Aye. Mr. Cash? No. Mr. Clymer? No. Mr. Corbin? No. Mr. Cromer? No. Mr. Davis? No. Mr. Fanning? Aye. Mr. Gambrell? No. Mr. Garrett? No. Mr. Goldfinch? Not voting. Mr. Grooms? No. Mrs. Gustafson? Not voting. Mr. Harpootlian? Aye. Mr. Hembry? Aye. Mr. Hutto? Aye. Mr. Jackson? Aye. Mr. Kevin Johnson? Aye. Mr. Michael Johnson? Aye. Mr. Kimbrell? No. Mr. Kempson? Aye. Mr. Leatherman? Aye. Mr. Loftus? Mr. Loftus not voting? Mr. Malloy? Aye. Mr. Martin? No. Mr. Massey? Aye. Mrs. Matthews? Aye. Mr. McElveen? Aye. Mr. McLeod? Aye. Mr. Peeler?
No.
No. Mr. Rankin? Aye. Mr. Rice? No. Mr. Sabb? Mr. Sabb not voting. Mr. Scott votes aye. Mrs. Sin? Mrs. Sin not voting. Mr. Setchler? Aye. Mrs. Shealy? No. Mr. Stevens? Aye. Mr. Talley? No. Mr. Turner? No. Mr. Verdon? No. Mr. Williams? Aye. Mr. Young? No.
Have all senators voted? Senator Loftus votes no. Senator Sabb votes aye. Senator Goldfinch votes no. Have all senators voted? Senator Gustafson votes aye. Senator Sin votes aye. Last call. Have all senators voted? Polls will close. Clerk will tabulate. By a vote of 25 to 21, the amendment is tabled. Clerk will publish the next amendment.
Next amendment is Amendment Number 5 by Senator Massey. Amends the bill, adds a new section.
Senator from Richland, Senator Jackson, what purpose do you rise?
Mr. President, I'd like to ask unanimous consent for leave until tomorrow at 11 a.m.
There's an objection. Being none, so ordered. Senator from Edgeville.
Mr. President,
Let me get some attention. Senate, please come to order. Senator Massey. Senator from Spartanburg, Senator Martin, what purpose do you rise?
Unanimous consent with the senator from Edgefield holding the floor. If I have any more amendments on the desk, I would like to withdraw them.
Is there objection? Hearing none, so ordered. Senator Massey.
Thank you. Mr. President.
Senator from Colleton. Senator Matthews, what purpose do you rise?
To ask the parliamentary inquiry.
State your inquiry.
How many amendments are presently on the desk?
We'll count.
Thank you, Mr. President.
Senator from Edgefield. Senator from Florence. Senator Leatherman, what purpose do you rise?
Request leave till 11 o'clock tomorrow.
Is there objection? Hearing none, so ordered. Senator Massey.
Mr. President, this amendment, and I briefly mentioned this one when I was up here earlier, but this one makes the permit process no cost. So it strikes that by statute there's a $50 fee that must be paid to SLED. This strikes that. It also allows for a refundable income tax credit up to $100 for the training class, which would cover, my understanding, would cover the training class across the state. So it would make the whole process, free. Now, I'll tell you this because I've talked to SLED about the number of permits that they issue for first time and also for repeats. I think, Mr. Chairman, I think this would probably cost about $5.5 million at SLED in order to do that. That $50 fee generates about $5.5 million from what I've heard. I think it would likely, looking at the number of first-time permits that are issued, it's probably cost about another $5.5 million for the refundable tax credit. So I think we're looking at about $11 million. But as I said earlier, look, we don't charge people to vote, to register to vote. And so I don't think we ought to charge people for this either. So that's what the amendment is.
Senator from Oconee, Senator Alexander, what purpose do you rise?
See if the senator would yield for a question.
Of course.
So you're saying that under your amendment that it would be you're not charging them the $50 fee, basically, is that?
Not charging them the $50 fee that goes to SLED, but also allowing them to be reimbursed for their training costs.
So, and how did you come up with that amount of $5 million? If you got over 400,000,
because they're not
every year.
They're not issuing those every year.
Right. So it's a yearly cost.
When I looked at, if I could,
let me get something.
I better quit doing that.
So I got a list of permits, new and
pre-inquiry.
State your inquiry, sir.
Abandon the podium and go to his desk.
I did.
He did.
And I would object.
And someone, and he came back. If you'd have come up while he was over there, I'd recognize you. It's a teachable moment.
It is a teachable moment. So scurrying is important. Scurrying back.
Mr. President, to the Senator from Oconee's question, so I got a list from SLED of the number of permits that they've issued every year for the last 10 years.
Okay.
And we looked at the new issuances and the renewals. Because right now, the requirement is that there's renewals every 5 years. So you don't have those every year.
That's right.
Right. The new numbers are important because that also tells you the training numbers, because you got to have the training for the new issuances only. All right, last year, in 2020, it was the largest number that they've done in the last 10 years. And that was just over 104,000 total permits, both new and renewals. So $50 is $5.5 million for that. There were just over 55,000 new permits last year. That's the largest number. I'll tell you, that's double what we had from the year before. And a good bit higher than any other year. But if we assume it's $55,000 every year, if we allow them a $100 refundable tax credit, you're looking at another $5.5 million. So that's how I got my two numbers.
Thank you, sir.
Senator from Charleston, Senator Kempson, what purpose do you rise?
Senator Yield.
Yes, sir. You for a question? Yes, sir.
Senator, I just want to make sure I understand you are advocating that SLED no longer is able to collect the $50 fee for the CWP application process. Is that correct?
That's right.
And by your count, how much is that per year for SLED?
Roughly $5.5 million. Well, actually, it's probably less than that on a typical year. I used last year's number. Last year's numbers were higher than any. Last year, they issued more permits than in any year in the previous 10. So if you use last year's number, though, it's $5.5 million.
And Senator, would you agree that SLED uses these fees? And I don't know. I assume you had conversations with SLED about the impact of a loss of. And we're just talking about one element because there's another element to your amendment. But just let's talk about the $5 million for a moment. What impact, if any, is that to the SLED budget and to administer this CWP process?
SLED cannot absorb that. So my hope would be if we adopt this and we pass this bill with that in there, then what I would do, and hopefully others would join me, is I would go to Chairman Smith and say, he's got a good bit of money to play with. I would say, we need $11 million in order to make that happen.
So you got a plan to replace the money.
Yes.
Now, the next element of this bill is a tax credit for people who've paid for training. Is that correct?
That's right.
So we're going to give these folks a tax credit to get their money back.
If we are requiring people to have a training course in order to exercise an individual right that's guaranteed, then I think it makes sense that you reimburse them for that.
Yeah, and there's been a lot of debate about an individual right guaranteed. I find, did you know, your earlier comments with respect to the Heller decision very persuasive. And I think you made a pretty good argument that the right to bear arms is not without some limitation as recognized by the seminal court opinions before Heller, and even Heller places limitations on the Second Amendment.
Justice Scalia said that nothing in that opinion should be construed to mean that you can't prevent felons or mentally ill. So that was Justice Scalia's words. Those weren't mine. But he also said, the holding of the opinion was that the Second Amendment guarantees an individual right to keep and bear arms. But then he went on to say there are limitations. Those are Scalia's words.
And so your amendment, and I'm characterizing this, I'm not trying to put words in your mouth, but you want to make this process, since some believe this is an impediment to what they view as a unlimited right to bear arms. You want to make this process easier for those who have that view.
Well, I think, look, I don't think any of us would support, maybe this is the way that it used to be, we outlawed it with a constitutional amendment, but I don't think any of us would support requiring people to pay a fee to register to vote.
See, Senator, I don't believe this is akin to registering to vote.
They're both constitutionally protected.
It's a good argument, but I don't believe that this is, you and I disagree about that. But I understand your position and what you're trying to do. I'm glad to know you having a plan to replace the funding for SLED.
Oh, yeah, absolutely. Yes, sir.
Senator from Richland, Senator Scott, what purpose do you have?
Mr. President, would the Senator yield for a couple of questions?
He will.
Senator, are you saying that we want to spend $11 million annually for those who want to get CWPs? And I guess also that would also include renewals, one time to renew. Am I understanding you to say that?
I think that's the high water mark.
Yeah, but
based on if you look at the 10-year experience, of the number of first-time and renewal permits that were issued, I think 11 million would be the high mark.
But is that the best use of taxpayers' dollars, given all the other needs we have out here? Colleges and universities asking us for deferred maintenance, K-12 asking us for funding to build schools, state agencies asking us for upgrade. SLED's in my district, and right now we're spending a ton of money building a new lab at SLED, and there's so many other needs. Is that the best?
I think
best
paying for
use
this,
of state funds?
I think this would rank. It would rank high on the priority list for me.
Just share with me how you got to and your ranking system, because to me, if you want a weapon, you buy a weapon. You want to be able to carry a weapon, you pay the $50 and you get the fees.
Well, Senator, let me ask the question this way: if you want to vote, you go stand in line. But if you want to vote, do you have to pay $50 to register to vote?
The voting is a whole lot different between me going to a class, getting training and certification. If you're an attorney, you take continuous education courses, you pay to take the exam. If you're in real estate,
but working as an attorney is not a constitutional right.
If you're in the real estate business, you pay to get your license.
That's not a constitutional right.
So can you give me another example of any other thing that we have for license that we spend $11 million on?
Well, I think the best example I can give you is voting, because it too is a protected constitutional right, and we don't charge people for that right.
You and I totally disagree with that. Especially we don't spend $11 million a year for voting. That's a lot of money.
Well, I think we do.
Well, I like to see that. Not at this state budget. Not $11 million for folk to vote. I'm just concerned about spending $11 million. I mean, we've got so many other needs other than trying to make sure somebody get a CWP. I mean, that's not making a whole lot of good sense. Terrible waste of taxpayers' dollars. When I just saw you 2 weeks ago stand up there and talk about those items that were in the budget that went back to people's districts.
Oh, this is a whole lot higher priority than that.
I don't think so. I mean,
this isn't even close.
You know what? You decide it's a priority based upon somebody having the capability to carry a gun, and if they really want to carry a gun, they can pay the $50.
Well, so look, I think it's a high priority, so I make the case, and people get to vote.
Okay. Well, I just want you to know, in making your case, I'm just shocked. I'm shocked at you, of all people, talking about wasting $11 million a year in taxpayers' dollars. You want to do anything? Take the $11 million, get some bonds, and let's build some schools. Thank you so much.
From Richland, Senator McLeod, what purpose do you rise?
Wanted to be heard on the amendment.
Johnny King?
When the senator from Edgefield is done.
Senator from Richland, Senator Harpootlian, what purpose do you rise?
Would the senator yield to a question or two?
He will.
So, as I understand it, you concede you're cutting SLED's budget by $11 million a year?
No.
You're not.
The SLED portion would cost about 5.5 at the high water mark. But what my plan would be to try to include that money in the budget before it passes this year.
That's a great plan. But if your plan doesn't work, and we pass this legislation, you concede you're going to cut SLED's budget by just $5 million.
I think if we pass, so the House is going through the whole committee process on the budget. Right? They're not going to vote on the budget until June the 8th. If this passes, it's going to happen before June the 8th.
Sure.
And I suspect that the House would like this idea, but if it passes, then I think the House will fund it. If it doesn't pass, we don't have to worry about it. But the House isn't going to pass this and put this burden on SLED.
And, you're a great prognosticator, predicting what the House, who right over there right now is debating the firing squad amendment, which I think I authored.
That's your fault.
No, I take credit. I'm not ashamed at all of that. And I think a majority of this body agreed with me. So this is a wish thing. You think they may, you can't tell me they're going to do it with certainty. You can't tell me the House of Representatives is going to do anything with certainty.
No, that's right, but I'll tell you this. If the House doesn't fund it, they also won't pass it this way.
you think.
No, I mean, they're not going to put that.
And Senator Massey, you've been here a lot longer than I have, but you cannot say with certainty they will do that, with certainty.
Senator, I can't say with certainty that a comment's not going to slam into the State House in 30 seconds.
Okay, so you would concede that there is, if this passes, at least for some period of time, it will instruct SLED to take a $5 million cut to their budget. If the House doesn't do what your crystal ball says it will do.
If we pass this and the House passes this and this becomes law and the House doesn't put money in the budget and we don't insist on that in the conference committee, and so we pass a budget, both sides pass a budget without that, having passed this, then it would result in a $5.5 million cut to SLED.
It would be an unfunded mandate in effect.
Well, it's a state agency, but...
Well, but I mean a mandate to a state agency to take a $5 million cut to do the same job they've been doing that they needed the $5 million to do.
But I would hope that you would concede that that's less likely.
I'm sorry. I mean, when I'm advising my clients of what's likely and not likely, I've never relied on what the legislature was going to do, because who knows?
But it takes legislative action to pass this.
Well, and in a moment, we're going to decide whether this is passed. And the question is, I guess what you would concede with me, this has a physical impact on a state agency.
Two, yeah.
Okay, 2 state agencies. Then I would, what am I calling it? What's it called? Point of order, Mr. President.
State your point, sir.
My point is that under Rule 24, this matter is not germane, if I might speak to that point for just a moment.
You may.
So the resolution, the bill, is titled to amend Section 2331-210 Code of Laws relating to the issuance of concealed weapon permits so as to enact the Open Carry with Training Act by revising the definition of the term concealable weapon to allow a permit holder to carry a concealable weapon openly on his person, and to amend 162320 relating to the carrying of a handgun so as to provide a person who possesses a concealed weapon permit may carry it openly on or about his person in a vehicle. Nothing about money, nothing about appropriations, nothing about cutting SLED's budget, nothing about an unfunded mandate, which, and obviously Senator Massey is more astute on these matters than I am, but he cannot, if we pass this right now and pass this bill, he's betting that the House behaves in a rational way. I was just over there a minute ago. I can tell you that ain't a good bet. So I would ask the president to rule, the chair to rule, that this is not germane to this bill. Now, that's not to say that during the negotiations on the budget bill that this might be dealt with in some sort of committee, or you might go over there right now and ask them to do away with that funding for SLED, but not in this bill. Thank you.
Mr. President, could I be heard?
Yes, please.
On the point?
You may.
Mr. President, the bill deals with open carry with training. The only way under this bill that you could carry openly would be with a permit. The permit, you got to pay for it. So the only way that you could do any of this stuff is to pay for the permit. And what my amendment does is says that you wouldn't have to pay for that part of it. That is a natural and logical extension of what we're talking about in the bill, because you can't do anything in the bill without that. The second part of of my amendment deals with the refundable tax credit for training. That is, if you look at Section 6 of the bill, talks about, that entire section is all about training and what you've got to do in order to get that training. This is a logical extension of that. So the bill, the premise of the bill is the permit. You can't get the permit without paying for it. So I would argue that this is more than germane.
Senator from Richland, I'm ready to rule. I'm ready to rule on your point.
You're ready to rule?
I am.
To hear it.
I sustain your point. But we'll read the next amendment. Senator from Spartanburg, Senator Martin, what purpose do you rise?
Could we just take a brief recess to allow that the senator from Richland won something and maybe take a little quick break? I object.
I'm glad you put it that way because I felt like I lost something. Senator from Clarendon.
I'm going to see if the senator will
Kevin
yield for
Johnson.
questions, but that's a moot point now. But I do have unanimous consent request.
State your request, sir.
I'd like to ask request for leave for myself until 11 o'clock tomorrow morning.
Is there an objection? Hearing none, so ordered. Senator from Lexington, Senator Shealy, what purpose do you rise?
Could I go, Mr. President, unanimous consent request, could I go to the well and make a brief announcement?
Is there an objection? Hearing none, so ordered. Senator Shealy.
I thought we needed to take a moment, if the senator from Orangeburg would listen to me for just a moment, but he won't. He might want to. Yesterday, no, I don't want him to leave because he needs to listen to me.
This is for you.
Yesterday, the senator from Orangeburg celebrated his 50th anniversary as an Eagle Scout. And earning the rank of Eagle Scout is no small feat. All of the troop meetings, campouts, merit badges, hours of service, and so much more. So we wanted to congratulate you on your achievement. We trust you carry the fine ideas of scouting in all that you do. Thank you for continuing to make a positive difference in your family, in your career, and your duties in scouting, and all you do for the Senate. And I have waited for 2 days to do this and for people to stop long enough so I could tell you. So congratulations to Senator Brad Hutto.
Congratulations. Congratulations. Senator from Richland, Senator Scott, what purpose do you
While
have?
we're taking a brief pause, can you go to the box and just read those matters if you have in the box? I know. We're going to be here for a while.
Senator from Lexington.
I restate that a different way. I ask unanimous consent to go to the box for the sole purpose of confirming a magistrate for Calhoun County on behalf of the two senators from Calhoun County.
Mr.
Is there an
President,
objection to the unanimous consent request?
Mr. President, unanimous consent while you're in the box to also read the Richland magistrates.
Is there an objection? Hearing none, so ordered.
Thank you.
Clerk will read.
I didn't know what you were doing.
Richland County Delegation reports favorable the appointment of the following Richland County magistrates: Ms. Paula Edwards of Columbia, Ms. Christina Pope of Columbia, Ms. Latanya B. Derrick of Columbia, Ms. Stephanie Bess of Blythewood,
Question is confirmation. All in favor say aye. Opposed, no. The ayes have it. Richlands are confirmed.
Calhoun County Delegation reported favorable appointment of a Calhoun County magistrate, Mr. Joseph David Teague Sr. of Swansea.
Question is confirmation. All in favor say aye. Opposed, no. The ayes have it. The magistrate's confirmed. Clerk will publish the next amendment.
Next amendment is Amendment Number 6 by Senator Alexander.
Senator from Oconee, Senator Alexander is recognized on the amendment. Please give the senator your attention.
Thank you, Mr. President. I'll be brief as I can be, as y'all will allow me to be, on this amendment. On more than one occasion, it's been brought to my attention that dealing with the judiciary, under the current law, it says that the following persons who possess a valid permit pursuant to this article may carry a concealed weapon anywhere within the state when carrying out their duties of the office. And that has been interpreted while they're in chambers or doing different things. So what this amendment does is strikes out when carrying out the duties of the office. So as long as they are active in the judiciary under those that are in the current law, would have that ability to be carrying at all times 24/7.
Let me get you some attention. Senate, please come to order. Please come to order. Take your conversations outside.
I move for the adoption of the amendment, Mr. Chairman.
Senator, you need to pay attention, ladies and gentlemen. Things like that happen. I bet you can't tell me what we're voting on. Senator from Newberry, Senator Cromer, what purpose do you rise?
Senator from Oconee, I misunderstood, I think, the way you phrased that, because on the amendment I see is it's scratched out when carrying out the duties of their office.
Well, that's what I said. I'm taking out that part because the way that's interpreted right now by the judiciary folks is that if they're not active, if they're off duty at night, like right now, if they finished up their court at 5 o'clock, or if they're not on call, if you've got a magistrate or a municipal judge.
So you're saying you want them to be able to carry it regardless?
As long as they are in an active status, and that's the way that it's listed now. So if they're active and they have gotten the valid permit pursuant to this article under the concealed weapons, they would be able to carry.
And that would mean pretty much, as long as, say, when we appoint a magistrate, he has the legal right to carry it for 4 years.
Well, then under that scenario, that would be correct.
Okay, Mr. President, unanimous consent to be added as a co-sponsor to his amendment.
Is there objection? Hearing none, so ordered. Senator from York, Senator Clymer, what purpose do you rise?
No.
Senator from Darlington, Senator Malloy.
I yield.
Senator,
I looked at your amendment and appreciate the same. Do you recall when we did the Circuit Defenders Act in 2007? You were part of it.
I remember us doing it. I don't remember all the details.
Right, and we were, and right at that point in time, and I'll try to give you the answer in the question, we decided to make the public defenders on par with the solicitors, put them in the same retirement system, that kind of thing. And so I just noticed in your amendment that it did not have the circuit public defenders in there because they are on the same par with the solicitors now.
Is
there a way we can add that maybe on third reading?
Possibly, because this is the actual ones that are in the law now. So what I didn't do was change who was listed in the category. So that is existing law. Only thing that I changed is giving them the ability to carry others. So,
and was that before or after the circuit defender law was passed?
That's a great question. I do not know the answer
and so,
to that.
And the other thing is that I just wanted to end up checking as we were trying to prepare for the end. There was some discussion, and I'm hesitant to end up saying this, and I want everybody to listen. Did you consider whether or not that they would add people of the General Assembly?
I did not. It had been brought to my attention by some in the judiciary, so that is the reason I focused on the judiciary.
Okay. I mean, I'm okay with what we have, but I think we get a chance to, we'll end up talking about it, but I want to see if we can just check overnight to see if we added the circuit defenders.
Thank you. Appreciate you bringing that to my attention. Move for adoption of the amendment.
Question is adoption of the amendment. All in favor say aye. Opposed, no. The ayes have it. The amendment's adopted. Yes. Clerk will publish the next amendment.
Next amendment is amendment number 7A by Senator Sin. Amendment number 7A amends the bill.
Senator from Charleston, Senator Sin, is recognized on their amendment. Please give the senator from Charleston your attention. Senator Sin.
Thank you. I have two amendments, this one and one following, both at the request of law enforcement. This particular amendment is being requested by the City of Charleston, and basically what it does is allow a municipality, county, or other political subdivision to temporarily restrict any lawful open carrying of a firearm at a public protest, demonstration, picket line, rally, fair, parade, festival, or other organized event. And any person or entity hosting those events must actually post.
Please, yes, ma'am. Just wait. When it gets quiet, you can get started, but it's not quiet yet. Just wait. Senator from Charleston.
Thank you very much. So basically I just read out what this bill does, but it would allow a municipality or a political subdivision to temporarily restrict firearms to certain events, such as, like I said, rallies, fairs, pickets, things of that nature. This was of particular interest to the City of Charleston Police Chief after all of the King Street riots. Those were not even permitted events, but yet you saw what happened. And even if we're going to have permitted events where we know we're going to have more than 45 people there, they want the ability to demand that at certain events, then they cannot openly carry or carry those firearms, and the entity putting on the event would have to publicly post that they cannot carry at that particular event, and then immediately after the conclusion of the event, it doesn't last any longer than whatever the period of time that the event occurs.
Senator from Greenville, Senator Corbin, what purpose do you rise?
Senator, you for a question?
Yes, sir.
Senator, correct me if I'm wrong, I couldn't get it pulled up on my computer here, but isn't this verbiage already in the bill? Is there a certain word or two in your amendment that's not in the bill?
Everything that's underlined here is not in the bill. So basically, I can read it again, but it's notwithstanding any other provision of law, a governing body, county, municipality, or other political subdivision may temporarily restrict or the otherwise lawful open carrying of a firearm at a public protest, demonstration, picket line, rally, fair, parade, festival, or other organized event. And again, the person that's getting the permit must post to let them know that only for the duration of that event, they're not allowed to openly carry.
Senator,
Senator from Macon, Senator Young, what purpose do you rise?
I want to ask the senator from Charleston a question.
You here for a question?
Yes, sir.
She will.
Senator, it looks like some portions of this amendment are actually in the version of this bill that came out of the subcommittee, but some are not. It looks like, do you know, it looks like the section A of your amendment would be new. Is that right?
My understanding, and we've got Mr. Moffitt right here, but my understanding is what is underlined is what is the new.
I think B,
which is B and C.
B on what on your amendment is A in the actual bill from the House, and B in the bill from the House is C on your amendment.
I think my next would be, where did Mr. President go? I lost him. Hey, while they're clearing this up, would it be helpful to move to carry over this particular amendment, and I'll get to the next one, which might be a good bit easier while they're sorting through the semantics.
Isn't you want to withdraw or carry over?
Unanimous consent request to temporarily withdraw 7A and move to 8.
You can.
You sure you want to just you want to withdraw it or carry it over?
Carry it over.
Is an objection to carrying over the amendment? Hearing none, so ordered. Clerk will publish the next amendment.
Amendment number 8 by Senator Sandman, the bill striking section 9.
Thank you. So all this particular amendment does is give law enforcement an additional 30 days before enactment, assuming that we are going to pass open carry. Law enforcement has asked that it not go into effect until 90 days after the governor signs. I think the current amendment says, or the current section of the bill says 60 days. They want an additional 30 days to get everybody trained. This is particularly important, believe it or not, for smaller departments because they have to work and they have to have...
Sergeant, clear the aisles, sir. Take your conversations outside. If we've got to stay here overnight and listen to this, we want to listen to the speaker. We want to be able to hear the speaker. Senator from Charleston.
So thank you. Basically, all we're asking for, all law enforcement is asking for is an additional 30 days so that they have 90 days to get their people up and trained. It's very, very difficult. It's going to be difficult, period, for law enforcement to know who the good guy and the bad guy is in this situation. And I can tell you, as a lawyer for police, I have defended two cases, very unfortunate, where police came to the scene and they shot. In one case, it was a guy that was in the armed services who is a video store robbery, and he thought he was the good guy, but he had the gun, and he ended up getting shot. And in another case, officers came to the scene, same thing. The man who called for assistance was the homeowner. He was holding the gun. He got shot and paralyzed. So it's very difficult for them anyway. Now they're just asking for a little bit of extra time to train on these situations. Move for adoption.
Question is, roll call has been requested. Do 5 members second the call? 5 members do. Clerk will ring the bell. Reading clerk will call the roll.
Mr. Adams. Not voting, Mr. Alexander. Aye. Mr. Allen. Not voting, Mr. Bennett. Aye. Mr. Campson. Aye. Mr. Cash. Aye. Mr. Clymer. Not voting, Mr. Corbin. No. Mr. Cromer. Aye. Mr. Davis. Aye. Mr. Fanning. Aye. Mr. Gambrell. Aye. Mr. Garrett. Aye. Mr. Goldfinch. Mr. Goldfinch not voting. Mr. Grooms. Aye. Mrs. Gustafson. Aye. Mr. Harpootlian. Aye. Mr. Hembry. Aye. Mr. Hutto. Aye. Mr. Jackson has leave. Mr. Kevin Johnson has leave. Mr. Michael Johnson. Aye. Mr. Kimbrell. Not voting. Mr. Kempson. Aye. Mr. Leatherman has leave. Mr. Loftus. Mr. Loftus votes no. Mr. Malloy. Aye. Mr. Martin. No. Mr. Massey. Aye. Mrs. Matthews. Aye. Mr. McElveen. Aye. Mr. McLeod. Aye. Mr. Peeler.
No.
No. Mr. Rankin. Aye. Mr. Rice. Aye. Mr. Sabb. Aye. Mr. Scott. Aye. Mrs. Sin. Aye. Mr. Setzler. Aye. Mrs. Shealy. Not voting, Mr. Stevens. Aye. Mr. Talley. No. Mr. Turner. No. Mr. Verdon. No. Mr. Williams. Aye. Mr. Young. Mr. Young votes aye.
All senators voted. Senator Clymer votes no. Senator Goldfinch votes aye. Senator Grooms votes no. Senator Shealy votes no. Senator Allen votes aye. Senator Adams votes aye. Senator Kimbrell votes no. If all senators voted, polls will close. Clerk will tabulate. By a vote of 32 to 11, the amendment is adopted. Clerk will publish the next amendment.
Next amendment is Amendment Number 9. Senator Kempson amends the bill, adds a new section.
Senator from Edgefield, Senator Massey, what purpose do you rise?
Briefly, but then to make a motion.
You recognize, sir.
Mr. President, I've been talking with Senator from Orangeburg. What we'd like to do, I think, is, and this will take unanimous consent, but what we'd like to do is to give the bill second reading, carry over all amendments to third reading, and waive the 3/5 rule for third reading, and then we come back tomorrow and we would start at it again. But that gets us out of here tonight. It probably does mean that we're going to be here for a good 5 hours or something tomorrow, but that may be happening anyway. So.
Is there an objection to the unanimous consent request? Hearing none, so ordered. Central.
Come in early, you want to stay at 11?
11. Central.
Time.
You want to read the box?
Yes, sir. Mr. President, I ask unanimous consent to read the box.
Is there objection? Hearing none, so ordered. Clerk will read.
Introduction of concurrent resolution by Senator Alexander. It's to recognize and celebrate June the 6th through 13th as South Carolina Boating and Fishing Week, and to commend the South Carolina Boating and Fishing Alliance on a successful start to its organization.
Senator from Oconee, what purpose do you rise?
The calendar, I have directly to the calendar. I talked to the chairman of Fish, Game, and Forestry, and just would ask that it go directly on the calendar.
Objection? So ordered. Senator from Martinsburg, Senator Tuttle.
Unanimous consent to give a local bill 771 on page 2. It's a Bamberg consolidation bill. Unanimous consent to give its second reading.
Is there objection? Hearing none, so ordered. Clerk will read.
Introduction of a bill by Senator Matthews that amends the code so as to provide that an employer may not inquire, consider, or require disclosure of the criminal record or criminal history of an applicant for employment until the applicant is selected for an interview by the employer or before a conditional offer of employment is made.
Labor, Commerce, and Industry Committee.
Further, an introduction of a bill by Senator Matthews that amends the bill so as to provide that probation officers, court personnel, county and municipal personnel, public officials, and private volunteers who participate in certain community service programs in which a probationer is completing community service as a condition of probation are not liable for civil damages.
Bill is referred to the Corrections Committee.
Introduction of concurrent resolution by Senators Goldfinch and Sabb. It's requesting the Department of Transportation name a portion of Pleasant Hill Drive in Georgetown County the A-Lane Crib Highway and direct appropriate signs and markers.
Senator from Georgetown, Senator Goldfinch, what purpose do you rise?
Mr. President, in the interest of time, that's a road naming bill for our former deceased sheriff. In the interest of time, I'd ask unanimous consent to put it on the calendar.
Objection? Hearing none, so ordered. Clerk will read.
Greenville County Delegation reported favorable reappointment of the Greenville County Master in Equity, the Honorable Charles B. Simons or Simmons Jr. of Greenville.
Senator from Spartanburg, Senator Talley, what purpose do you rise?
Mr. President, I ask unanimous consent to give that immediate consideration.
Is objection? Hearing none, so ordered. Question is confirmation. All in favor say aye. Opposed, no. The ayes have it. Confirmed.
York County Delegation reported favorable reappointment. York County Master in Equity, the Honorable Tessa K. Weaver of York.
Question is confirmation. All in favor say aye. Opposed, no. The ayes have it. Confirmed.
Message from the House, Mr. President, members of the Senate. The House respectfully informs your honorable body it's reconsidered the vote whereby they concurred in the amendments to H. 3539, a bill so as to prohibit the transportation of live swine, and they have Senate amendments and have recalled the bill and placed it on their calendar.
Received this information.
Yes, it's clear, Mr. President.
Desk is clear, Senator from Mitchfield. Senator Massey. Senator from O'Ree, Senator Hembry, what purpose do you rise?
Thank you, Mr. President. I have a unanimous consent request.
State your request, sir.
Unanimous consent that on the next available date, the Senate do adjourn in honor of Blanche McDougall Ferguson. This is the executive director of the Education Oversight Committee's mother, who was tragically killed in a car accident last Saturday night.
An objection? Hearing none, so ordered. Senator from Edgefield.
Request. I move the Senate do now adjourn.
Senator Massey moves that the Senate do now adjourn. All in favor say aye. Yes. Opposed, no. The ayes have it. Senate stands adjourned until 11 a.m. tomorrow.
All right, so that's where the bill was today. That's where they they were winding everything down. For everyone wondering where the bill is at right now, they're discussing it. They're going over it, and here's it right here. You can see. I don't know if it's too small, but right now the Senate is in the last. It's in the last leg. Okay, if it passes, it gets ratified. Then it goes to the governor, and it gets enacted. Okay, so right now we're just on that last leg here in the Senate. So again, we'll see what happens tomorrow. They're going to go over it, continue tomorrow. So I'll go and go over this again tomorrow. We'll go live again and go over it. I didn't go over it yesterday because yesterday I wasn't entirely here. So I was out running errands and whatnot. But today I had nothing going on, so that's what happens. With that, we're gonna kill it and go do whatever else is happening this evening. So I want to thank everyone for hanging out with us, commenting with us. I want to thank those here in South Carolina that were watching and commenting. Led with Steel, 803 Salad Shooter. Thanks, guys, for coming out and hanging out with us. The Greenbox Media, thank you for jumping in and hanging out with us. DM Foss. Who else? We had Mystic Guns. We had Warsaw Patriot. We had KR. We had Tyvin jump in. Armament and Axis. We had Jason Stewart. We had who else do we have that jumped in and hung out with us? Bradley Tannelhill. Who else? We had a couple people earlier. John Z. I'm going through the list. T Tiger, 8626. We had more than that. We had more people than that. We had E-Rock out there. Who else do we had? Battle Chris was out there. We had Your Local Gun Nut, 803 as well. Yep. Who else do we have? M. Gabriel was out there. Gun Websites was out there. Midnight Range was, being his normal pancake self. Artisan Tony was with us in here and out there. Who else? We had more than a couple people. Mr. FNH was with us in here and out here. So there was a bunch of individuals that hung out with us and commented today. And I want to thank everyone for being here. You didn't have to, but I'm glad you guys were. And I appreciate you guys sitting here watching it with me, giving your comments, your feedback. Because quite honestly, I'd like to get more South Carolinians that live in on a panel, so we can discuss some of the rights that are going on in our state. Because these things are important to us. So, guys, if you're out there listening, if you were listening and commenting, and you're in South Carolina, and you wouldn't mind jumping in on a panel, just go ahead and let me know. Just send me an email, nightstrike@gmail.com. That's NIGHTSTRYKE@gmail.com, and we'll try and set something up now. But regardless, thanks everyone for coming, commenting, and hanging out with me. I don't think I could have made it without you. So with that, we'll adjourn this, and we'll see you guys tomorrow. We'll try and get through it and see. Hopefully, cross my fingers. I'll do a couple Hail Marys. I'll pray, and for those that aren't religious, I will hope really, really hard that they actually get something done tomorrow. But again, as we saw, this is how government works. They argue about one bill for days and days and days, then eventually they either say yes or no. So that's how the Senate works. So, and believe it or not, this isn't just in South Carolina. This kind of thing happens all over the country in every state. So, we're not different in South Carolina. Well, we are, but, again, whatever. Thanks, guys. We'll see you later. And on that note, shall not be infringed. So, we'll see you later, guys.